Section 49 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jennifer Fournier, Sandia Park, New Mexico. American State Trials, Volume 4, by John D. Lawson. Trial of Henry B. Allison and others for larceny, Richmond, Virginia, 1851. The narrative. In the capital city of Virginia, more than half a century ago, an exhibition of Indians was held in a church, and quite a crowd of people were present. After the performance, an Indian girl was selling pictures, and among those looking on was James Mackenzie. Now, James was caution itself. He had been told to beware of pickpockets, and so he had put his purse, which contained all the money he had, in his side pocket, where he could keep his hand on it. And, for further protection, he had taken his seat in a pew. But when a small boy called out to him, "Mister, you are taller than me. Please reach up and buy me a picture," James forgot all about his treasure and thieves. He took his hand out of his pocket, took the coin from the boy, and reached out and passed it up to the girl. An instant later, when he clasped his hand on his pocket, lo, the purse had gone, and a man whom he had noticed near him was making haste to leave the church. Happily, a few days later, 3 suspicious characters were arrested by the police. They were identified as being in the church on that evening, and on one of them were found a number of bank bills, which James was able to identify as those that were in his purse. Tried for the larceny, the 3 were convicted, Allison receiving the heaviest sentence, as he was the moving spirit in the robbery scheme. On the trial, the sheriff testified that on that very morning Allison had consulted him on the advisability of his pleading guilty, whereupon his lawyer at once withdrew from the case and left the prisoner to conduct his own defense, which he did in a short speech to the jury. The Trial. In the Circuit Court of Henrico County, Richmond, Virginia, April 1851. Honorable John S. Caskey, Judge. April 21st. The grand jury had returned an indictment charging Henry B. Allison, Joseph Dowell, and John Clare jointly with stealing and carrying away, on January 31st, 1851, a number of banknotes, the property of James M. Mackenzie. There were 5 counts. In the first, the money was described as 18 banknotes of the value of $160. In the second, as 18 banknotes of the value of $159. In the third, as 3 banknotes of $20 each, amounting to $60, and 15 banknotes amounting to $100. In the fourth, as 1 banknote of $20, 1 other of $20, and 1 other of $20. In the fifth, as 3 banknotes of $20 each, 1 of $10, 7 of $10 each, 3 of $5 each, and 4 of $1 each. John B. Young, for the Commonwealth. William W. Crump, for the prisoner. The prisoners, by their counsel, announced their election to sever in their trial, and thereupon the prosecuting attorney elected to try Allison first. Henry B. Allison was sent to the bar. He was a short, thick man with remarkably broad shoulders, large eyes somewhat protruding, and a bad expression of countenance. He seemed about 40 years of age. Mr. Crump, for the defense, objected to the indictment, that it did not sufficiently describe the property alleged to be stolen. It spoke only of banknotes. It should have stated of what banks, whether incorporated or not, and whether of Virginia banks or not. Otherwise it could not be known that they were of any value. The 16th section of the Act decided the question of value by, quote, "the money due on or secured by the writing and remaining unsatisfied, or which in any event might be collected thereon." End quote. Mr. Young insisted that the property was, according to approved precedents, sufficiently described as banknotes, and that Section 16 did not refer to banknotes at all. The court overruled the objection, deciding the indictment to be sufficient. Mr. Crump then pleaded specially that he had not been properly examined by an examining court according to law. Mr. Young produced the record of the examining court. Mr. Crump demurred to the replication on 2 grounds. 1. That no certificate of the committing magistrate appeared. 2. That one of the 5 magistrates who sat in the examining court had not been summoned. Mr. Young: The warrant of the committing justice appears in the record. The certificate is no necessary part of it, is not the foundation of the examining court's authority, and need not appear. 5 justices of the city sat according to Section 4 of the Act. It did not vitiate the court that a justice sat who had not been summoned. The court overruled the demurrer, deciding that the prisoner had been properly examined. The prisoner pleaded not guilty. The following jurors were selected: E. L. Tompkins, Thomas Jones, Ballantine Winfrey, James A. Scott, George Lynch, Thomas Trowers, David A. Brown, Thomas Goolsby, John Clash, Thomas Stone, John Messler, John Pay. The evidence for the Commonwealth. James M. Mackenzie. On the night of 31st January last, I went in company with Mr. George Watt, Jr., to the African Church to witness an exhibition of Indians. By an unusual fact, I had all my money and my papers with me in my pocket. It was a cold night. We took our places in a pew some distance from the stage, where I thought I would be safe from pickpockets. Mr. Watt had warned me to guard against pickpockets, and I took my pocketbook out of my coat and put it in my pantaloons pocket, and held my hand there. After the exhibition, it was announced that the Indian girl would sell some pictures or other things at the stage. After some hesitation, I went up. There was a great crowd. I still kept my hand on my pocket. I saw the man Clare. He pressed close upon me. Mr. Crump: I object to any statements as to Clare or his conduct. No connection has been shown between him and the accused. The Court: Some such connection must be shown before the evidence would be proper. Mr. Young: Stand aside a moment, Mr. Mackenzie. Mr. Handy? Edward G. Handy: Am an officer of the police in Washington. On Saturday, 1st February last, I received a telegraphic dispatch from Mr. Mayo, prosecuting attorney in the Hastings Court, Richmond, stating that a gentleman had been robbed, giving me some description of Allison, and asking me to endeavor to apprehend him. I went to the Southern steamboat on her landing and saw the prisoner. Mr. Crump: I object. No proof has been given of any robbery or larceny. Mr. Young: I will go on then with Mr. Mackenzie. James M. Mackenzie, recalled: I held my hand on my pocketbook, in my pocket, among the crowd. A little boy handed me a 9-pence and said, "Mister, you are taller than me. Please reach up and buy me a picture." Perhaps the little boy knew that I felt an interest in youth, as I have long been engaged in teaching. Forgot my pocketbook, took my hand out and handed up the 9-pence, and got the picture for the boy. When I put my hand back, my pocketbook was gone. Recollected that just before I had felt someone pressing his hand between Mr. Watt and myself, and on turning round saw the man who had been pressing on me all the time, retreating and keeping his eye upon me. Mr. Crump: Was the prisoner present? Did you see him? I do not know that I did. Mr. Crump: The witness cannot state anything said or done by Clare. The Court: Unless the prisoner was present, or unless a conspiracy be proved to have existed among them at the time, the conduct and declarations of others cannot be given in evidence against the prisoner. Mr. Mackenzie: I lost $159 or $160. Am not positive which amount, because I had had 3 20s, 1 10, and either 7 10s and 3 5s, or 8 10s and 1 5, and either 4 or 5 $1 notes. A number of banknotes were shown to the witness. I looked at my money every day for 8 or 10 days, and became quite familiar with its appearance. One of my $20 notes had a little piece torn out of the margins, like this one. Have no doubt as to this one. Cannot swear so positively as to the rest, but I am so confident as to all, that if my salvation depended on it, and I were compelled to swear either way, I would not hesitate to say that these are the notes I lost. Cross-examined. Do not recollect distinctly what occurred before the mayor. Don't recollect being there asked as to the number of each denomination of notes. Recollect that I have stated something of the excitement and confusion attendant on the scene at the African church. Am subject to an affection of the head, which sometimes distresses me much. After it was stolen, I first saw the money again the second time I testified before the mayor. Think I gave such a description as I have mentioned to Mr. Mayo before he telegraphed, and this was before I had seen the notes after they were stolen. My account to Mr. Mayo was that there were 3 20s and 1 10 in one roll, and that the majority in the other roll were 10s. Saw the money on Wednesday after the Friday when I lost it. Sold a colored girl for whom I think I got $580. Deposited $500 in bank, and kept the balance. Think these 3 20s were part of that balance. Believe Mr. Dickinson sold the girl. This was less than a month before I lost it. As to one of these rolls, I have no more recollection of this bundle of 10s as mine than I would have of any other 10s, similar in appearance. It corresponds with mine. Edward G. Handy, recalled. Mr. Woolward went with me to the boat. Prisoner came off and went in an omnibus to the Baltimore depot, about a mile from the wharf. We followed him. At the depot, I stopped him and told him I wished him to come with me. He immediately did so. Put him in a hack with Mr. Woolward and myself. On the way, he asked what he was arrested for. Answered him that he probably knew better than we did. He asked if we could not come to some terms. Answered no. He could have no terms from me. While in the hack, I saw him take something out of his pocket and put it behind him. When we got to the mayor's office, Mr. Woolward got out first. I told the prisoner to get out. He hesitated, but finally got out. Looked behind the cushion of the hack and found a roll of money. I think $199 in all. The money which had been shown to Mr. Mackenzie was shown to the witness. I marked each note, that I might identify them thereafter. Yes, sir. All these notes were in the roll I found. Cross-examined. The telegraphic message said a gentleman had had his pocket picked at the African church, that 2 parties, supposed to be guilty, had been arrested, that another had escaped. Described as a short, stout man, with head somewhat bald. Think the amount was stated. Did not know that 2 gentlemen had been robbed, or I would have kept the rolls separate. James F. Woolward. Am a police officer. My statement will be pretty much Mr. Handy's, with the addition that I took some $25 or $30 more from the prisoner, with a pocketbook. Here the pocketbook and money were shown and identified. The pocketbook, among other papers, contained Park Benjamin's poem, To My Mother, apparently cut from a newspaper. Peter Wren. Am employed at the Columbian Hotel. Prisoner arrived there by the southern cars on 28th January and left 1st February by the northern cars. On 19th December 1850, he arrived at the hotel in company with Dowell, and on the 15th January, Allison, Clare, and Dowell all arrived there together. James M. Sublet. Prisoner came to the Columbian on 19th December, in company with Dowell. They paid their bills and went away. On 15th January, Allison, Dowell, and Clare all came together. They asked for separate rooms on each occasion, but the last time we were crowded and I put them all in the same room. They did not seem to have any business. They did not often speak to each other, though I could perceive they were acquainted. On 28th January, Allison came alone and got a single room. On the 29th, Clare and Dowell came together. The last 2 stayed until they were arrested, 31st January. Allison left 1st February, without having given notice of his intention to leave, although we have notices put up in every room that guests intending to leave early in the morning may have early breakfast by giving notice the night before. Cross-examined. They stayed more than a week, from 15th January. We presented their bills at the end of a week, and they paid them. Never saw them in the street. No one came to see them or asked for them, but that was not altogether unusual. Saw nothing in their conduct disorderly or other than respectable. They did not stay much together, but sometimes in passing exchanged some words. Think they all left together after the 15th January? As a general thing, passengers give notice who are going by the northern cars. Allison seemed hurried because he had not more than 15 or 20 minutes to get off. Each had a carpetbag. I was present when their carpetbags were opened. Besides apparel, they had nothing except blacking brushes and razors. George Watt, Jr. Am pretty positive that I saw the prisoner at the exhibition in the African church the night of the 31st January. Went with Mr. Mackenzie. There was a great crowd. Cautioned him to take care of his pocketbook. After the exhibition, they offered some pictures for sale. 2 or 3 of us went up to the stage. While there was a considerable pressure on me. I was standing against the platform, and the pressure became painful. Asked Mackenzie, "Why this pressure?" Saw 2 men who were pressing on Mackenzie, as I thought, without necessity, and looking at them, I asked them to desist. They put on a sort of daring, insignificant grin, and still pressed. Threw myself forward to relieve myself from the painful posture in which I was, and succeeded. Immediately afterwards, I heard a sort of a scuffle, and looking round, saw Mackenzie, with his arm raised, reaching out as if to seize some body. Mr. Crump. I object to any statement as to Clare and Dowell. Mr. Young. Mr. Watt, did you see the prisoner? Mr. Watt. I believe I did see the prisoner that night, but I can't locate him. George Sublett. Was at the African church that night. At the time of the pressure, was about 3 feet from Mr. Mackenzie. Saw no necessity for a pressure. My arm was in a sling from a hurt, and I avoided the crowd. As I was advancing, I met a man pressing towards me, elbowing his way, when there was no need for it. I stood aside and made way for him. The man was not tall, not as tall as I am, but broad and stout. I was struck by his appearance, and when afterwards I saw Allison in the mayor's court, believed it was the same man. Cross-examined. Am sometimes at the Columbian, but not at mealtimes. Never saw the prisoner there. The man had not gotten out of the church before I heard Mr. Mackenzie cry out he was robbed. Did not see the man's face or the color of his hair. Think he had a hat on. Never recognized him except by his broad shoulders. Was with a lady, and when the confusion commenced she was very much alarmed, and begged me to leave with her. Got up on a bench and stayed about 5 minutes. There was much confusion, and propositions to search were made. Did not see any little boys in the aisle, nor did I see Dowell or Clare. Think I first mentioned the matter to my brother that night or next morning. Mr. Young. I think we have now in the case evidence tending to prove a connection of the prisoner with this affair at the church. The court. You can go on, sir. Mackenzie, recalled. I turned, and Clare was retreating and watching me, in this way. Here the position was shown. I reached out after him. I was so eager that my hand fell down by his head, crushing his hat, and I seized his collar. I said, "You have got my pocketbook." He said, "I haven't." I said, "You took it." After a moment, he said, "Search me." Mr. Crump. These statements are not evidence. It is not pretended that Allison was then present, and they cannot be given in evidence on the ground of conspiracy because, even if any conspiracy existed, its object had been accomplished the moment of the theft, and the conspiracy had ceased. The statements of one conspirator, made after the conspiracy is ended, are not evidence against another conspirator. The court said Mr. Mackenzie might state any facts connected with the Lawson search, but not declarations of Clare or Dowell. Mackenzie. I searched him, but did not find my pocketbook, and did not expect to find it. I searched both Dowell and Clare at the church, and did not find any of my property upon either of them. I had on a pair of homemade pantaloons, which were very sparing in everything and had very shallow pockets. George Watt, Jr., recalled. Seeing him catch Clare, I caught hold of the other man that I had seen pressing upon Mr. Mackenzie. As soon as possible, I went to the cage and got Captain Jenkins and the police to arrest them. When Allison was brought back here to the jail, I went and asked the jailer to let me see him. And the moment I saw him, I recognized him as a man I had seen at the church. I have a peculiar faculty for remembering faces. Cross-examined. There were very few persons immediately around the stage. These two persons were the only ones crowding on Mackenzie. No one was crowding on them. The nearest persons I saw to them were some boys. Clare had on a cloak and was in a leaning position when I saw him. P.P. Winston. Sheriff. This morning, when I was walking around by him, Allison asked me what I thought he had better do. He said he thought they would convict him and let the others off. He said he received the money from the man whom Mr. Mackenzie seized at the church. He asked me if I thought he had better plead guilty. I told him I thought, as he had stood so far, he had best plead not guilty. He said he had been advised not to plead by his counsel. Mr. Crump stated that he considered his office and his duty as ended. As the prisoner had thought proper to take his case into his own hands, he considered himself no longer bound to act as his counsel and should leave him to the jury. Mr. Young submitted the case without argument. The prisoner addressed the jury, saying he was not concerned in the matter, that he was not at the church, that the money was handed to him by a man named Humphreys, and that he was innocent. The jury retired, and in a short time returned with a verdict of guilty. April 22nd. Dowell and Clare were tried on the same indictment. Their trial was to a great extent a repetition of the evidence above given. They were convicted. April 25th. The judge pronounced sentence on the three prisoners. The circumstances of Allison's case, he said, had furnished one more proof how often the very fruits of crime are turned to gall and wormwood upon the lips of the criminal. Allison had escaped with the money, while his accomplices were instantly arrested. To others' eyes and to his own, he perhaps seemed the most fortunate. Yet the result had been that his prey was the means of his conviction, and so his punishment would be more severe than that of his comrades in crime. The sentence of the court was that Dowell and Clare should be confined in the penitentiary for the term of 4 years, and Allison for the term of 5 years. End of section 49.
Section 50 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Karen Smith. American State Trials, Volume 4, by John D. Lawson, Section 50. The trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869. The narrative. There had been a heavy fall of snow in the city of Newark, New Jersey, and on each side of a fashionable residence street just after breakfast, men and boys were shoveling the snow from the sidewalks. A prominent house was that of Dr. Lafon, a popular physician, and his young son Joe, a boy of 15, was at work in his front yard, varying his labors with throwing snowballs at the other boys across the street who were similarly engaged. A butcher boy drove by in his master's wagon, and in sport Joe threw some snow at him. The butcher boy resented this act and called out to Joe that if he did that again, he would punch his head. Joe dared him. The boy jumped down, and in a moment the two youngsters were both down on the sidewalk, pummeling each other in an earnest struggle. The butcher boy on top and getting the best of it, as he was bigger and stronger than his antagonist. Standing at the window of his father's house, Tommy Lafon, an older brother, saw the fight and ran out of the house, picked up the shovel from the sidewalk, and struck the butcher boy several times. One blow fell on his head. There was a question whether he used the blade or the handle of the shovel, and whether the blow was not aimed at the back and only fell on the head because of an unexpected movement of the boy. The result, however, was the death of the boy. It was not charged that there was any intention to kill, and the indictment was for manslaughter and not murder. The court ruled that defense of one's brother was not a justification and that the defendant might be found guilty. An unfortunate incident was made much of at the trial and doubtless influenced the verdict. When the bystanders picked up the senseless butcher boy and attempted to take him into the doctor's home, they were met at the front door by Mrs. Lafon, who refused to let him be brought in and told them to take him to the basement. This caused the case to take on the aspect of an issue between classes, the rich against the poor, and the working men of the city demanded the punishment of the rich man's son. Two of the most eminent lawyers of this state, Joseph P. Bradley, afterwards an Associate Justice of the Supreme Court of the United States, and Cortland Parker were retained to defend him. And when the trial came on, the courthouse was packed, the front rows of seats being occupied by scores of ladies of the highest circles in society, while the rear was crowded to suffocation by the representatives of the working classes. The jury brought in a verdict of manslaughter, for which he was sentenced to imprisonment for a year. All the evidence was to the effect that Tommy Lafon was a thoroughly good-natured young man, and that his action in striking the victim was simply an impulse of the moment. He was pardoned after a few months' imprisonment and lived and died an honorable citizen. Footnote 1. Footnote 1. 37 New Jersey, L. J. 220-286. In the summing up of counsel at the conclusion of the trial, Mr. Bradley fairly surpassed himself for his stringent review of the testimony and his masterly eloquence. Toward the close of his address, however, he appeared to be overcome with emotion, and a thrill of excitement ran through all of the front rows of spectators at his stammering words as he appealed to the jury not to inflict upon this young defendant their con. He could go no further, but dropped helplessly into his chair and dropped his face upon his arms, outspread upon the table. It was an exciting scene. Nobody appreciated it better than his associate counsel, Mr. Parker. But Mr. Parker attributed the thrilling emotion to a different cause from that of the other spectators, and he watched Mr. Bradley with a mixture of whimsicality and curiosity. His expectations were finally fulfilled, as Bradley raised his head and muttered half to himself and half to Parker, "Condemnation. That's the word I wanted." Reminiscences of William Nelson. The trial. Footnote 2. Footnote 2. Bibliography. Trial of Thomas Lafon, Jr. for manslaughter in the Essex, Oyer, and Terminer, February 8th to 11th, 1869. Evidence printed from the notes of Samuel Johnson, the court stenographer. Newark, New Jersey, Daily Journal Steam Print, 1869. In the Court of Oyer and Terminer of Essex County, Newark, New Jersey, February 1869. Judges, Honorable David A. Depew, footnote 3, Honorable William B. Guild, footnote 4. Footnote 3. Depew, David Ayres, 1826-1902. Born Mount Bethel, Pennsylvania, graduated Princeton, 1846. Studied law with John Maxwell Sherrod, Belvedere, New Jersey, and admitted to New Jersey Bar, 1849. Practiced law at Belvedere, an Associate Justice of the Supreme Court of New Jersey, 1866 through 1900. Chief Justice of New Jersey, 1900. His knowledge of the law was profound, and he was seldom overruled. In purity of life and strength of character, he made a lasting impress on the bar and bench of the state. Footnote 4. Guild, William B., 1806, 1888. Born Clinton, New Jersey. In early life was miller and merchant at Hackettstown, New Jersey. Then, 1836, opened dry goods store in Newark. Sometime in the 60s, he became manager of the Evening Journal of Newark and later sole proprietor. Under his management, it became the strongest Democratic newspaper in New Jersey. About 1868, he was appointed lay judge of the Essex Common Pleas and held the office 2 terms. February 8th. The indictment, which had been previously found by the grand jury of the county, charged that Thomas Lafon, Jr. did on the 5th day of December, 1868, in the city of Newark, inflict certain wounds on the head of one Joseph Hebring, from the effects of which he died on the 11th day of December. The prisoner pleaded not guilty. C.S. Titsworth, footnote 5, prosecutor of the pleas for the state. Footnote 5. Titsworth, Caleb S., 1826, 1886. Born Metuchen, New Jersey. Graduated Union College, 1850. Read law with John T. Nixon, U.S. District Court Judge, New Jersey, and Chancellor Theodore Runyon, and was admitted to practice 1855. Prosecutor of the Pleas of Essex County, New Jersey, 1867. Presiding Judge of Essex Common Pleas, 1874 through 1879. A man of great ability and one of the first members of the Republican Party in New Jersey. T.P. Rainey, footnote 6, Cortland Parker, footnote 7, and Joseph P. Bradley, footnote 8, for the prisoner. Footnote 6. Rainey, Timothy P., 1829, 1874. Born Granville, Massachusetts. Graduated Amherst, 1851. Studied law in Newark, New Jersey. Was admitted to the New Jersey Bar, 1854, and practiced at Newark until his death. For a time a partner of Joseph P. Bradley, a lawyer of marked ability. Footnote 7. Parker Cortland, 1818-1907. Born Perth Amboy, New Jersey. Graduated Rutgers College, 1836. Studied law with Theodore Frelinghuysen and Amzie Armstrong at Newark, New Jersey. Became the most eminent lawyer of New Jersey in his day and was one of the active founders of the Republican Party in the state. Prosecutor of the Pleas of Essex County, 1857 through 1867. President Grant requested him to act as one of the judges in settling the Alabama claims. President Hayes offered him the ministry to Russia and President Arthur that to Austria. But he declined all these and similar honors in order to remain at the bar. In 1876, at the presidential election, he accepted the duty of being witness to the counting of ballots in Louisiana. He was president of the American Bar Association, 1883, and received the degree of LL.D. from Rutgers College and Princeton University in the same year. As an orator and writer, he was equally as prominent as at the bar. Footnote 8. Bradley, Joseph Philo, 1813-1892. Born Berne, New York. Graduated Rutgers College, 1836. pursuing his studies while conducting an academy at Millstone, New Jersey, studied law with Archer Gifford of Newark, New Jersey, and was admitted to practice 1839. Practiced at Newark and soon became counsel for the old Camden and Amboy Railroad. Associate Justice, Supreme Court of the United States, 1870 through 1892. Was a member of the Electoral Commission of 1877, which seated President Hayes over Samuel J. Tilden. In legal learning, he had few equals, and the extent of his knowledge in literature, science, art, history, and antiquity and biblical learning appeared to be as extensive as his knowledge of the law. He married the daughter of Chief Justice Joseph C. Hornblower of New Jersey. C1 AM ST TR 725. The jury having been impaneled and sworn, Mr. Titsworth opened the case, narrating the evidence that the witnesses to be called were expected to give. The witnesses for the state: Agatha Hebring, live number 112 South Orange Avenue, Newark. My husband is Stephen Hebring. My son, Joseph Hebring, died on 11th December last. He was brought home on Saturday morning, 5th, between 10 and 11 by Dr. Daugherty and Mr. Lafon, the defendant. The doctor on one side and Mr. Lafon on the other side of him. The doctor knocked at the door. I opened the door, and the doctor says, "Is this your boy?" I said, "Yes." Asked him what was the matter. He did not make an answer right away. He said there had been a little scuffle. Have the bed made and put him to bed as soon as possible, and have bricks put to his feet. He was very cold. Did everything the doctor told me. He remained about half an hour till I got hot irons. The doctor put them on his feet himself. When we was in the kitchen, Thomas Lafon asked how many children I had. That was all he said to me. Me and my daughter, my oldest, attended to my son. From the time I put him to bed at 11 till 1, he never opened his eyes nor spoke. About 1, his feet was warm, and he opened his eyes. I said to him, "What have you been doing?" During the night he wanted to drink, and said his head was dreadful sore. He was not able to sit up. He could not help himself more than a tiny baby. He was conscious all the time till 9 o'clock on the morning he died. He was 18 years and 9 months old when he died. My husband was not in when they brought my son home. No one but myself and my little children. My husband is a saddle maker and works for George Peters. My son was working for Mr. Bathgate, the butcher, since about a year. He was a strong, hardy boy before this occurrence. Never sick at all. Dr. Alexander N. Daugherty was called to see the lad Hebring about 10 a.m. of 5th December in the market house in Mr. Bathgate's room, lying down upon a lounge. His condition was very feeble, with blood running from his left ear. There was a mark of a bruise about 2 inches above the ear on the left side of the head. Thought he was very seriously hurt and wanted him taken to his house. Lafon came with a carriage, and we took him home. He was very unsteady, had vertigo, and could not stand. Dr. Bromley and myself treated him. The cause of his death was inflammation of the membranes of the brain, the result of fracture of the skull. There was a post-mortem examination by Dr. Lilabach. I assisted. So did Dr. Bromley. It was held the day after his death. The skull was fractured. I produce a skull. The fracture went through the solid part of the temple bone. He spoke and continued to be sensible until the day before he died. Was conscious all the time till then. Prisoner went with me to the house. He said to me, "I know you will think it is a beastly thing, or a brutal thing to do. I saw him on my little brother, and I went to get him off. Am not positive he said he used this shovel or not. Thomas Lafon and I stayed at Hebring's house about an hour to get the boy in bed and warm. Did not hear Thomas Lafon say anything to the family. He came back with me. Hebring's mother asked what was the matter. I put her off, said he had met with an accident. Cross-examined. When Thomas made the remark to me, he might have said something expressing surprise that any particular injury had been done, but I don't remember distinctly. He appeared very sorry for the result and apprehensive. Gave to him to understand the injury was serious. Don't recollect that he said to me that he had no idea of doing the boy any harm. Thomas Lafon did all he could to aid me. We carried him in a carriage, a covered wagon, a sort of cab hired for the occasion. One horse, young Hebring, was sitting up. I supported him on the seat with me. Under the place where I found the bruise, the bone was fractured. The skull where the fracture began is a thin portion of the skull. There is no thinner part of the skull than that point where the two pieces of the head join. Deceased's skull at that particular point was thinner than the skull there generally is. There was a bruise there, no cut. A blunt instrument, in my judgment, caused the bruise. Don't remember seeing any other injury outside, though he complained of injury to his arm. Dr. Charles F.J. Lilabach. Am the county physician. I held the post-mortem examination on the body of Joseph Hebring. Dr. Daughtery and Dr. Bromley assisted me. The cause of his death was inflammation of the brain resulting from fracture of the skull at the templar bone. It ran from near the junction of the table and the parietal bone right down, and then through the membranes of the ear. We looked for external bruises on the body but did not find any. Our first examination was at the head. When we became satisfied that was the cause of the death, we did not particularly look further. Think we opened the chest. There could be no hope of recovery, I think, under such a fracture of the skull. Cross-examined. The fracture began at the junction of the parietal and temple bone. The outer plate of the temple bone was splintered off. Thought I could see some abrasion. The absence of any external abrasion would indicate that the blow was struck with a dull instrument. The thickness of the skull was a little below the average of persons of that age. Up to a certain age, they increase a little in thickness, but not much after 21 years. They increase not so much in thickness, but in firmness, in strength. Sarah W. Crowell. Live at number 9 Cedar Street. My house is very nearly opposite Dr. Lafon's house. On the morning of 5th December was on my stoop. Saw only part of the occurrence between Thomas Lafon and the Hebring boy. Had been to market and had just returned. Saw no part of it until I got to my stoop. First saw Thomas Lafon striking the boy Hebring with a shovel. Think it was a coal shovel or a snow shovel, a shovel like that now produced. Seemed to me it was the iron part of the shovel that he struck Hebring with. He appeared to hold the shovel with both hands. Saw him strike him 3 times. It was near the head where he struck him. The blows were in quick succession. As to force, they seemed hard. Their effect upon Hebring was he groaned very much. Did not see Thomas Lafon get the shovel. When he had struck the 3 blows, he went up to his father's steps. Don't know what he did with the shovel. When he struck the blows, he was standing near the boy. The boy was lying on the walk, near the area gate. His head was by the gate and his feet towards the curb. When Thomas Lafon left after giving the blows, the boy attempted to rise, but was not able. He staggered and sunk again. He tried a second time to rise and sank again. He was groaning considerably. put his hand up to his head and made a considerable noise. Saw no blood from my stoop. I went into one of my neighbors, Mrs. Matthews, on the opposite side of the street, next door to Dr. Lafon's. The Hebring boy, when I crossed, was still on the walk. Saw Stickles, the boy who was shoveling my walk, take hold of him to help him into Dr. Lafon's. There was another person helping him, but who it was I don't know. They took Hebring as far as Dr. Lafon's stoop. Then I went into the next door, was not but a few minutes between the time of Thomas Lafon leaving the boy after striking him and the taking of him by the two men to Dr. Lafon's stoop. It seemed very quick, the whole of it. Did not see the boy after he was taken to Dr. Lafon's stoop. Saw no blood upon the sidewalk. I stood upon my stoop during the occurrence and went across the street afterward. Told the boy that was cleaning my sidewalk to go over and help him. Thomas Lafon was then in his father's house. The boy called for Mr. Bathgate. Thomas Lafon did not say anything, did not hear a word from him. Cross-examined. Had just come from the market. The first thing I saw was the shovel in the air. Use spectacles for sewing and reading the newspapers, but never in the street. Am not what is called a nearsighted person. The blows seemed quick. The whole transaction was very quick. Do not feel as if I could be at all sure how the spade was held. Think the iron part was used. Cannot say what part of the shovel struck the boy. It seemed to be sideways that Thomas Lafon was standing with respect to me. They were very close together. Did not notice anyone lying on the sidewalk but this boy. Julia Woodruff. Live number 17 Cedar Street. My husband is John C. Woodruff. On morning of 5th December was in front of my house when the groans of the first boy attracted my attention. Next saw the boy lying on the walk, saw him attempt to rise but unable to do so. When I first saw Hebring, he was lying on the walk in front of the area gate before Dr. Lafon's house. Saw the last blow given. It was on the head. Before I heard the groans, saw the boy raise his head. Think it would have been given on the back if he had not raised his head and turned it. After the blow was given, saw Thomas Lafon take the shovel from the walk and enter the house. Think he struck Hebring boy with the blade part of the shovel. Don't know how he held the shovel, whether with one or both hands. The left side of the head was struck, above the ear. After Thomas Lafon went into the house, saw the boy lay there on the walk 5 minutes. He appeared to be suffering, groaned and called for help. Saw the younger Lafon on the sidewalk, while Hebring lay there. Did not see him before the blow was struck. Thomas's back was towards me. He stood on the left side of Hebring. It was Thomas Lafon gave the blow. After the blow, saw the blood streaming from the boy's ears. Stood on the sidewalk a moment until I saw him taken into the house. Then I went back to my house. Thought I might assist him in getting up, but found he was larger than I thought, and I could not. 2 others came to assist him, and took him into Dr. Lafon's house, up the front stoop. They did not get in there. He was brought down again and taken into the basement. He was brought out again in about 10 minutes by Dr. Dennis and Thomas Lafon. They put him on the wagon that had been sent from the market. Cross-examined. Don't remember seeing Joseph Lafon lying on the sidewalk at all. The first I remember was the last blow given. Saw the shovel hit the head. Afterwards, Thomas Lafon seemed very much excited and pale. Re-examined. Saw Thomas Lafon after he had thrown the shovel down and went into the house and returned. Noticed he seemed excited. Saw Joseph Lafon standing on the walk. He had picked up the shovel and attempted to throw the snow from the walk, the same shovel that Thomas Lafon had used. The shovel produced is like the one used. A boy who had been shoveling snow from the sidewalk in the street, and another person I don't know, took the Hebring boy into the house. Maria McCormick. live 140 Washington Street, was coming through Cedar Street on morning of 5th December about 9:30 on the same side as Dr. Lafon's house. As I turned Halsey Street, the butcher boy sat on the wagon, and angry words were passed between him and the doctor's boy. Did not hear what the doctor's boy had said. The butcher boy made use of an oath and said, "I will show you," jumped out of the wagon, came on the sidewalk, and ran down to the doctor's boy who stood 2 or 3 steps in the street. As soon as they came together, they gave about blow for blow till they fell across the sidewalk with their feet in the gutter. The butcher boy came on top of the doctor's boy and commenced to pound him. Did not see the doctor's boy use either hand or feet. The elder boy then rushed out of the house with slippers on and bareheaded, ran across the walk, picked up the shovel, and struck him 2 blows in the back. The butcher boy then turned his head to the left and raised partly up. The 3rd blow struck him on the left side of the head. After he struck the last blow, he dropped the shovel immediately and turned to go up his father's stoop. Noticed him looking very pale, saw the blood come from the ear of the butcher boy, and heard his groans. Was very near when the blows were given. Don't think I was 6 feet from them when the last blow was struck. Some part of the sidewalk was cleaned and some was not. Don't know whether it was snowing then. Thomas Lafon was standing with his back towards me when the blows were struck. Did not see his face, only when he came out of the house. When he struck the butcher boy, he stood with his face towards Broad Street. Did not see Joseph Lafon. The butcher boy seemed to have complete power over him. Saw Thomas Lafon on the stoop and Hebring lying on the sidewalk, and Joseph Lafon at the side of him. Both their caps fell off, and they were 2 or 3 steps in the street when Joseph Lafon and the butcher boy exchanged blow for blow. Did not hear a word between Thomas and the boy. There was words between the butcher boy and Joseph. Did not hear what Joseph said. Hebring made use of an oath and said, "I will show you." Think he said, "Damn you." Don't know what they had been doing before that. I think Joseph Lafon had been shoveling snow from the gutter. All 3 blows seemed to be quite hard. Thomas Lafon struck him with the handle, the end that has got the hole in it. It was a shovel like the one produced. He took hold of the shovel with both hands and struck with the flat part of the handle. Cross-examined. I saw all 3 blows. Did not notice the first blow occasioned any change in the butcher's position. When the second blow was given, he still continued to pound the doctor's boy. The butcher boy turned around and raised himself up partially, but did not raise up on his feet. His object seemed to be to see who was striking him. This action brought him into the way of the 3rd blow, changed his position, and brought the blow on his head. The boy Hebring was about the size of the doctor's eldest boy, except stouter, a well-knit, strong young man, stronger than the doctor's young boy. When they fell, Joseph Lafon was on his back and underneath. Think Joseph's hands were held by the butcher boy. The sidewalk and gutter were wet. Think it was snowing a little. My husband is a grocer. The butcher boy turned his head towards me to see who was striking him. The blows were given as quick as one blow could follow another. Hannah Searing, live at 11 Cedar Street. My house is next to Mr. Crowell's. Our stoops adjoin. Saw part of the occurrence from the 2nd-story front window. The first thing I saw was the Hebring boy and Joseph Lafon struggling together near the curbstone. The Hebring boy seemed to be trying to throw Joseph, and Joseph seemed to be trying to get away. Saw no blows. They had hold of each other. The Hebring boy seemed to have his arms round Joe. Don't know whether Joe had his arms round the butcher boy. The Hebring boy succeeded in throwing Joe on the sidewalk, on his back, and the boy was on the top of him, and pounding him about the head and neck. Thomas came to the window and looked out and saw them, and instantly came out and took up the shovel on his way to the boys, and struck the blows. Saw him strike 3 blows. Don't think the blows hurt him enough to do him any harm if one of them had not struck him on the head. They were not very hard blows, though in quick succession. Think the Hebring boy was struck with the blade, but will not be positive. Saw the shovel raised 3 times in the air. The window I looked through was closed. Heard the boy scream after the blows. When Thomas has struck the blows with the shovel, he went into the house, throwing the shovel down. Saw blood coming from the Hebring boy's ear. They carried him up the stoop of Dr. Lafon's, perhaps a step or 2, then carried him into the basement. A boy that was shoveling snow helped him. Think Thomas Lafon helped him, but cannot say. Hebring boy made 2 or 3 efforts to get up, but fell back. He was in the basement 10 or 15 minutes. Thomas Lafon and Dr. Dennis helped him in the wagon. Cross-examined. Think I saw Thomas at the window before he came out, but may be mistaken. Had never seen him before. Did not notice he was bareheaded. The first 2 strokes fell on the back. There was a change in the position of the Hebring boy between the second and third stroke. He raised and changed the position of his head, seemed to put his head in the way of the shovel. That raising of the Hebring boy seemed to be the first notice he had taken of anyone interfering. Did not go out myself to help them. Did not think the boy was hurt. As I went on looking, saw him make attempts to rise, and he fell back. Thought he was pretending a little. Saw the blood coming from his ear. Did not know but what it might be a little cut. End of section 50.
Section 51 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 2. Charlotte Condit. My father's name is C. Harrison Condit. I'm 13 years old. Our house is the last house in Cedar Street on the same side as Dr. Lafon's. Was in the street on the morning of this occurrence, in front of the stoop next to Dr. Lafon's, in front of Mrs. Matthews. Saw Joseph Lafon shoveling snow off the walk. There were several boys shoveling snow. Saw the Hebring boy coming on the wagon from Broad Street. As the boy was passing, Joseph was throwing snow from the gutter and threw a shovelful against the side of the wagon, and there were some words. Don't know what they were. The Hebring boy dared him to do it again, challenged him to throw snow against the side of the wagon, and Joseph said, "Very well." Do not recollect what more was said. The Hebring boy swore at him when Joseph threw the snow on the wagon. Don't know what he said. Hebring dared him to throw more snow on the wagon, or to do it again. Joseph said he would dare to do it again. He did dare to do it again. The boy jumped off the wagon and ran back to the place where Joseph was standing. Don't remember hearing any words, but they commenced to strike each other with their fists and clenched and rolled over onto the sidewalk. The Hebring boy struck Joseph about the head and shoulders. Don't know that Joe did. Did not see him use his hands at all after he was down. Saw Thomas Lafon in the window. And when he saw the 2 boys rolling on the sidewalk, saw him come down the steps. He picked up the shovel and struck the boy 2 blows on the back. Then as he was lifting himself up, Thomas struck him another blow, which hit his head. The boy was on his knees on the sidewalk when the first 2 blows were struck. When the last blow was given, it seemed to me he was looking up to see who was striking him. The blows appeared to be heavy blows. Could not tell which part of the shovel he struck with, or which end. The blows came in quick succession. After he struck the blows, he went up on the steps of his father's house. Joseph Lafon got up and stood there. Don't remember his doing anything but that. Joseph Hebring lay on the sidewalk, put his left hand up to his head, and groaned, and then laid his head down on the sidewalk. Did not see him make an effort to get up. He groaned, did not see the blood coming out of his ear. Saw the blood on the sidewalk afterwards. Had been playing with Joseph in the snow on the sidewalk. Thomas was at the window a few minutes before Joseph and the boy commenced to strike each other, and was at the window as they fell over on the sidewalk.
Don't know whether he was at the window when Joseph threw the snow, but think he was. Cross-examined, it was a white-covered wagon, such as is usually driven by butchers. Did not see Hebring's boy until he got off the wagon. Dr. Laban Dennis. Live next door to Dr. Lafon's. Am connected in business with Dr. Lafon. Was in my boarding house at the time of the occurrence spoken of. In the second-story front. Saw Joseph Lafon struggling with some boy in the street. Both were standing and scuffling. Thought it was a little boy's quarrel. I turned away and saw nothing more of the blows struck. Next, saw the head and shoulders of Thomas Lafon as he was apparently standing near the edge of the curb. Saw the handle of the shovel come over 3 times in the air. Did not see where the blows struck. The object aimed at was hid from my view. The blows came from the right shoulder of Thomas Lafon. This part of the shovel impressed itself on my mind. The handle end. Did not hear the blows. Heard the cry of the Hebring boy and saw him standing on the sidewalk and bleeding. Hastened down as it seemed worse than I had thought. Suppose Thomas was striking the Hebring boy on the back. From the character of the instrument and my previous knowledge of the boy, found he was carried down into the basement to ascertain the nature of his injuries. Dr. Lafon was not at home. Joseph Hebring was sitting in a chair in the basement. I examined him, discovered no wound, was told blood had come from the ear. He was conscious and answered my questions as to where he lived, and seemed to be merely suffering from the pain. He moaned. From that circumstance alone, blood coming from the ear, thought it was serious, but from his consciousness did not think it was great. He made attempts to vomit. In a few minutes, Bathgate's man came in and I told him to bring a wagon immediately and take him home. Went to prepare medicine for him, and while doing this, the boy had been taken out and was sitting in the wagon, leaning slightly forward, between the man and Thomas Lafon. Did not help him into the wagon. Saw him at his house afterwards, but not again that morning. Cross-examined. The street there is very narrow, not more than 30 feet, was on the same side of the street that the occurrence happened on. Unless I put my head out of the window, could not see at all. Did not stand close to the window because it did not impress me. Saw Thomas Lafon's head and shoulders. He was in the basement when I got down. A dining room 6 steps below the street to the level of the basement floor. Would be the least effort for the Hebring boy to go down than up. He was sitting in a chair in the basement. Mrs. Lafon, Thomas Lafon, Joseph, a servant girl or 2, were down there, completing that operation of washing his face. Did not hear any suggestion of Hebring going to Mr. Bathgate's. Suggested the getting of the wagon. Bathgate's man had come in, went to prepare medicine. When I got to the basement, they were in the wagon in the front street. The steps down into the basement are rather narrow. 3 men could not conveniently walk side by side to the basement. The steps to the front door are wider. Saw Thomas Lafon in the presence of Hebring immediately after the occurrence. My impression is Thomas said, "Here's a boy badly hurt." Chilean Stickles. Shall be 21 next March. Was in Cedar Street on 5th December. Was cleaning the pavement next house to Dr. Lafon's. Saw the youngest Lafon fire snowballs at Hebring, or snow, don't know whether it was made into a snowball or not, in the opening of the wagon. Hebring told him to stop or he would make him. Young Lafon said he could not do it and fired again and struck the horse on the hip. When he had struck the horse, Hebring drove to the corner of Halsey Street and came back again and asked Lafon what he meant by firing snowballs when he told him to stop. He gave him an answer not very proper. He said it was none of his damned business. They clinched round the neck and tried to throw one another, and slipped, and Lafon fell under. Hebring did not trip him. Hebring commenced to punch him on the shoulder. Young Lafon asked him to let him up. Hebring asked him if he would fire any more snowballs. He said he would. After punching him once or twice more in the shoulder, and as he was getting up, the elder Lafon ran off his father's stoop and picked up the shovel from the side of the boys. I saw one blow, and he fell from the effects of the blow. Then I went across the street to Mrs. Woodruff's. Her house is on the other side, and told her I would be over in a little while to clean the walk. They asked what was going on. I said they had been fighting, and they asked me why I did not go over and pick the boy up. Went across and helped to pick him up. Someone helped me. Don't know who it was. Took him up to the front stoop. Mrs. Lafon told me not to fetch him up there. She did not want the blood. We brought him to the basement steps and took him down, and young Lafon and a servant girl took him in. Went across the street again and went on shoveling. When the butcher boy was struck by Thomas Lafon, could not exactly tell the distance. I was standing from then. Saw one blow certainly, and the butcher boy fell. The blow hit him on the head on the left side. It seemed to be a hard blow. Saw the blood on the side of his face. He made several efforts to get up and was not able to. After Thomas Lafon struck him, he went into the house directly. After striking the boy, did not hear him say anything. He went up on the stoop immediately and disappeared. Don't know how long Hebring stayed on the sidewalk before we took him into the basement. Time enough to go to the market and back. Had seen the butcher boy at Bathgate stand. Had no other acquaintance with him. He was about the same size as Joseph Lafon, perhaps an inch smaller or taller, not much stouter. Cross-examined. Am a house painter. When I can get it. Have had no work steady this winter. Have been to Trenton on the Camden and Amboy Road. Before that, took a job wherever I could get it. Have been employed by liverymen. Was shoveling snow. I lay my hand to what I can lay it to. Was sworn before the coroner's jury. The butcher boy had his head over young Lafon and was straightening himself up when he was struck. The thing at first did not much attract my attention. Could not help but hear them, and did not look to see them. After the butcher boy asked him what he meant, he clinched him. The butcher boy did not strike young Lafon before he asked him. Before the coroner, I said that the butcher boy drove up to the corner of Cedar and Halsey and stopped, and then got out of the wagon and came to ask young Lafon and asked him what he meant, and he told him it was none of his damn business, and that the butcher boy drew off and struck him on the shoulder. Did not say he struck him at the side of the head. Can write my name, cannot read well. After they clinched, the butcher boy gave blows. Did not see young Lafon give blows. His hands were free to do it. Young Lafon was under when they fell. Hebring was on the top, breast for breast. Immediately after they fell, he raised himself. He was partly supporting himself by his hands, and with his right hand he was punching Lafon. Saw Hebring give 3 or 4 blows with his fist. Saw Thomas Lafon come from the stoop. The butcher boy was just getting up. He had stopped striking him entirely. The butcher boy was very nearly erect when the blow struck him. Cannot say which end of the shovel struck the butcher boy, whether the iron or wooden part of the shovel. Robert William Talmage. Am in the employ of M. Osborne. Confectioner. Was in Cedar Street on the morning of 5th December. Had a team with me, driving it. First saw Dr. Lafon's son cleaning the sidewalk. Hebring called out to me, and I called out to him to give room. Just this side of Dentist Colburn's. Passed him before he got to Dr. Lafon's. Colburn's house is the first house. After I passed Hebring's wagon, a loud talk attracted my attention, between Dr. Lafon's son and Hebring. Did not hear what was said. As I looked back, saw Dr. Lafon's son strike Hebring. They were a couple of feet from the street. Saw the butcher boy strike young Lafon, and Lafon struck with a shovel, and they got on the sidewalk. They clenched, and the butcher boy, being larger and heavier, got him down and pounded him with his fist. Saw Dr. Lafon's eldest son come out and pick up the shovel and hit the butcher boy on the back. The young man raised up, and the blow came on the side of the head. Don't suppose it would have hit him on the head if he had not raised up. Took the first blow to be quite light. The second blow was quite heavy. Hebring boy appeared to be hurt. Did not hardly think it was my place to stop or have anything to do with it. Did not turn around to see what happened after Lafon struck the second blow. Did not hear a word said by Lafon. Drove on out of the street. Cross-examined. Hebring was punching young Lafon when the elder Lafon came out. Hebring had all the advantage, was striking very heavy, hitting him quite fast. The ordinary way of striking when men are fighting. He did not give him any chance. He wanted all the chance himself. Striking at young Lafon's face, think if the Hebring boy had not changed his position, the blow from the elder Lafon would not have hit him on the head. Hebring was on his knees, and the boy was under him, and he was turning his head up to see who was striking him. He was hugging young Lafon pretty close. Hebring did not lift his body, only turned his head. He could turn without raising himself. James E. Bathgate, Jr. Am a butcher in the Center Market. Joseph Hebring had been in my employ about a year at the time of his death, delivering meat. On the morning he was injured, he had gone out with a load of meat, with my horse and wagon. Heard before he was brought to the market that he was hurt in Cedar Street. Sent a man to find out, George Burgesser, who is still in my employ. He came back with the Hebring boy. Thomas Lafon came with him. They came in the side door, one on each side of him, holding him by the arm. They said they had brought him in the wagon. He was laid on the lounge in the office. Thomas Lafon said he had hit him. He had done it. He said I would hardly think it, or something to that effect. He wanted me to let him have the wagon to take him home, and said he would fix it right with me. I said he could not fix such a thing as that with me. I wanted him to take him back to his house and leave him there till he could be properly cared for. He would not do it, but insisted upon taking him home to Hebring's house. He wanted to take the butcher wagon, and I would not let him. Told him to take his father's carriage. He said his father had it out. He then wanted to take him home in the butcher wagon, and I told him to get a carriage. He went after it, and I immediately sent for Dr. Bromley. Could not find him, and I sent for Dr. Dougherty. Dr. Dougherty got there before Thomas Lafon got there with the carriage. Dr. Dougherty said he was seriously hurt. Blood ran out of his ear a little. Thomas said Dr. Dennis had seen him and washed his ear and had got medicine for him. He had a little vial and took it out of his pocket. Thomas said he hit him with a shovel, did not say much to Thomas Lafon, but Mr. Johnson in the shop scolded him, and Thomas said he was responsible for it. He had done it. Hebring complained of cold feet and said he was sick at his stomach. Thomas Lafon and Dr. Dougherty got into the wagon and took Hebring away. They brought him to the market about 10 o'clock. He was probably 20 minutes in my office. Hebring had been gone out of my place 3/4 of an hour before he was brought back. This way. Cross-examined. When he said he was responsible, he had done it, he said he felt as badly as anybody. The wagon of mine was a spring-covered wagon. Think it had straw in it. It had no cushion. Do not think he could have been carried well in the bottom of the wagon. Thomas Lafon got a carriage better than the wagon. Don't think the boy spoke about going home. He said very little. He sat up part of the time while he was in my office with his arms laying on the back of the chair. If I said before the coroner's jury that Lafon said he hit him with a shovel, that Hebring was on top of his brother, he saw him through the window, he thought he was a larger person, and he then went out of the house and hit him with a shovel, it is true. Re-examined. Hebring was a little larger than Joseph Lafon, not quite so large as Thomas. Someone spoke of arresting Thomas when he got out of the wagon, and he said he did not know, but he would go to the police station himself. James Allen. Lived with my mother, was in Cedar Street the morning of 5th December. I was shoveling next door to Dr. Lafon's, saw Joseph Hebring come along with his wagon, saw the butcher boy jump out of the wagon and go to young Lafon and punch him right over the left shoulder. Saw nothing before that as he passed along with his wagon. Did not see the difficulty about the snow. When Hebring got out of the wagon and went towards Lafon, he said nothing to Lafon. Yes, he asked what he fired snowballs at him for. Lafon made no answer. Hebring took hold of him and knocked him down and punched him right in the face as hard as he could. Dr. Lafon's son did not strike before they took hold of each other. The butcher boy did. They were right in the gutter, saw the shovel that was laid on the curbstone, saw someone pick it up. The larger Dr. Lafon's son. He hit the butcher boy 3 times. He took hold of the iron part close to the blade and hit him with the handle. They were pretty hard blows. Was standing on Dr. Lafon's stoop. I got on Dr. Lafon's stoop as soon as the butcher boy ran to Dr. Lafon's youngest son. Stood there till he had done to see what he had done to him. Saw where the elder Lafon's son came from. He was upstairs and came down the front stoop. Did not hear him say anything. Hebring was on the top of young Lafon fighting, right by the gutter. The elder Lafon hit the butcher boy, then went up on the stoop. He chucked the shovel down. I saw the Hebring boy was hurt. Blood was running out of his ear. He groaned. Did not hear him say anything. Saw him try to get up a couple of times. Stayed there about 15 minutes. The Hebring boy laid out there about 2 minutes. Did not see him taken from the sidewalk. Did not hear the Hebring boy hollow from his wagon before he jumped off. Don't know where his wagon was when he jumped off. Did not see him jump off. When I first saw him, he was running up the sidewalk. Dr. Lafon's boy was shoveling his walk. Hebring asked young Lafon why he fired snowballs. Don't know what Lafon said to that. Cross-examined. Was shoveling the walk of the house next Lafon's. Don't know the lady's name who belongs to the house. The butcher boy did not pass me after he got out of the wagon. I don't know why I went on the stoop. Was a little frightened. Saw the Hebring boy running up. I don't know whether he seemed mad, angry. Don't know the boy I went to across the street to tell of the affair. I have not seen him here. The boys lay right across the gutter. Anna Poor. Am 14 years old. Am daughter of Reverend Dr. Poor. Was in Cedar Street the morning of 5th December. In Mrs. Bell's house, 2nd story, next door to Dr. Lafon's. Dr. Dennis's house. He married my sister. Was looking out of the window. Saw part of the affair. the handle of the shovel raised in the air, but did not see where it hit nor who it hit, or who raised it. Saw the person, saw his head, did not see the face to recognize him. His hands held the shovel next to the blade, right down next the blade. I saw his hands, both hands, did not see where the blows struck. I'm not positive whether I heard the blows or not. The window was shut. When I saw the shovel raised, saw it brought down. Did not see where it landed. Heard a noise when the shovel came down. Seemed as if it was striking something. Saw the shovel raised 3 times. Heard this noise 3 times. The last one sounded as if it was striking the sidewalk. The first 2 sounded as if it was striking the back. Dr. Dennis was in that room. Don't know which window he was looking through. William L. Thompson. Emma Surveyor have made the map produced here showing the distances from Dr. Lafon's to the corner of Halsey Street and from Dr. Lafon's to the corner of Broad Street. John S. Ball was the constable acting on the coroner's inquest. Held on the body of Joseph Hebring. Have seen this shovel before. Got it the day of the inquest at Dr. Lafon's house. I left it in Mr. Manners' office with this one where the inquest was held. Both shovels were at the coroner's inquest. Joseph Lafon. Am a son of Dr. Lafon. The shovel produced is my father's. I used this shovel on Saturday morning, 5th December, in front of my father's house, cleaning the sidewalk. Cross-examined. There were 2 shovels there belonging to my father. One I used, and the other was loaned to Stickles. Stickles returned his, and I returned mine to the cellar. Went on for about 5 minutes shoveling the walk after the boy was hurt. Don't remember where the shovel was from the time I had it in my hands until the time the servant girl put it away. Did not give it to anybody. Left it at the basement door. The counsel for the prisoner demanded that the state should examine the witness, who was the person named by the other witnesses as engaged in the original conflict with the deceased, upon the details of the occurrence, or at least that the defense should have the liberty to cross-examine him as a witness on the part of the state as to such details, and that the court should so order. The court refused the motion. George Burgesser. Emma Butcher, work for Mr. James E. Bathgate, Jr., have been employed by Mr. Bathgate over 2 years. Knew Joseph Hebring, saw him on the morning of 5th December, drive out in the wagon. About 3/4 of an hour afterwards, I saw him again over in Dr. Lafon's house. I was at market, and someone came and said one of our boys had got knocked down in Cedar Street, and the boss sent me over to see what was the matter with him. Went over to the street and saw blood on the sidewalk, and was told he was in the basement of Dr. Lafon's. Was going down, and Joseph Lafon locked the door, and I could not get in. Went back to the market again, and the boss sent me back to get him. Went again, and they was not going to open the door. Told them Mr. Bathgate had sent me to see how he was. They opened the door, and they was washing him off. It was a lady who was doing it. Don't know who it was. Did not see Thomas Lafon the first time. Saw Joseph Hebring the first time in the basement. They were washing his face off. Did not stay because they wanted to get him off to the market to take care of him. Got the wagon at the corner of Halsey Street, and I went into the basement again where Joseph Hebring was. Thomas Lafon came downstairs. The lady and the man was in who were there before. Thomas Lafon came downstairs into the basement. He did not say anything, but Thomas Lafon helped me to carry him out to the wagon. It seemed to me Hebring was hurt badly. He could not stand and could not walk. We sat him on the seat, and Thomas Lafon drove the wagon, and I was in the back part of the wagon holding Hebring up. He drove him to the market. Did not ask Lafon any questions at all about Hebring. He told me he was not going to see his brother licked of him, getting beat of him. When we got to the market, we took Joe and laid him in the office on the lounger. Left Joseph there, and I had to go to work. That is all I know about it. Saw Joseph Lafon outside his house, and he locked the door on me, so I could not get to see Joseph Hebring. He was outside on the crosswalk. Cross-examined. There was not many people there when I got there, only a couple of boys. Am a German. I have been in this country 7 years. All Thomas Lafon said was, he did not want to see his brother getting beat of him. Did not ask Thomas anything at all. When I came into the house, did not tell Thomas I wanted to take the boy home in the wagon. I said if he was well enough, I was to take him home to the market. The lady said I could take him. I don't know who it was. Stephen Hebring. Am the father of Joseph Hebring. Joseph was about 5 feet 2.5 inches high. He weighed 114 pounds. He was rather small for his age, no taller than Joseph Lafon, but a little stouter. In winter, he used to wear a skating cap and pull it over his ears. Don't know how he was dressed that morning. Mrs. Agatha M. Hebring recalled, Joseph generally wore a hat, but that morning he wore his skating cap to keep his ears warm. He pulled it over down to his neck. It was made of wool, black and red. He wore another hat over it. George Burgesser recalled, Hebring had nothing on his head that morning but the cap that his mother had just shown you. He had it pulled down over his ears. End of section 51. Section 52 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring. Newark, New Jersey, 1869. Part 3. The witnesses for the prisoner. Joseph Lafon. Am the son of Dr. Lafon. Am 15 years and 7 months old. Live with my father. Did not know Joseph Hebring. First saw him on Saturday morning, 5th December, through the back of the butcher wagon. He was going toward Halsey Street through Cedar. Threw snow on the top of his wagon with a shovel. Did it in play. The wagon had a white cover, but the back cover was up. Did nothing to Hebring or his wagon besides throwing snow on it. Am not certain where the snow struck. Hebring turned round and swore at me in the wagon. Answered him. Don't know what oath he said, but if I did it over again, he made some threat. Don't know exactly what it was now, and I told him he would do no such thing. Believe he said he would punch my head off. He said nothing opprobrious or unpleasant, only that he made use of the oath. I told him he would do no such thing. That is all I said. He threatened to punch my head off if I tried it again. He drove to Halsey Street and jumped off the wagon and ran toward me. Stood still and said nothing to him as he approached. Stood about a foot from the curb. He struck me in the left cheek with his fist rather hard. I stepped back, said nothing. Did not strike him. He made a strike at me again, and I struck at him with a shovel, had hold of the handle and held it up as if I was going to hit him. I made a feint at him. Did not throw the shovel forward. He grabbed for the shovel and got hold of it, and I left go. He dropped the shovel and caught hold of me. We both struggled and fell. I was under him. The fall was severe for me. It knocked the breath out of me. Did not feel able to make any resistance to him. He took hold of my hands and commenced striking my face. Put his knee on one of my hands and held the other with his hand and struck me in the face a number of times, very hard. Believe my brother came down the steps then. First thing I saw was the shovel in the air. Saw just the handle. I heard it strike the boy's back twice. During that time, I received blows on the face from Hebring. The next I noticed he was struck in the head and he rolled off me and I got up. He was groaning and called for somebody to send for Jim Bathgate. There was nobody around. Blood was streaming from his ear. Looked round for someone to come and help me. Saw my brother after I got up. He came to the window. After I got up from the struggle, did not see my brother. Did not see him go into the house. Saw him after come to the parlor window, and I saw him ring the bell for Dr. Dennis in the casing of the front door. When Hebring was striking me, I was lying on my back. He was on me right across my breast. One of his knees was on my right hand. His other knee was on the sidewalk. He hurt my face quite badly. It was swelled up and lasted till the next morning. I felt other injuries. My shoulders and arms were lame so that I did not feel able to do anything. I did not go out that day, said nothing while I was down to Hebring, and Hebring said nothing. Did not ask him to let me up. Don't recollect whether I called for help. Had seen my brother before the fight between me and Hebring at the window. He was standing looking out. He was walking up and down. At the time of the contest, when the boy came up, I did not see my brother. Saw George Burgesser at our house in the morning. Did not shut the door upon him that morning. There was a catch on the inside so that you cannot open the door without a night key. When they took Hebring down, they shut the door behind them. That door is usually shut. The boy was brought to the stoop first to go in. Don't know why they did not go in. Cross-examined. Had seen Joseph Hebring often before going round with meat. Had seen him before that morning, but was not acquainted with him. Threw the snow on the top of the wagon from the sidewalk to the middle of the street. Did not make considerable effort. Did it easily. Believe it hit him, am not sure. He said if I did it again, he would punch my head off. Told him he would do no such thing. When I said before the coroner's jury that he said, "You son of a bitch, if you do that again, I'll punch your head off," suppose my memory was better then than now. Those were the words he said. When he used those words, I said he would do no such thing. He muttered something I could not understand, and said, "You will, and then jumped out of the wagon and ran for me. I was standing in the gutter, off the sidewalk, did not move from that position until he struck me. Was struck on the left cheek when I fell. Made a feint at him when he struck at me with a shovel. Got hold of him at the same time he got hold of me. Round the neck we clenched. We struggled and both fell. He put one of my hands under his knee and held it by his weight. He was straddling me. He held my other hand with one of his and struck me with the other. Don't know how long I was that way before my brother came out. Did not seem to me over 3 minutes when he grabbed me first to being down. He commenced hitting me as soon as I was down, quite a number of times before my brother came. There was not much interval between our fall and my brother coming. Did not see my brother come down nor pick up the shovel. Saw the handle of the shovel in the air. I did not see how my brother held it or who held it. I did not see where the shovel struck. From the sound, I say it struck the back. Immediately after receiving that third blow, he rolled off me and I got up. My brother, in giving the 3 blows, gave them in quick succession. Saw the blood from Hebring's ear as he lay on the sidewalk and heard his groans. Looked round for someone to come and help me. Did not call for my brother. Saw Stickles shoveling off the sidewalk a short time before. Did not ask Stickles to help Hebring. I stood on the sidewalk after that about 1/2 an hour after Hebring had gone. Part of the time shoveling and part of the time standing, talking to people standing round. After that I went into the house. Before Hebring came along was playing with the snow and shoveling. I went to Dr. Fish's house after the occurrence, a minute or 2 after Hebring went away. Took my cue with me to play croquet with Fred Fish. Got it at my house. Did not play croquet because Fred did not want to. While I was lying upon the sidewalk and Hebring upon me, there was no blood drawn from my face. There was no marks of blood. Believe there were no scratches. My father did nothing for me. Made no prescription for me. He is a physician. Made no complaint to my father about being hurt, nor to Dr. Dennis. Next morning complained of my shoulders being stiff. Father made no examination of my shoulders or no prescription for me. Am not in the habit of shoveling snow or using a shovel. Am not accustomed to manual labor. My cheek was much swelled. First noticed it as soon as I went into the house, after I came back from Dr. Fish's. When I was at Dr. Fish's, Fred told me my cheek was swollen. Believe my father was home that Saturday. Don't remember about Dr. Dennis. The bell my brother rang for Dr. Dennis is in the casing outside the front door. Saw my brother ring the bell outside. Hebring was then on the sidewalk, was standing on the sidewalk. Don't know whether my brother saw me throw the snow on the wagon. Saw him standing at the window a moment before the wagon came along. Could not say it was true if I said before the coroner's jury. My brother was in the front parlor at the window when I threw the snow, and he saw me throw the snow, because I did not see him. Believe I did not look at the parlor window while I and Hebert were in the tussle. The shovel produced is the one my brother struck Hebring with. Did not see how it was raised. Only saw that part of it, the handle. Don't know how high it was raised. Did not say to Hebring in reply to anything he said that it was none of his damned business. Did not swear. Emily Hornblower. Live in Cedar Street, 3 doors from Dr. Lafon. Came out into the street immediately after the occurrence. The boy was lying on the sidewalk. Saw nothing of the fracas. Saw Joseph Lafon then. Noticed that he had been struck on the face and was very frightened, or as they commonly say, dazed. He was so frightened he did not know who he was addressing. Did not see Thomas. Cross-examined. The report of something going on in the street brought me into the street. Heard Hebring moaning on the street. The first person I saw was Joseph Lafon. Was standing on the sidewalk in front of his father's stoop. It was evident Joseph Lafon had been struck in the cheek. It was red, not the color of excitement or exercise, but the color of the blow. Doubt whether shoveling snow would have had the same effect. Have boys, and when shoveling snow, it sometimes gives them a redness in the face in winter time. Ruth Lafon, am mother of defendant Thomas Lafon, was at home on the day of this occurrence, but did not see it. Heard of it from Thomas first. Heard Thomas's footsteps and judged from the sound, his walking from room to room, he was looking for me. I stepped from my place. I listened to his remarks, told him to bring the boy in, and did not then tell him where to bring the boy in. Followed him then into the entry. He went quickly downstairs into the street, followed him down the steps, and called to my servant to come immediately. Saw Thomas bringing the boy up the front steps, and called to him to bring him to the dining room, for the reason was the house was cleaning and open, and it was therefore inconvenient, and the dining room was ready. My servant came to meet the boy at the entrance to the house, and Thomas took the boy by the arm, and the person holding him drew back, and she assisted the boy with Thomas, had him in a chair, and directed them to bring water and cloths. Examined him as thoroughly as I could, found very little blood issuing from the ear, washed it off, and very little more appeared. Sent for Dr. Dennis. He did not get my message, but came from seeing and knowing of the circumstance. He examined him, asked the boy if he had a mother. He said he had. Asked where he lived. He told me. Just at that point Dr. Dennis came, and I asked him the nature of the injury. He said he did not know. It was internal because he could not find any external injury. He asked the boy if he had a mother and where she lived. After I had washed him and done all I could, a man came rather boisterously to the door, stepped forward to the glass door, and I asked who he was. He said he came from Mr. Bathgate's, and then I opened the door. Previously, Dr. Dennis had said he must be taken immediately home and articles put to his feet to warm him, and rather hurried the matter to be attended to at once. This man and Thomas led him out of the house and put him in the wagon. Joseph's age was 15 years last July. Thomas was 20 years old, 28th October. Thomas has been brought up in Newark. Cross-examined. Thomas was bringing Hebring boy up the front stoop, and another person, a stranger, a plain-looking man, Stickles, directed Thomas to take him down the area steps, and he did so. Thomas returned home about Thanksgiving and had for 15 months previous been in Ohio. He was living in Missouri up to about 2 months previous to leaving for Ohio for 6 months. He was engaged in farming. Before he went to Missouri, he lived at home. Re-examined. Saw Thomas instantly after I heard him going quickly from one room to another looking for me. He wanted advice of me. Am not positive whether he asked me to do anything, but I got the impression what he wished. There was no time of any account elapsed before I went. Did not go to the door, was on the stairs descending, went out and got the boy in assistance, and got 1 or 2 steps up the front stoop. Directed him to return and take him back into the dining room. Dr. Samuel H. Pennington, Reverend Dr. J. P. Stearns, Henry H. Miller, Dr. E. D. G. Smith, Samuel H. Pennington, Jr., Bloomfield Miller, Wayne Parker, Cornelius B. Bradley, Reverend Dr. Poore, Louis Stearns, George W. Hubble, and Preserved H. Porter testified to the good character and peaceable disposition of the prisoner. Mr. Titsworth and the prisoner's counsel respectively agreed that the depositions of Chilean Stickles and Joseph Lafon taken before the coroner should go into the case, whereupon the evidence was closed. The speeches of counsel. Mr. Parker for the prisoner. Mr. Parker, it gives me great satisfaction, gentlemen of the jury, to be able on this occasion, the first on which I have appeared at this bar for 12 years in defense of any man, to enter upon it with the same sense of duty which I endeavored to illustrate when filling the place of my learned adversary, and to assert for my client that he is guilty of no crime, that he is simply unfortunate, that he obeyed an impulse which was honorable and just, which sprang from the better, not from the baser part of his human nature, and that therefore, because he is morally unfit to enter them, undeserving of punishment, the prison doors which open before him ought to be shut, and he should be proclaimed free from legal, as he certainly is from moral blame. What has he done, gentlemen? I do not ask what has happened. We all know the sad tale. We all mourn the untimely fate of the deceased. We all sympathize with the grieving mother and father, refusing to be comforted because he is not. This lad at your bar, not from apprehension but from kindliness and conscientiousness, grieves more than anyone over the sorrowful event which brings us together. His life is blighted by that disastrous blow. But what has he done? Gentlemen, if no death had resulted, if the blows had given simply achieved their purpose, compelled poor Hebring to quit the body of his prostrate opponent, and then, if a grand jury could have been found to indict for assault and battery, what would be your verdict? Would you have hesitated? Would you not at once acquit? And if you would, why should the result be different when all the defendant did was to assault the man who assailed his younger brother, and no more dreamed of serious evil, much less of death, than did young Hebring himself? Take this suggestion to your minds, gentlemen. It is the point of the defense we make. The theory of that defense, gentlemen, at large, is this, that the defendant had a right to defend his brother to the same extent the brother had, that the violence he used so far as he intended it was not unreasonable, nor more than his brother had the right to use, that the death happened through the mischance of the deceased turning his head at the same time, rising so as to receive this blow on the side where the skull was thin, and hence that in this case comes directly within the definition of death per infortunium, a homicide excused by reason of its happening through misadventure. For the purpose of clearly stating the law, I shall here assume certain facts. Later I shall prove them. 1. That the deceased was the assailant upon Joseph Lafon. 2. That when defendant saw the combat, his brother was helpless in the hands of deceased, who was administering to him blows with the intent of doing great bodily harm. 3. That defendant then rushed out and taking the spade as if it were a cudgel, struck deceased. 4. That deceased turned and at the same time raised himself, and his head thus received a blow which, but for his change of his position, would have been harmless. If deceased was the assailant and Joseph Lafon was suffering blows, the right of self-defense existed on Joseph's part, and it is material to settle to what extent. Self-defense, so as to take life, does not exist when the assailant does not seek life till the assailed has been driven to the wall, i.e. has retreated as far as retreat could be carried. That he had done. He was down, helpless, the assailant holding him skillfully and beating him. In this position he had the right to anticipate great bodily harm, but for the intervention of his brother he would have received it. There was inequality of strength, there was avowed intention. There was perfect triumph, there was skillful pugilistic arrangement, there was greater age, strength, everything, there was violence directed to the eyes, mayhem perhaps might have ensued, to an excited sufferer it was probable. Now what right had Joseph Lafon? It is not necessary to claim that he had a right intentionally to kill. Who believes that this intention existed in any heart? But he had a right to oppose bodily harm by bodily harm, in his helplessness to use any weapon not necessarily deadly, nor in a manner intentionally deadly for self-defense. Who can deny this? If Joseph Lafon had, while writhing on the ground, seized this shovel and using it as a weapon struck blows which killed his assailant, without intending any special wrong, striking as it were at random, would he be held guilty of his death? Certainly not. It would not have been involuntary manslaughter. It would have been self-defense, clear, for the weapon was not deadly, nor would its use be meant to kill. I put to you some cases, gentlemen. Suppose the weapon was a pistol, which was used as a stick, not as a firearm, but went off and killed. Suppose it was a sword cane, and that used as a cane, the scabbard flew off, and not seen by the recumbent boy, the blade pierced and slew. Suppose he struck blindly and thus hit a vital part and slew. Suppose the blow was received where it could do no great hurt, and a change of position brought a vital part beneath it. As we say here, clearly this would present no crime. And there are the best of reasons for this conclusion, for, 1. The act was lawful. It was so because it was only self-defense, preventing bodily harm by bodily harm, of the same nature and not unequal degree. The fist and the stick are both striking weapons. Position, opportunity, strength, skill may make either one superior to the other. 2. No intent to do the greater injury existed. That sprung from chance. For that no one is responsible. Whether manslaughter be voluntary or involuntary, there is always an unlawful act intended and performed. There can be no crime without an unlawful act intended and performed. In the supposed case, no unlawful act was intended, and so none could be performed. Further on, I shall cite the law on this matter, settling and describing what is homicide by misadventure. I submit, then, that Joseph Lafon had the right of self-defense in this case to the extent of justifying homicide, if he had committed it just in this way, intending only to meet force by force, and unintentionally slaying. And I contend next that Thomas Lafon, his brother, standing near and seeing his imminent danger, had the same right exactly. He had a right to join in this combat. he had a right to administer blows of the like nature with those given to his helpless brother. And if by chance and undesignedly one of those blows slew, it is misadventure only, and he can be convicted of no crime. It is intimated by eminent authority that this right of interference, of joining in the quarrel and aiding to beat off an assailant, belongs only to the relations of parent and child, husband and wife, not to brothers. On principle, why? Suppose a brother find a sister struggling with dishonor in the grasp of a villain. Shall he not do for her what sufficient strength prevents her doing for herself? Suppose a brother find a young sister, a child in the hands of someone who is endeavoring to carry her away, though without felonious intent, only unlawfully. Suppose a brother find a younger one, and that a child utterly overpowered, and at the time receiving great bodily injury, helpless. Must he parley or strike? Must he ask, "What are you doing?" Must he run into the mother and tell her? Or may he not at once act upon evident necessary to save his brother? Cain exclaimed, "Am I my brother's keeper?" Does the law endorse the principle of which he sought protection? It was God who asked, "Where is Abel thy brother?" And though the question was, "Why have you murdered him?" it involved the principle that it was his duty to defend him. Blackstone does not exclude this brotherly interference. He says, Volume 4, page 186, under this excuse of self-defense, "The principal civil and natural relations are comprehended. Therefore master and servant, husband and wife, parent and child may assist each other." It is only that he particularizes these relations affirmatively, not that he negatively excludes any does he not mention. I beg pardon for asking your attention to rather a long citation from the Book of Acknowledged Authority. I read from 1 East Pleas of the Crown, page 289. 3. As to the persons by whom such justification or excuse may be urged, in all cases where a felonious attack is made, a servant or any other person present may lawfully interpose to prevent the mischief intended, and if death ensue, the party so interposing will be justified. Thus, in the instances of arson or burglary, a lodger may lawfully kill the assailant in the same manner as the owner himself might do. This is subject, however, to the same limitations I before noticed. In this respect, I see no difference between the case of the person assaulted and those who come in aid against such felons. If A and B fight upon malice, and C, the friend or servant of A, not being acquainted therewith, come in and take part against B and kill him, this is murder in A, but only manslaughter in C. Otherwise, if C had known that the fighting was upon malice, for then it would have been murder in both. But if A had been assaulted and had retreated as far as he could, and then his servant had killed the assailant, it would have been se defendado. Upon the whole, although Lord Hale and others appear sometimes to intimate a distinction in these respects between the cases of servants and friends and that of a mere stranger, yet it must be confessed that the limits between both are nowhere accurately defined. And after all, the nearer or more remote connection of the parties with each other seems more a matter of observation to the jury as to the probable force of the provocation and the motive which induced the interference of a third person, than as furnishing any precise rule of law grounded on such a distinction. Later authorities are clear on the point. 2 Bishop's Carl Law, 662, also 630, 631, 633, 634. Wharton on Homicide, 230, states the doctrine rather loosely and cites Calm v. Riley Thatcher, Case 471. Psalm v. Drew, 4 Mass, is a case where a fellow workman was held within such relationship as to be excusable in interfering. In Addy's case, Leach, 248, 1 East, 329, a paramour was held within the benefit of this doctrine of relationship. Reg v. Tooley, 2 Mod, 242, entire strangers were held excused for interfering to get a woman released who turned out to be unlawfully arrested. People v. Cole, 4, Parker, CC 40. The court allowed defense that defendant interfered to protect another standing outside the specified relations, and held if the jury thought murder was intended, it was right to use firearms, otherwise, if beating only was designed. These authorities are sufficient to settle that what Joseph might do for himself, Thomas might do likewise. Neither had a right to intend taking life, either had to defend Joseph, and if in exercising this lawful right, accident joined and produced death, there is no crime, for there is no unlawfulness and no guilty intent. If either had used a knife and struck to kill, it could have been but manslaughter, but that it is not necessary to discuss. I said that I would cite the law to describe the case in hand and show that it is no crime. I take as clearest and most profitable the definition of manslaughter given by Lord Coke, 3 Inst. 56. Homicide by misadventure is when a man doth an act that is not unlawful, which without any evil intent tendeth to a man's death. Bishop, Cur Law, page 614 to 642, quotes Blackstone adopting Hawkins, who instead of saying without any evil intent, says without intent of hurt. This is loose. Illustrations are given in 1 East, PC 40. A man corrects his child. He means to hurt him, but he has no evil intent. An accidental change of position or other misfortune renders a blow fatal. It is homicide by misadventure. So with officers punishing soldiers, a man shooting when in play. The real principle underlying all is that there must be evil intent. If no intent, no crime. The law of homicide may be thus summed up. Evil intent, inexcusable to take life, is murder. Evil intent, excusable to slay, is manslaughter. Evil intent, inexcusable to injure or do some great bodily harm, is murder in the second degree. To do some unlawful act not involving that which results in death is involuntary manslaughter. No homicide without assault, no assault, technically without intent to do wrong. Whenever only right is intended and nothing done in excess of right, the consequence is misfortune, though it be death. End of section 52. Section 53 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 4. These are the principles of law, gentlemen, and now I turn to you to demonstrate the points of fact, which hitherto I have taken for granted. I insist. 1. That the deceased was the assailant of Joseph Lafon. 2. That when defendant saw the combat, his brother was helpless in the hands of deceased, who was administering to him blows with the intent of doing great bodily harm. 3. That defendant then rushed out, and taking the spade as if it were a cudgel, struck deceased with no intent to do bodily harm, or more than to protect his brother. 4. That deceased turned, and at the same time rose, and his head then received a blow intended for his back, and which, but for his change of position, would have been harmless. That the deceased was the assailant upon Joseph Lafon. Chilean Stickles himself, whose account of this transaction is so different from everyone else, that it seems as if he had not actually been there, says in his examination before the coroner's jury that Hebring told young Lafon if he fired another snowball he would knock him over the head. That he got out of the wagon at the corner of Cedar and Halsey Streets, went back, and afterwards between them drew off and struck Joseph Lafon by the side of the head with his fist. Mrs. McCormick, the nearest of all the witnesses, corroborates Stickles' story. James Allen tells you that he saw the butcher boy come out of his wagon and come up to young Lafon and punch him in his neck. That was the first he saw, that Lafon said nothing to him when Hebring asked why he threw snow at him. And Talmadge, who passed Hebring, both driving wagons, says he saw Hebring come back and strike the younger Lafon. These are all witnesses for the state. Joseph Lafon, called likewise for the state, though not upon this point, states everything in detail and says that after throwing snow against the wagon, Hebring turned, swore at him, said he would punch his head off or something similar, and he replied to this simply that he would do no such thing. That he then jumped off the wagon, returned, and struck him on the left cheek with his fist. When he stepped back, struck him again, and so commenced the struggle, which, in its later stage, defendant saw from the window. When he looked, his brother was lying flat upon his back on the stone sidewalk, helpless. In the hands of the deceased, one hand under one of his knees, the other clutched in his own grasp, and forcibly held across his body, while the deceased, with every apparent intent of doing him all the harm he could, was striking him in the face and near the face with all of his force. No question exists as to the truth of this narration. Miss Searing looked from the window opposite. She saw them in the beginning of the struggle. After the first blow, Hebring seemed trying to throw Joseph, while Joseph seemed trying to get rid of him. Hebring threw him on his back, took his place upon him, and was pounding him about the head and neck. Then, says she, Thomas came to the window, looked out, and instantly came out, picked up the shovel as he passed to the boys, and struck these 3 blows. Mrs. McCormick tells the same thing, with the addition that Thomas came out bareheaded and in his slippers. Charlotte Condit relates it almost in the same words, and both she and Mrs. McCormick say that while he was down, Joe did nothing, that they saw that neither his hands nor his feet were in use. The violence of Hebring's attack was most graphically described by Talmage, the colored man. Hebring, he says, was striking very heavily, was hitting him fast, was in earnest, giving him no chance, was striking at his face. James Allen says Hebring took hold of him and knocked him down and punched him right in his face as hard as he could. Joseph Lafon says we struggled and fell, I under. The fall was severe for me. It knocked the breath out of me. I did not feel able to make any resistance to him. He took hold of my hands, put his knee on one, and took hold of the other, striking me in the face. He struck me quite a number of times very hard. I believe my brother came then. I received blows from Hebring during that time, the time when the shovel was used, more severe than when he came out. And Mrs. Hornblower, one of the most intelligent of Newark ladies, came out immediately after the disaster and noticed Joseph's appearance. A mother, and used to seeing her boys after contests of this kind, she says she saw that he had been pummeled in the face, describes him as appearing dazed, and realized at the time that the assault had been severe. It may be urged that little harm turned out to be actually done, but what of it? All was done that could be done, at least all appeared to be doing all that could be done. Certainly to a brother's eye, and that is all that the case calls on you to realize. While the parties are in this attitude, the younger brother helpless, the assailant unknown, his appearance that of a person accustomed to acts of violence, his attitude and action those of a master of the business he was then engaged in. The defendant rushes out, prompted by no anger, obeying an impulse as laudable as it was natural, and having a right, if our view of the law be correct, to assist his brother and to meet force by force, to equalize the contest between the parties. He seizes the spade, he uses it, not as the weapon which it might have been, and with no intent to do great bodily harm. The harm it did produce was as great a surprise to him as it was to every one conversant with the transaction. His manner of use is clear, he uses it as a stick. He struck with the handle. There can be no doubt on this point, and it is a material one to consider. Mrs. McCormick, passing so that she must almost have stepped upon them, states positively on her examination in chief for the state that he struck him with the handle of the shovel, with the flat part of the handle. Dr. Dennis, looking from the second-story window of the house next door, and able only to see the instrument as it was raised, swears with like positiveness that it was the handle which rose and fell. Young Allen says he took the handle of the shovel above the iron part and hit him with the handle. He held it this way, says the boy, and showed you how it was done. Annie Poore saw the shovel raised as she looked out of the same window as Dr. Dennis, saw the handle, though she did not see what it hit, nor where it hit, nor who held it. She saw someone's back and someone's hand, and swears that his hand held the shovel right next to the blade on the handle. Joseph Lafon saw distinctly that it was the handle with which he was rescued, saw it rise, marked each blow, and cannot be mistaken. Here are witnesses having the best of opportunity, entirely positive and entirely reliable. Those who do not agree with them are not positive and do not contradict. Mrs. Crowell says, I do not feel as if I could be at all sure what part of the shovel was used. Mrs. Woodruff only thinks it was with the blade that he struck. Miss Searing says it seems as if he struck with a blade, but of that I will not be positive. And Stickles has the same uncertainty. And this fact joined with others to demonstrate that the defendant had no intent to do bodily harm. In fact, the idea of such an intent is almost ludicrous, if one will consider a little. Why did he not seize the shovel by the handle, using the edge for a weapon, and split the skull at once, if he had wanted to do injury? Why did he not, although desirous to avoid such inhuman extreme, with one blow given on his side, knock the assailant as he might clear off from his brother's body? The flat of the shovel, used with half the force in his power, could easily have done this. Instead of this, he gives blows which evidently were not violent, and as evidently must have been restrained. For notice that the first blow did not even attract attention. The assailant went on pounding or punching, to use the different words of the witnesses, paying no heed whatever. The second blow quickly followed. That made no special difference. There was no groan, there was no cry, there was no convulsive start. The only effect observed was that he turned his head as if to see who was striking, and at the same time rose, as indeed he must, in order to see from the almost recumbent position in which he was stooping over the boy Lafon. And note lastly that the physicians found no wounds or bruises elsewhere than the almost imperceptible abrasion on the head. In another thing do all witnesses agree, that the blows were in quick succession and were almost alike in character. No witnesses applies to them terms of great severity. All use adjectives which diminish the force of what they say. To Mrs. Crowell they seemed hard, to Mrs. Woodruff rather severe, to Mrs. McCormick all three quite hard, about alike all three. Miss Searing says they did not seem very hard. I don't think they were hard enough to do harm if one had not struck him in the head. Charlotte Condent says pretty heavy in quick succession. Chilean Stickles, pretty hard. James Allen, pretty hard. Did ever a case occur when violent blows were struck which every witness thus qualified in description? Nor does the effect produced, as shown by the medical testimony, prove this blow severe. True, there was a crack in the skull, but the abrasion was on the thinnest part of the skull, proverbially most dangerous. The thinnest part, says Dr. Dougherty, of the skull, thinner than usual, which there, as often, was quite brittle. The fissure left the abrasion and started downward, and in its course striking the bone of the ear. The crack extended through that bone, but what of that? A moment's thought will tell you how easily this might be. And yet the blow be light. Strike a glass upon its edge, thicker though it be toward the bottom, the blow, if sudden, will crack it to the bottom. Strike with a stick a watermelon smartly on its side, the bruise cracks it transversely. Stamp your foot upon the ice, and the crack flies hither and thither, amazing the observer. Take an illustration which I read you from Taylor's Medical Jurisprudence, where a simple tap by an officer holding a party in arrest broke his skull and occasioned his death. It is not the violence of the blow that produces such a crack, it is the suddenness mostly. Why, gentlemen, a violent blow with a heavy stick of the size of this upon the side of one's head, rising as it meets it, would smash it in, and produce no crack, but almost pulverization. Having thus no intent to do any great bodily harm, the question is, how much force had he a right to use? He had Joseph's rights, as I have shown you. I might even argue that he had more if the rights of each are according to what they realize. For Joseph, feeling, knew better than Thomas, seeing, knew what force the assailant was using, and therefore what he needed to equal. I will not repeat to you what the witnesses say as to the violence of Hebring's blows. Did they not appear violent? That is the point. If to Talmadge the colored driver, and to little Allen, who stood upon the Lafon stoop and looked on, and to Joseph Lafon as he lay there, the appearance was of blows given with all possible force, the party striking, kneeling over his prostrate foe, securely holding him in a manner to indicate power, skill, triumph, and ill intent. If I say things appeared thus to the uninterested, how did they appear to this elder brother accustomed to think of the boy near 6 years his junior as but a child, and utterly ignorant that this young butcher lad was not a grown man? What appeared settled his right. What reasonably appeared, I mean, reasonably having regard to all the circumstances and means of knowledge in his possession. There is a case cited in the books where one, seeing another down, an assailant striking with apparent violence, handed to him a knife, with which the assailed took the life of the assailant, and he was held not guilty of crime. The law is definite that in cases of self-defense by a party helpless, blow may be returned for blow, and that the violence of such blows will not be carefully measured. It is only when a man having a chance to escape will not take it that the laws measure the resistance he makes. Thus, I submit, gentlemen, justified by law, because he acted without criminal motive and in aid of one whom it was his duty to aid, the defendant's last blow is attended with disaster utterly unforeseen, never sufficiently to be regretted, but for all that naught but misfortune, for which before God or man he is in no wise responsible. For that blow struck the deceased only because of a change of position, and but for that position would have been as harmless as those which had preceded it. There can be no doubt of this. What says Mrs. Woodruff? It would not have been given on the head, except for the boy raising and turning. It would not have struck him there, but for that it would have been given on the back. What says Mrs. McCormick? He turned his head to see who was striking, turned up his head and raised up. He changed his position and brought it on his head. It appeared to me that this change of position brought him in the way of the third blow. He turned and raised to see who was striking him, I suppose. Then Miss Searing says, the two first fell on the back. The boy raised and turned his head at the same time and seemed to put his head in the way of the shovel. Charlotte Condent, he struck 3 blows, 2 on the back, that the boy lifted himself up. As he did, he struck a third, which hit his head. Chilean Stickles, before the coroner, says he was in the act of getting up, was getting straight from being doubled up. He had his head over and was just merely straightening himself up. And Robert Talmadge, if it had not been he changed his position, the blow would not have hit his head. He raised up, and then the blow came on the side of his head. If he had lain still, he would not have hit him on the head. True, he was not called upon to lie still. True, if the defendant was not justified in his blow, the whole complexion of the case is changed. But if he was justified in his blow, if it was without evil intent, if on the contrary it was with lawful and good intent, if the blow as such was not unlawful, then the death which came from it was not unlawful either, but was simply and solely misfortune. Just as when a father correcting his child wrings his own heart by inflicting a fatal but accidental violence, or an officer punishing a soldier or any individual acting carelessly but not unlawfully, as one in sport, happen by accident to take life, all are excused, for the law punishes crime and requires evil intent or unlawful conduct. Here is the keynote of the defense, which I sound and sound again, that may it not be forgotten. To convict this defendant, his intent must have been evil, or his act must have been unlawful. Neither of these things exist in this case. His intent was noble rather than evil. His act was what no law prohibits. If he struck from personal animosity simply, or if the act he meditated was unlawful, then the state may succeed. But if the act he meditated was lawful, and the act performed was likewise, a result uncontemplated and purely accidental involves neither turpitude nor crime. Here, gentlemen, is the moral gravamen of this case. If this defendant goes to the penitentiary, he goes innocent of crime. He meant no wrong. He did what you might have done, what your sons would still more likely to do. He had no malice, no knowledge even of this unfortunate boy. His first sight of the occurrence was when he saw his brother on the ground. He had no time for animosity. He had no time for consideration. Blows were falling thick and fast. It was his brother who was suffering, and how can you or I or anyone blame him for rushing to the rescue? How did he behave when he realized, not death, not even danger of death, but simply that injury greater than he had dreamt of was done to this poor boy? Who brought him into the house? Thomas Lafon, obeying his mother's wish as well as his own impulse, met him halfway on the steps and aided to bring him in. It is a crime alleged against him and his unfortunate mother, too, that they did not bring him into the entry and the parlor, which then were in confusion, the very act of cleaning going on, and where there was no convenience for his relief, but took him instead to the dining room, which was in order for his reception, and where water and every other desirable convenience were ready at hand. To argue on this seems nonsense. When he was there, the mother washes his face, the son standing anxiously by. The doctor is summoned, and as soon as his look betrays anxiety, their interest doubles. Bathgate's boy comes over for him. They find he has a mother, learn her residence, and this defendant and a messenger go together and gently take him home. They stop at the market. There the boy alights. Thomas wishes to go on. Was he not sensible? Bathgate wishes him to go back with him to his own home. Would his mother have liked that? Thomas sees more clearly what is best, and finding that Bathgate would provide no vehicle, goes and gets one, and with Dr. Dougherty, who fully endorses the wisdom of the procedure, carries the poor sufferer where he most wished to be, and where those who most loved him wished he should be. Before they go, some stranger scolds the defendant. His reply is, "I have done it. I feel as badly as anybody can do about it. I am responsible for it. Hebring was on top of my brother. I thought he was a larger person, and I went out of the house and hit him with a shovel." To Burgesser he says in the wagon, as if soliloquizing, "I was not going to see my brother getting beaten of him." To the doctor, "I know you will think it a brutal thing, but I saw him on my little brother, and I went to get him off." And the doctor adds, though he does not recollect, that he may have said that he had no idea of doing him any hurt, and expressed surprise at what he saw of the injury. And when he goes to his home and sees his mother and witnesses her natural grief, he asks a question which seems to me most natural. His only remark, for what words could express the feelings which tormented his heart, was to ask her how many children she possessed. All this to me seems, not cold, not unfeeling, but the natural conduct of one who shrunk from the thought that he had done any hurt, and upon whose mind, instant by instant, the extent of the hurt done was dawning. Some natures, mostly thoughtful of themselves, bemoan their conduct violently, thinking that thus they will help screen it from animadversion. But other natures, deeper natures, and more unselfish, are horror-struck by the discovery that they have done unwitting evil, and are silent because unable fully to express their self-reproach, while they labor with all their might to do what they can to alleviate the suffering they have accidentally inflicted. Day after day did this boy visit the family his hand had inflicted. By day and by night this terrible scene is in his memory. Convicted or acquitted, the thought will never leave him that he had been the occasion of another's death, and he needs no punishment that the law can inflict to deepen his sense of what he has done. And now, gentlemen of the jury, my task is done. I leave the defendant in your hands. You cannot wonder at my solicitude or my zeal. You do not. You are fathers, brothers, men, Christians. You know I speak the truth when I say that the fate of poor Hebring, lying in his shroud, is preferable to that which may befall this boy at your bar, as a consequence of the verdict which you may give. Child of fond parents, their eldest hope and pride, unstained by vice or crime, member of a Christian church, beloved by a large circle of relatives and friends, no wonder that he shudders, no wonder that they and I shudder at the possible close of this sad drama. Over his bright and happy future a dreadful cloud already hangs, and must hang, though you release him till years live down the suspicion which mere accusation necessitates. But one fearful word from you, and this cloud settles around him, black, dreary, perpetual. Gentlemen, can you speak it? You are to do justice, but to love mercy. You are to give him your doubts, all doubts which are reasonable. Under the evidence in this case, is the state prison his desert? Think what it is to him, innocent beyond question of guile, the extent of whose possible fault is indiscretion, not even impelled by momentary animosity, obeying an impulse which God makes his duty. Can you fasten on his limbs the fetters of a felon? Can you see him led away in sad procession to the train, and thence to the portals of that house of villainy and vice? Can you think of him, shorn, clad in the vile dress of convicted felony, laboring from day to day, the companion of thieves and robbers and murderers, of men whose crime deserve the ignominy they endure? It is not fit, gentlemen, that this suffering should be his. You cannot impute to him moral guilt, and no man should enter there devoid of that, to endure the torment which an unstained soul must suffer, degraded to such companionship. Will you say this may not be his fate? But your verdict against him must be of almost equal horror. Convicted, what will he do? What room for usefulness or happiness in his future? The stain of blood will be stamped upon his brow. You will write there the fearful title of manslayer, and where will he go that it may be forgotten? What will he do to efface it? It will block his pathway everywhere. He will be an outcast and a wanderer, driven forth from this happy home, these loving friends, these doting parents, without hope. No, gentlemen, I say too much. Nothing can deprive him of that. Those who have so earnestly pursued this persecution, however successful they may prove, cannot. For he trusts in God. He has given his heart to him. He has consecrated his life to him. And though the worst should befall him, though he should be doomed even to the horrors of that cell, over whose gloomy doors imagination writes, who enters here leaves all hope behind, still God will be with him. God will comfort him. He has trusted in him, and he still confides that though all human help be impotent, though flesh and heart fail, yet his God will be the strength of his heart and his portion forever. End of section 53. Section 54 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 5. Mr. Bradley, gentlemen of the jury, I feel that I encumber the case after the very able and exhaustive address of my associate counsel. My observations will be brief and will relate only to such points as have struck me with peculiar force. In the first place, after a careful digest of the evidence, I will endeavor to state to you what seems to be the principal facts of the case as they have been proved before you, founded mostly on the evidence of the state itself, but where not thus founded, so substantiated by credible evidence and so probable that no unbiased mind can have a reasonable doubt on the subject. If I have ever made a careful, truthful, and conscientious statement, it is this, and it is as follows. On the 5th of December, after a fall of snow, Joseph Lafon, a mere lad of 15 years old, was shoveling snow from the sidewalk in front of his father's house in Cedar Street, and, boy-like, occasionally indulged in the sport usual on such occasions of throwing snow with his companions. He had just been engaged in this play with his little neighbor, Miss Lottie Condit, having in the meantime cleared off the sidewalk and commenced to clean out the gutter. Thomas Lafon was in the house, walking the room, and occasionally stopping and looking out of the window. Joseph Hebring, the unfortunate deceased, came along in his butcher wagon, going out to distribute meat for his employer. He was nearly 19 years old, and, as his mother says, a strong, hearty boy. As he passed Mr. Lafon's house, the boy Joseph Lafon, in sport and play, threw some snow against his wagon. This enraged the deceased, and he called him by an opprobrious epithet. "You son of a bitch, if you do that again, I will punch your head off," and swore at him. Joseph said to him, "You will do no such thing." Hebring then drove on a few rods and stopped his horse, deliberately got out of his wagon, ran back, and attacked Joseph, who drew back, making a feint as if he would strike with a shovel, and tried to get away from Hebring. But Hebring clinched him around the waist, threw him on the sidewalk, fell on him, fastened his hands, and commenced pounding his head and face unmercifully, whilst the back of his head lay on the stone pavement. At this instant Thomas Lafon comes to the window, and seeing Hebring pounding his brother, and deeming him even larger than he was, and supposing that his brother was in imminent danger of being seriously injured, he ran into the street without hat and nothing but slippers on his feet, caught up the shovel which had fallen on the walk, holding it near the blade with the end of the handle, struck Hebring on the back or shoulders in order to force him from off his brother, when unfortunately Hebring raised his head and turned it around toward Thomas right in the way of the shovel handle, and thus accidentally received the blow on the side of his head over his ear, and his skull was fractured, and his death was the consequence. Thomas was frightened and horror-struck. He rushed into the house, stopping on the front steps to look back at Hebring, searched for his mother, and asked her what he should do. What he said to her we were not permitted to show. She told him to bring him in and directed them to the dining room in the basement. He was brought in, slightly examined, and was able to speak, and Dr. Dennis directed that he should be taken home to his mother. Thomas assisted in getting him into the wagon, accompanied him first to the market in accordance with the request of Mr. Bathgate, then got a carriage and assisted in taking him home, and never manifested anything but the deepest sorrow at the occurrence, and never attempted to evade justice or the strictest inquiry into his conduct. These are the naked facts, and in view of them it is very difficult for an honest mind to see anything in Thomas Lafon's conduct worthy of the slightest blame. Had it not been for the unjustifiable excitement which was incautiously and wrongfully raised, no one would have seen anything to blame for him. For the defendant, we contend that it was a case of excusable homicide. We do not contend, it is not necessary to our case to contend, that it was justifiable homicide. The latter is when a man purposely and intentionally commits a homicide for a justifiable cause. The former is when a man accidentally commits a homicide against his intention whilst doing some other act which he had a right to do. The case then depends on two questions. First, did Thomas Lafon intentionally produce the death of Joseph Hebring, or intentionally strike him on the head? If not, secondly, had he a right to do what was intentionally doing, strike Joseph Hebring on the back or shoulders with the handle of the shovel to force him to leave his brother? If he had such a right, then the accidental result was indeed a misfortune greatly to be deplored, but it was only a misfortune for which Thomas was excusable. It was then a mere case of homicide per infortunium, as the law books call it. Now, as to the first point, I have never heard any person hazard the belief or even suggestion that Thomas Lafon purposely took Hebring's life, or purposely struck him on the head. At all events, the evidence of the state's witnesses is clear on this point, and needs no illustration from me. Mrs. Woodruff, an eyewitness, said the blow when delivered would have been received on the back had not the boy raised his head and turned it. Mrs. McCormick, who was close to the boy, said, when he, Hebring, turned around and raised himself up partially, his object appeared to be to see who was striking him. This action on his part brought him in the way of the third blow, changed his position, and brought the blow on his head. Miss Searing said the two first blows were on the back, then the boy raised and turned his head at the same time, and seemed to put his head in the way of the shovel. These are the state's witnesses. Other witnesses testified to the same effect, and there is no evidence to the contrary. If anything in the case is clear, this is, that the blow on the head was accidental, and there is no evidence of any intent to do anything more than to strike the deceased on the back to compel him to get off of Joseph Lafon. The prisoner himself, whose declarations have been put in evidence by the state, expressly states that to have been his object. The question then recurs, had Thomas Lafon a right, under the circumstances of the case, to strike Hebring with the handle of the shovel on the back and shoulders in order to compel him to leave his brother? I unhesitatingly and confidently contend that he had. In the first place, I contend, as Mr. Parker had contended, that Thomas Lafon had the same right which his father would have had to defend and protect Joseph Lafon from the furious assault of Hebring. And his father, had he been present, certainly would have had the same right to defend and protect Joseph that the latter would have had himself. And surely neither of them would have been called in question for using the most vigorous means for compelling that stout young man to desist from beating Joseph. Are we to be told that a boy or man may not protect and defend his little brother when he sees him abused by an older and a stronger boy? That he must only interfere as a stranger would interfere to prevent a breach of the peace? That he must crush the spontaneous feelings that rise to impel him to the rescue? If such is the law, it needs instant amendment. But I contend that it is not law. I contend that when the law says that parent and child, husband and wife, master and servant, and guardian and ward may defend each other, it cites these merely as examples of a general rule, that all persons in near domestic relations to each other may defend each other. Such, I think, is the spirit of the law, if carefully scanned. As a general rule, whatever violence an individual may lawfully exert in his own defense, he may equally exert in defense of another person who stands in a near domestic relation to him. In the Hebrew law, it was the bounden duty of the brother to defend and even revenge his brother. He was a true avenger of blood. But in this case, Thomas Lafon may be regarded as standing in his father's place. His father was absent from home. He was the oldest male member of the family present. As son and servant of his father and his representative, he was bound to take his father's place. We claim this position for Thomas because we think he is entitled to it, and because the law is not so strict in requiring a man to ascertain the cause of the altercation, or in exacting care and caution in the means used for his own defense, or the defense of a child or other near relative, as where he interposes in behalf of other persons merely to prevent a breach of the peace. And certainly no reasonable person could blame the father of the boy or the boy himself for raising the handle of a shovel or any other instrument of the sort, lying accidentally at hand, upon the back or shoulders of the assailant to compel him to desist. But in the second place, if not entitled to stand in like place as a father, Thomas Lafon, as a mere brother, was entitled to act on those sacred instincts which would prompt him to protect and defend his little brother, and was not called upon to exercise all that circumspection and deliberation which would be exacted from a mere stranger. The law is express on this point and amply sufficient to justify the defendant in all that he intended and attempted to do. In East Pleas of the Crown, 1-292, it is said, "The nearer or more remote connection of the parties with each other seem more a matter of observation to the jury as to the probable force of the provocation, and the motive which induced the interference of a third person, than as furnishing any precise rule of law grounded on such a distinction. What we justify is the assault with a shovel handle for the purpose intended, namely the compelling of Hebring to desist beating Joseph Lafon. That being justified, the defendant is excused from the consequences of the unfortunate accident which resulted in the blow on the head. The only question in the case which admits of the slightest hesitation is, whether the defendant, in effecting the purpose he had in view, was justified in using the weapon he did. The circumstances must be remembered. He was walking the room, he looked out, saw the butcher boy beating his brother, who was down on the hard pavement, beating him about the head and eyes, not softly but violently. He rushes out, prompted by the most natural and justifiable instincts, with bare head and nothing but slippers on his feet. He catches up the shovel which lay there accidentally. He shows that he had no intention to use it in a deadly or dangerous manner by taking hold of the handle near the blade being towards himself. In that manner, holding as it were by the middle of the handle, he strikes rapidly with the end of the handle. Strikes not at the head, not at any vital part, but at the back and shoulders, protected by thick winter clothing. Had the case ended here, could a case of assault and battery have been sustained against him? Certainly not. And here was where he intended it to end, but by chance and the mysterious providence of God, the boy raised himself on a sudden, turned his head against the last blow, and received the fatal wound. All that the defendant did or sought to do was justifiable, lawful. The rest was accident, which all of us are liable to. It seems to me that if we properly distinguish between what was done by the defendant and what was a result of mere accident, the jury cannot have a doubt that he ought to be acquitted. If he cannot be acquitted, then a father who reluctantly and affectionately attempts to punish his beloved child, but by an unfortunate accident inflicts a blow that takes its little life, is also guilty in the eye of the law. We beg the jury to remember that we do not justify the homicide, but only the act which the defendant attempted to do. The homicide being accidental was excusable. And wherefore, gentlemen of the jury, should you convict the defendant? For any moral guilt? Certainly not. For any legal guilt? Certainly not, if I have stated the case rightly. Then what purpose can be subserved? You cannot bring back the spirit of young Hebring. That has fled beyond our or your recall. The defendant had no malice against him. He did not know him. Aside from any consequences to himself, he would gladly call him back to life again, if, by any sacrifice he could make, he could do so. Will public justice be subserved by a verdict of guilty? Does the cause of good order require it? Justice and good order, gentlemen, are best subserved by a verdict according to truth and the law. Mr. Titsworth for the State. Mr. Titsworth. Gentlemen of the jury, in the few words I may have to address you, I must in the beginning crave your patience, for I shall endeavor, in very plain speech, to impress your minds and souls with the facts of this cause, as mine have been during this trial. The case has assumed an importance greater than that which usually attaches to criminal trials. The interest manifested by the community is deep and absorbing. The social position of the defendant and that of the late deceased have naturally excited this interest to a great extent. But let us, divesting our minds from all undue sympathy or prejudice for or against this defendant, seek to do what is only right, that justice may follow. The learned counsel who first addressed you in the defendant's behalf called your attention to some cases of manslaughter which he tried during the time he occupied the position I now fill. He omitted to call your attention to some other cases which he tried. I refer to the case tried here a few years ago of a man who struck at another but did not hit him. The assaulted, in stepping back to avoid the blow, tripped and fell, and from that fall was fatally injured. The learned friend on the other side prosecuted and convicted the man who aimed the blow for manslaughter. There was the case of O'Brien, the poor switch-tender who, beyond question, was perfectly innocent of any intent to do harm, with a conscience as pure as virgin snow, yet for a momentary neglect of duty, the train was thrown from the track, a human life destroyed, and O'Brien was tried and convicted of manslaughter. The law sets a high value upon human life. The legislature will hardly change law to suit the learned counsel's notions of his client's cause. This has become quite fashionable of late, where the law pinches your client to go to the legislature and get everybody else pinched so that your client is relieved. Never until now has it been claimed that to establish the crime of manslaughter was it necessary to show an intent to kill. Killing may happen without any intent to do harm. If it happens through indifference, carelessness, or neglect, or in the doing of an unlawful act, or in the doing of a lawful act, in an unlawful manner, it is manslaughter. End of section 54. Section 55 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 6. This sad tragedy had its first scene in one of the beautiful streets of our city. It was a beautiful morning. The town was joyous as the merry sleigh bells were jingling through the streets. Joseph Hebring, a youth, in passing through Cedar Street, peaceably and properly delivering from his wagon meat to his employer's customers, is assaulted with snowballs by the defendant's brother, Joseph Lafon. Counsel for the defendant says Hebring was the aggressor. I say Joseph Lafon was the aggressor. He commenced the affray by throwing snow at Hebring as he passed. He says he stood on the sidewalk and threw snow upon his wagon as he passed through the middle of the street. Stickles says he afterwards threw a snowball and struck Hebring's horse. Then hot words passed between them, and Hebring stopped his horse, jumped from his wagon, and came back to him. Where was Joseph Lafon then? Out in the street. Why did he leave the sidewalk and go out in the street? Was it to dare Hebring to a quarrel? He stood there until Hebring came up. Stickles says Hebring asked, "Why did you throw snowballs at me?" The Allen boy says the same. Lafon replied, "None of your damn business." Mrs. McCormick and Miss Lottie Condit both say then they struck each other blow for blow. They clinched. Joseph Lafon says he caught Hebring around the neck. If he had been so much smaller than Hebring as is alleged, he could not well have taken hold around his neck. They struggle, stumble, and both fall, Hebring on top. Now where was the defendant during this encounter up to this time? Standing at the parlor window looking at the affair. He manifestly saw the whole of it. Joseph Lafon says in his testimony before the coroner's jury that his brother saw him throw the snow at Hebring. Miss Condit says she saw him looking out of the window while the boys were struggling. Miss Searing, from an upper window on the other side of the street, saw him looking out, so that the defendant knew that his brother was the aggressor. Anne had provoked the quarrel, but when he saw his brother getting the worst of it, he then rushed out of the house to punish his adversary. Was Joseph Lafon so much weaker than Joseph Hebring? There was but little if any difference in size. Dr. Dennis said as he saw them struggling together, he thought it was a little boy's quarrel. Was Joseph Hebring a skillful fighter? Counsel says he was trying by his blows to put out Lafon's eye. A skillful fighter. Skillful fighter. Think of that, gentlemen, and call to mind the evidence of his skill. There lay the boys, Lafon on his back, face up, Hebring over him on his knees, his left knee pressing upon Lafon's right hand, holding it down, his left hand holding tight Lafon's left hand, and with nothing in his way, Hebring with his right hand, by blow after blow, hard and heavy, aiming at Lafon's eye, trying to put it out. What hindered him from hitting his eye? Did he hit his eye? Trying to put his eye out, cried counsel, and yet, with all this excellent opportunity, having Lafon at such an advantage, this skillful fighter does not even hit his eye, does not blacken it, does not make the nose bleed, does not raise a mark or make a scratch upon any part of Lafon's face. Lafon in this situation, according to his story, hit in the face before he fell, and a great many times after he fell, and that by a skillful fighter, and not a mark, scratch, or bruise made upon his fair face. Skillful fighting that well up in the art of the ring. Doesn't the bare statement of the facts show the absurdity of counsel's allegation? Oh yes, his cheek was red. Mrs. Hornblower, who came out, saw he had been struck in the cheek because she saw a redness, and she knew he had been struck because it was the same peculiar redness of the cheek which she had noticed in the cheeks of her own boys when they had been struck in the cheek. Isn't that cheeky evidence, gentlemen? I do not wish to say anything unjust against this lady, but when she, a highly respectable person, comes before this jury and tries to prejudice it with her presence, I feel it my duty to characterize her evidence as it deserves, as if all the shoveling and snowballing and struggling would not cause a redness of cheek. And that was the sum of his injuries, a red cheek. Joseph says his cheek was swelled. Nobody else says so. He says his arms and shoulders were lame, but he never told his father, a physician, or Dr. Dennis, who were about the office all that day, of any injuries of face or arms. They never examined his injuries or prescribed for them. All he did for his swelled face was to bathe it in cold water that night as he went to bed, and the next morning it was all right. Had he been like most respectable boys, he would have bathed it in water at noontime and tea-time also. Making out that Joseph Lafon was hurt and that there was an urgent necessity for intervention, so as to prevent the younger Lafon from being killed, was the aim of the defendant's counsel. After the affray, he resumed shoveling snow and was out in the street 3/4 of an hour, relating to different ones what had happened, and then got his cue from his own house, and went over to play croquet with Fred Fish on his table, and the reason he did not play was because Fred Fish didn't want to play. Lame arms indeed. Badly injured boy that. No, Thomas Lafon, seeing all this affray from the beginning, and seeing that his brother was not injured, what was his object in attacking Hebring with a shovel? When he came out, did he ask his brother if he was hurt? Did he tell Hebring to get up, or did he attempt to pull him off or kick him? No, nothing of the sort. He knew his brother was not hurt. He did not stop to help him up after he had beaten Hebring. He left his brother as he found him and ran back in the house. Now, I shall endeavor to show, first, that the defendant's object was not to protect his brother. Second, it was to punish Hebring, and third, in doing so, he used unlawful means. Now, if I succeed in maintaining either of these propositions, which I propose to discuss together, then the defendant is guilty of manslaughter. Both of the lads who were engaged in the quarrel at the time of his interference were blamable, and Thomas Lafon knew it. Now, did Thomas come out to lift his brother up and see fair play? No, he came out, rushed into the street, picked up the shovel, and struck the fatal blow. I do not deny that it is the duty of a brother to defend either a brother or sister from his honor or from imminent peril, but this is no such case. Counsel says, why did he not hit him with the blade, the edge of the blade, if he meant to kill him? Witnesses differ as to the part of the shovel, but I think he was struck with the handle. Why, gentlemen, if he had struck with the edge of the blade, the shovel would then have been a deadly weapon, and in law there would have been much malice manifested in that act, that he should have been indicted for, and now be on trial for murder in the first degree. But they say he did not mean to hit him on the head. When the last blow was struck, the contest between the boys was certainly at an end, and Lafon had no right to hit him at all. Suppose he did not mean to hit his head. If he struck heedlessly, recklessly, and willfully a fatal blow, is he not guilty? The manner in which he struck is proof that he meant harm. All the blows were struck about the head. They were heavy blows, given in quick succession, and when Hebring looked at him and eye met eye, he meant to hit him on the head. But whether he did or did not is of very little consequence under this indictment. That he struck him and by the blow caused his death is not denied. That he did this without right or law is my claim. The blows were all heavy, qualified by the witnesses, it is true, as rather heavy, pretty severe, hard blows, except Miss Searing. She thought Hebring was making believe, heard his groans, saw the blood from his ear, saw him attempt to rise and fall again and again, and thought he was making believe. Oh, I am sorry. Sympathy goes far. Miss Anna Poor, looking through a second-story window of the adjoining house, Dr. Dennis's room, she is a sister of Mrs. Dennis, saw the upraised shovel 3 times, but could not see what it struck, but she heard the blows. The first 2 sounded like something striking heavy, and the last like striking the sidewalk. This was in the morning, the streets noisy with the humdrum of busy life, and she heard this some distance, through a closed window. Joseph Lafon said the last blow sounded like striking hardwood. Talk about thin skulls. Men of common sense know that shovel in the hands of a man accustomed to farm life brought down upon a lad's head so hard that the blow could be heard in the closed second story of an adjoining house, and sound like hitting a sidewalk would break the thickest skull. We do not need experts to tell us about thin skulls. Medical books are of little worth. The facts are stronger than opinions or theories. The fracture, what a fracture! It runs down the temporal bone. The momentum carried it through the solid ear bone, one of the firmest in the body, according to Dr. Laibach, and this solid bone, 2.5 inches thick, was cracked through. Now, this bone turned across the temporal must act like a knot. The blow must have been very heavy that would split this knotty bone. The sight of the affair was alarming even to the colored boy Talmadge, who was probably accustomed to hard sights. He could not stop and see more of this thing. He drove on. The people in the streets are alarmed with his distressing cries. The ladies who witnessed it are filled with consternation, but the defendant is unconcerned. His ears are deaf to the cries of distress. He has accomplished his purpose. He has punished his victim and gone back into the house. He can stand at the window and look out upon that poor boy, bloody from his cruelty, but he has no hand to help him whom he has crushed. Call it accident. Why does not he come out? What is he? Is Thomas Lafon sacred and Joseph Hebring the opposite? Why does he not rush to the assistance of poor Hebring? Oh, talk to me about accident. Why, gentlemen, if he had not intended to do just what he did do, when he saw that he had hit him on the head and done him great harm, he would have fallen upon the poor boy's neck and asked him forgiveness. He would, with many tears, have lifted him up. He would have told him, my dear boy, I am sorry I have hurt you. I hope you are not much hurt. I will do all I can for you. Let me help you. No place in his father's house would have been too good for him. Would not that have been human nature if this was an accident? But instead he leaves him upon the cold sidewalk to moan and cry, and strangers come to his aid. And even now, when they would carry him up the wide front steps to his father's office in the rear of the parlors, they are met at the door as they ascend the steps and told to take him back and down the narrow basement steps, into the narrow area way to the basement door. Gentlemen, the intention of the defendant is to be gathered from his acts and words at the time and immediately after the occurrence. I dwell upon these things that we may understand his intent. True, he has been hurt by my son. He has just told me about it, but take him down to the basement. We have just cleaned this part of the house. The Saturday cleaning has been done. The house must not be soiled. He is only a market boy. Mrs. Lafon says Thomas was helping him up the steps when she told them to take him down into the basement. She is mistaken. The evidence is that Stickles and a stranger helped him. Thomas did not go out. She might have thought so, but he did no such thing. All the neighborhood had been alarmed before the boy was taken in. If he had no intention of doing grievous harm, why did he not drop the shovel and at once extend his aid? I asked Dr. Stearns if that would not have been the prompting of a Christian heart. Well, he was taken into the basement and his head examined. Now I am bound to talk plain. Dr. Lafon is my friend, as Stephen Hebring is my learned opponent's friend. I do not desire to wound my friend's feelings, but I must do my duty. Oh, there was such a coldness about this affair, such a heartlessness, such cruelty. What was the purpose of Thomas Lafon, I ask again, in giving these blows? When he had knocked Hebring in the head, did he stop to ask his brother if he was hurt? No. Did he offer to help his brother? No. But he had injured Hebring, and that was his intent. Counsel says Thomas wanted to equalize the power, that he had a right to equalize the powers. Equalize the power indeed. 2 lads of about the same size are engaged in a street quarrel, and a young man larger than either, weighing nearly as much as both, comes along and attacks one of them from behind with a shovel to equalize the power. That may be a good proposition for natural philosophy, but there is no room in the law or in common sense for such an absurdity. And when the injured boy was taken into the basement, what feeling, sympathy or sorrow, did he manifest? Did he tell his mother it was an accident? Did he tell her or anybody that he did not mean to hit him on the head? But he did say to Dr. Dennis as he came into the basement, "Here is a boy badly hurt." Did he say accidentally hurt? Would he not have said so if it had been true right then and there when the blood of the moaning boy was dripping warm and fresh from his ear, there in the presence of his mother and the doctor? Then what did he do? What did they, this household, do to help this boy injured by accident, as they now say? Did any of them believe or even think then that there was any accident about it? George Burgesser comes, sent by Mr. Bathgate, to learn the condition of his comrade. He sees blood upon the sidewalk. He hears his groans and sees his drooping head through the basement window, but he is not allowed admittance. Returning the second time with more positive commands from his employer, he again seeks admission, and they say he came boisterously. 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 Why, he is naturally excited. He feels, if no one else about that house does, for the fate of his young friend and fellow workman. He fears, from the terrible evidence he has seen, the worst has befallen him. He came boisterously. Oh, gentlemen, is this a time to stand on etiquette? Is this a time to ask for bows and scrapes and flexions and genuflections and good morning salutes before you can be allowed to aid the suffering one? See here an example of the liveliest regard for good manners smothering heartless attention to suffering. Why care for Burgesser's manner? He feels, he sees, he hears excitedly. Perhaps he asks if he can take him away. Is he able to go? Yes, take him. Get him out of here as quick as possible. Thomas says he is badly hurt. The doctor sees he is wounded, but how or where he knows not, and seems not able to ascertain, but the blood flowing from his ear should have been evidence to him, a physician, that the blow upon the head with the shovel, which he saw lifted high in the air but a few minutes before, that the injury was serious. He said he must be warmed at once, and yet they allow him to be carried out into the cold, and that to the very coldest and most uncomfortable place for an injured person in the whole city, the Center Market. What chance for attention there? How can he be warmed in that cheerless place with cold draughts from every direction? But take him out, take him away from here. I, Thomas Lafon, have wounded him, they now say by accident, but there is no room for him here, no comfortable bed or lounge or warm stove or heated brick. No, not here. He says he has a mother. Why could he not stay there a little while in the basement? It wouldn't soil it much, and send for his poor mother. No, he can't stay here. Take him out, and Thomas Lafon, assisted by George Burgesser, carried him out, tumbled him into the cart with the cold, dead meat the poor boy has not yet delivered. He is only a butcher boy, and Dr. Dennis lets him go without the care of a physician. Why couldn't he go and see him safely lodged in some warm place, which he says he above all needs? Oh, gentlemen, if this were a son of mine or a son of yours, would not charity dictate that he be left a while? Why not care for him tenderly and send for his mother or someone who loves him? Was this an act of Christian charity and amiable loving-kindness, of which we have heard so much in this trial? An accident, and treat humanity thus. An accident! Did Hebring receive that care as if injured by accident? About the same as would have been bestowed upon a wounded dog. Oh, Christian charity, amiableness of temper, don't let us hear any more of it in this case. Well, Thomas drives the meat wagon over to the market, and George Burgesser supports the wounded Hebring. What did Thomas on the way say to George Burgesser? That he was sorry he did not mean to hit him so hard, or that he accidentally hit him upon the head? No, nothing of that sort. I wasn't going to see my brother licked. I didn't want to see my brother getting beat of him. A German mode of expression, and that is all he said. Then we come to the market. Here Thomas has another opportunity of explaining himself. Does he say or intimate to Bathgate that he hurt him by a misblow or unintentionally? Not at all. He says to Bathgate, I hit him with a shovel. I did it, and I am responsible for it. You would hardly expect this of me. And when Bathgate importunes with him to take him back to his house and make him comfortable there for the present, he refused, and insisted upon taking him home in the meat wagon. Many people in this town knew Joseph Hebring, and it is no wonder that Mr. Bathgate told Thomas to get a carriage and take him home, and not allow him to be tumbled about in a meat cart. Then it is intimated to him that he would be arrested, and he replied he might go to the station house himself. Why didn't he say, this is an accident, I didn't mean it, I have committed no crime? I tell you, gentlemen, this idea of misadventure was not then thought of, not until counsel had been seen, and their learning and ingenuity was put to the rack to devise a defense based upon the seemings of some of the witnesses to the occurrence. Dr. Dougherty is called. He pronounces the boy seriously injured, advises him to be taken where he can be warmed at once. Thomas Lafon brings a hack, and he and the doctor proceed to take poor Hebring home. Again, does the defendant have another opportunity? Remember, gentlemen, we are seeking after intent on the part of this defendant, the quo animo of the deed. They say accident, we say intent, on the way he speaks to Dr. Dougherty. I know you will think it a beastly thing or brutal thing to do. I saw him on my little brother, and I went to get him off. Significant words. How they throw light as from a blazing sun upon this sad tragedy. The doctor had given him to understand the injury was serious. He appeared to be sorry and apprehensive, but the way he conveyed the idea of sorrow to the doctor's mind, as he says, was by his showing alarm. He had just heard the words at the market, arrest. Now he begins to feel alarm, but is there in any expression to the doctor, or in his manifestation of alarm, any intimation that he did not mean the blow upon the head? His own conscience characterizes the act as beastly or brutal. It was brutal, cruel in the extreme, and now the scene in this terrible tragedy changes again. The defendant bearing the victim of his brutality is confronted with Hebring's mother. At the door of her house she sees the defendant and the doctor aiding her dear boy. He is laid upon the lounge, the doctor gives necessary directions, and there stays the defendant for half or 3/4 of an hour. And during all this time he has another opportunity to explain. Does he? He talked with the mother. Did he tell her, I injured your boy by accident. I am very sorry. I will do all I can for him. Let me know what you want, and you shall have it? No words of hope, cheer, or consolation, or sympathy. He asked a question pregnant with meaning. How many children have you got? As if he knew she would soon have one less this side of the eternal gate. How many children have you got? This community asks today of this afflicted woman, how many children have you now? And where is your bright, promising Joseph? And I ask of this defendant, where is Joseph Hebring? Counsel says he was protecting his brother, and God expects a brother to protect his brother, for he asked Cain, where is thy brother Abel? Be it so, gentlemen of the jury. Cain and Abel were early representatives of the human race. Brother in this connection has a deeper, wider meaning than that of near blood ties. It is brother in the sense that we are all children of one common Father, and in this sense God has asked every Cain or manslayer from that day to this, where is thy brother? And God asks today of Thomas Lafon, where is thy brother Joseph Hebring? Call this brutal deed accident. Accident. Then strike brutal and cruel out of the language as obsolete words and use accidental instead. So much for that branch of the defense by misadventure or accident. Now, by his counsel, he asked this jury to justify him on the grounds that he had a right to defend his brother, and that he was only doing that. If it was right for the defendant to defend his brother, as I concede it was to do it, there was a right way and a wrong way. He took the wrong way. Just as in the case referred to of the falling house, there was a right way to prop it up and a wrong way. The builder took the wrong way, a child was killed, and it was held manslaughter. His learned counsel account for his cold and unfeeling manner after the affray, on the ground that he is a doctor's son, and used to such things. They feel the smart and apply such a plaster. I leave that explanation hardly worthy of my learned friend with you, gentlemen, for what it is worth. But I would like to ask Dr. Stearns or Dr. Poore, who have taken such deep interest in this trial, if they or either of them think it right for one of their parishioners to exercise his furious temper, which they call amiable, as the defendant is proved to have done in this case, strike repeatedly in heavy blows, about and upon the head, prostrate him upon the sidewalk, and leave him there seriously wounded, without a care. Didn't he have an evil heart when he struck those blows? Talk about moral guilt. Was not moral guilt there? All the provocation that Thomas Lafon had was that his brother was fighting with Joseph Hebring, and as he knew how the fight commenced and had seen its progress from the beginning, there should have been little in it to provoke him to this rash and cruel deed. He did not have the same provocation which his brother had. If his brother, while lying upon the sidewalk, had seized some instrument and with it given Hebring a mortal wound, Joseph Lafon would have been guilty of manslaughter, clearly so. Thomas certainly cannot escape the consequences which would have befallen his brother had he killed Hebring. End of section 55. Section 56 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 7. The learned counsel on the other side would have us believe that the defendant had no malice in what he did. Why, gentlemen, is it not necessary that malice should be proved to maintain the offense of manslaughter? This indictment is not founded upon malice. If malice appeared in the acts of the defendant, he might have been indicted for murder. It is not urged on the part of the state that he committed this deed maliciously for the purpose of maintaining this charge, but the character of the deed has been inquired into to ascertain the motive of the defendant. Malice divides murder from manslaughter. I here submit to you, as I did in the opening of this cause, if it was not a merciful grand jury that found this indictment, take the facts as they stand proved before you, and tell me, did not the grand jury give this defendant the benefit of all the doubts he can reasonably ask in finding this indictment for manslaughter rather than murder? And though it may appear upon the evidence that he had malice in his heart, he can now be convicted of manslaughter only. I ask you now, gentlemen of the jury, what was the object of the defendant when he struck these blows? Was it to protect his brother or punish Joseph Hebring? Was there such an urgent necessity even appearing to him as he looked from the window as to justify him in the seizing of this weapon and using it in the brutal manner proved? It has been somewhat difficult for me to understand what counsel for defense, with their great learning and ability, have aimed at or relied upon for an acquittal. At one time they say it was an accident, a misadventure, then they jump that defense and say defendant was justified because a brother has a right to protect a brother, and intimate, they have hardly dared to say it, that Joseph Lafon was in such imminent danger that Thomas had a right to use the shovel and beat off his assailant with deadly blows. Human life has never been held so cheaply as this in New Jersey. Joseph Lafon was not hurt or scratched even by this encounter. Their attempt to prove injuries utterly failed. This stout defendant, hardened and strengthened in muscle by his farm life in Missouri, could easily have pulled off Hebring and tossed him in the middle of the street. If protection alone had been his object, this he would have done and not tried to beat out his life. I submit, therefore, in all candor, that the propositions with which I started upon this argument are wholly supported by the proof. That is, the defendant's object and intention was, first, negatively, not to protect his brother. Second, affirmatively, it was to punish Hebring. And in the third place, that he used unlawful means, and his manner of interference was unlawful. He should therefore be held responsible for the consequences of his acts. They tell us his character has always been good, and ministers and doctors and lawyers have been called to testify to his peaceableness and good temper. With all their opinions of his high character, the facts in this case are not obscure. One not of a quick and ungovernable temper, of strong passions easily excited, would never have struck those horrible blows. And after all, they knew very little about him of late. For several years he has been away from home, and the most of them have seen little or nothing of him. He may not have shown much violence of temper among his companions in earlier years, or in the presence of his pastor, who has great kindness of heart, aye, kindness to a fault, as is manifested by his interest in this trial. He doubtless thinks the defendant free from guilt, and strange it is, with such facts before him, his head seems buried for the time in his heart. This occasion called out temper in the defendant, the evidence is clear, and though he may never have allowed it to carry him so far before, that can be no defense upon this charge. Now, as to the defense that he was justified, homicide is justifiable only when it is impossible for the one attacked to retreat further and the danger is imminent. Joseph Lafon, by falling to the ground, did not retreat to the wall and could have made further resistance. In homicide by misadventure, there must be no intention to commit bodily harm. There was brutality in this attack upon Hebring that no law can excuse or justify. Then such a cruel, cold, heartless treatment of the poor boy after the injuries were inflicted. What says that good Christian poet, Cowper? I would not enter on my list of friends, though graced with polished manners and fine sense, yet wanting sensibility, the man who needlessly sets foot upon a worm. And again he uses these appropriate words. The springtime of our years is soon dishonored and defiled in most by budding ills that ask a prudent hand to check them. But alas, none sooner shoots, if unrestrained, into luxuriant growth, than cruelty most devilish of them all. Mercy to him that shows it is the rule and righteous limitation of its act, by which heaven moves in pardoning guilty man, and that he shows none, being ripe in years and conscious of the outrage he commits, shall seek it and not find it in his turn. But I must not weary your patience further. In conclusion, I wish to call your attention to one or two matters made necessary by the appeal of the learned counsel for the defense. I confess to a fear of their power. They have brought their great learning abilities and matchless eloquence into requisition to acquit this defendant from the charge laid against him. I have sought to lay the case before you with some care. As God is my judge, I have been impelled only by a solemn sense of duty. I would that this defendant could be relieved from the consequence of his crime, but the security of the state, the protection of the people, forbids it. Courts are established to protect communities. The fountains of justice must not be choked by sympathy. The defendant, they say, has been reared with religious care. It may be so. I am not here to send grief to the hearts of his parents, but to ask for simple justice. Deliberate a moment on this one thought. If Joseph Hebring was in Thomas Lafon's position, and the latter were, I hope, young Hebring is, in heaven, what would these parents and these sympathizing friends say then? Has not the law been violated? And though ever so well nurtured, should he not be treated as the law treats all? Courts of justice cannot afford to respect persons. You remember what Moses said to all Israel on this side Jordan in the wilderness. Hear the causes between your brethren, and judge righteously between every man and his brother, and the stranger that is with him. Ye shall not respect persons in judgment, but you shall hear the small as well as the great. You shall not be afraid of the face of man, for the judgment is God's. Thus judge all aright. I appeal to you on behalf of the people of this county. Because a man has always appeared respectable, it does not follow that he should not be held guilty of crime fully proved against him. Can the defendant say to you that because he has been reared in the lap of luxury and had every advantage of society, schools, and church, that he should not abide the consequence of his misdeeds? You cannot recall the lad upon whose growing strength his parents depended for support in their declining years. And although we are not here for revenge, you may do something by your verdict to protect others in our midst from a like sorrow. You can set up a beacon light as a warning to the wayward. If the actors had been reversed, would your duty have been different? Oh, no. Let this poor mother, who has sat here alone in her dark weeds of mourning, know that justice will be done. Let this community know that you will do justice. I know you are moved with sympathy, but I know you are men actuated by high and honorable purposes and will dare do your duty. This man should be tried and judged as are all others arraigned before this bar. Let there be no distinctions. It is our boast to say that in our courts of justice all stand alike, the rich and the poor, the native and the foreign-born. Let it be shown that it is true, so that we may continue to enjoy the reputation we have heretofore so well merited. And here let me say that this reputation has been largely owing to the great power and unbending integrity of my learned friend on the other side, who so ardently opposes me in this case when he stood for 10 years in my place. Where would we drift to if the courts are partial in their judgments? If this man has done wrong, let your verdict convict him. You are asked by counsel on the other side if you would have his locks shorn, and prison garb thrown upon his person, and he forced into a felon's cell, to consider the effect of your verdict against him in this regard. Gentlemen of the jury, were you sworn to do that? The facts and the law are our guides, not consequences. With consequences, I, as prosecutor, and you, as jurymen, have nothing to do. The judgment of the law upon a verdict of guilty will be for the very learned and conscientious judge, and his honorable associates upon the bench to pronounce. That part of this case is not ours to perform or even to consider, and it may be left to them safely, for they are just men. But counsel asks, will you shut him in an ignominious place where sin alone enters? I answer yes, yes, 1,000 times yes, rather than that he, if guilty, should be acquitted because he is Dr. Lafon's son. Will you say that violence in our streets, such as this, shall go unwhipped of justice? What dire disasters may befall us if such conduct is to be justified by jurors? I only ask for justice in this case, as in all other cases. It is sought by the prosecution, nothing more is asked, nothing less will satisfy. Let all know that here the poor is as strong as the rich, and he who has no friends as strong as he who has many. The law is the same for all classes and all nationalities. The Americans, the Germans, the Irishman, the Italian, the Frenchman, and the inhabitants of the islands of the sea in this court, all stand upon one common level. So it has been, so may it ever be and shall be, so far as my feeble efforts can tend in that direction. I know with what power I have been opposed, but facts are stronger than theories. Justice is stronger than eloquence, and duty is stronger than sympathy. When I am called to pity the criminal, said that eminent Christian Chief Justice Hale, I remember that there is a pity due to the people. I would that this defendant had shown some defense by which you would have been justified in a verdict of acquittal, but he has not. Deliberate upon this case with calmness and candor, take the facts as they have been put in evidence before you, and the law as his honor shall declare it to be, and consider seriously without sympathy or prejudice. And may God bless you and keep you, and direct you aright, and enable you so to discharge your solemn duty that the people will say faithful. Your own consciences will say faithful, and the judge upon the great white throne will say, as you finally enter up yonder, faithful. The judge's charge. Judge Depew. The defendant is on trial upon an indictment charging him with manslaughter in causing the death of one Joseph Hebring, that the deceased died on the 11th day of December last, and that he died of a certain wound upon the head inflicted by the hands of the defendant on the morning of the 5th day of the same December, are facts proved in the case which are not controverted by the defense. The defense consists not in denying the commission of the act or that fatal consequences resulted from it, but in the denial that the defendant has incurred any legal liability from the homicide. The indictment is in form an indictment for manslaughter, the lowest grade of homicide which is attended with criminal responsibility. And while under an indictment for manslaughter, a conviction may be had for a common assault and battery, because the latter offense is technically included in the former, yet a jury upon the traverse of an indictment for manslaughter is justified in convicting of the lower offense only when it does not appear that death resulted from the force which was used. In this case, that death resulted from the act of the defendant is not disputed, and if the jury convict at all, their verdict should be guilty in manner and form as charged. Under the facts proved in the case, the defendant is either guilty of manslaughter or he is not guilty of any criminal act whatever, and is entitled to a verdict of acquittal. The defense is based upon the doctrine applicable to homicide by misadventure. As a starting point in this case, it will be useful to consider the principles applicable to this grade of homicide when misadventure is made a substantive defense to an indictment for manslaughter. Homicide by misadventure is where one without intention of bodily harm and with all proper precautions against danger while doing a lawful act unfortunately kills another. For a homicide resulting from such misadventure, no criminal liability is incurred. But to constitute this defense, 3 requisitions must exist. 1. There must have been no intention to do harm. 2. Proper precaution must have been taken to avoid mischief. 3. The act in the doing of which death resulted must have been in itself a lawful act. If the intention was to do any bodily harm, or the act in the doing of which death happens was an unlawful act, then, if death unexpectedly follows as a consequence of the act, the party is involved in criminal responsibility for the death which ensued, though no such consequences were apprehended by him at the time of doing the act. Obviously, under the evidence in this cause, the defendant is not to be excused because of the death having unexpectedly followed as a consequence of his act. His defense must consist in its being established to your satisfaction that he was justified in the assault which he committed upon the deceased, and that the act in the doing of which death resulted was in itself a lawful act. That defense has been attempted to be made by the defendant, and it consists in insisting that he was justified in interfering in the contest between the deceased and his brother, and in using the force which he employed against the deceased. This defense does not fall under that branch of criminal law which is denominated excusable homicide by reason of self-defense, but is to be judged by those principles of criminal irresponsibility which are applicable to that species of justifiable homicide which arises when the act is done in the preservation of the public peace. The distinction between these 2 classes of defense is not always observed. Illustrations for either are frequently drawn from both indiscriminately, but the origin and nature of each are different, and in civil actions by the rules of pleading the distinction is carefully preserved. End of section 56. Section 57 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Lafon, Jr. for the killing of Joseph Hebring, Newark, New Jersey, 1869, Part 8. The right of self-defense is one of the natural rights of persons, existing in the individual prior to the organization of society and independent of its laws. It is extended to such as bear to each reciprocally the relations of parent and child, guardian and ward, husband and wife, and master and servant, because of the obligation of protection growing out of their relations. The right to interfere for the preservation of the public peace is a right which pertains to the citizen, springing from his obligations to the law and his right, as a member of society, to maintain the public peace and prevent the commission of crime. In some cases, the distinction is important. If this case under an indictment for manslaughter, the distinction is entirely unimportant. But whatever be the origin or foundation of this right, it is carefully guarded by qualifications and restrictions, and the stranger to the combat, who interferes and steps beyond these qualifications and restrictions, becomes involved in a criminal responsibility for the consequences of his act, and if death ensues from his act of interference, the law, from its regard for human life, holds him to a strict accountability. The conditions to a justification of this character are these: 1. That the motive for interfering was a laudable and proper motive, and not for the purpose of engaging in an affray, and 2. That in this prosecution of his purpose the force which he used was appropriate to the prevention of bodily harm, and was not carried beyond the bounds of what was reasonably necessary to that end. If the defense fails in either of these particulars, either as to the motive for interference or the extent to which such interference was carried, the defendant should be convicted. And first, as to the motive for interference. In this branch of the case, the relations existing between the defendant and the person with whom the deceased was engaged in a contest, and the extent to which he was informed of the merits of the controversy, have an important bearing. In the language of an authority read in your hearing, 1 EP, page 292, the nearer or more remote connection of the parties with each other seems more a matter of observation to the jury as to the probable force of the provocation, and the motive which induced the interference of a third person, than as furnishing any precise rule of law grounded on such a distinction. It is said that strangers interfering in a mutual combat or in behalf of another must use great caution, and that before their interference is actual they should make known the purpose of their interposition. That principle does not apply in this case. The natural instincts of the defendant would prompt him at once to fly to the aid of his brother, whom he saw worsted in the scuffle. The motive of the defendant in interfering was natural, and if it was not on his own account to join in the affray to punish the deceased, was justifiable. But that does not make perfect his defense. His conduct while interposing must have been such as to justify the acts he did in the prosecution of his interference. The assailant, as well as the assaulted, was under the protection of the law. It is in the second condition to the perfection of this defense that the burden in this case chiefly lies. Was the force used appropriate to effectuate the preservation of his brother by rescuing him from his assailant or shielding him from injury? And was it confined within the limits of what was necessary to secure that protection? Directing your attention to the distinction between murder and manslaughter will aid you in comprehending the exact bearing of this, the essential part of the defense, upon the indictment on which the accused is upon trial. If the intention be to take life or inflict grievous bodily injury, the offense is murder either in the first or second degree. If the intent does not extend to the intention to take life or to inflict great bodily injury, but was to commit a mere assault and battery upon the person of the deceased, if death ensues, the offense is manslaughter. The defendant is on trial on a charge of manslaughter. The distinction to be observed is between provocation and justification. Provocation will, in some cases, mitigate the crime from murder to manslaughter. Nothing short of a justification by maintaining that the act done was in itself a lawful act will absolve the accused from the charge of manslaughter. In a book of acknowledged authority, the rule is stated accurately as follows. In general, where an involuntary killing happens in consequence of an unlawful act, it will be either murder or manslaughter according to the nature of the act which occasioned it. If it be in prosecution of a felonious intent, or in its consequences naturally tended to bloodshed, it will be murder. But if no more was intended than a mere civil trespass, it is manslaughter. Wharton's Homicide, page 36. The subject being considered by the author with reference to which these remarks are made is that of involuntary manslaughter, where death unexpectedly results from the act of the accused, the precise question which is involved in this case. You will perceive from the extract I have read that in order to a conviction, it is not necessary that the state should satisfy you that the fatal blow was purposely delivered on a vital part where it was likely to be attended with dangerous consequences, with an intent to cause a grievous injury. It is sufficient that you should be satisfied that the purpose of the accused was to commit a trespass on the person of the deceased. If you are satisfied that his intent was to commit a trespass, then the merits of the defense must consist in satisfying you that he was justified in committing the trespass, the assault and battery he committed on the person of the deceased. Whether the attentions to the deceased after the injury were such as they should have been is of no importance in this case, except so far as it relates to the conduct of the accused, as bearing on the question of his intent in committing the assault. He was not the master of the premises. The case stands on the question of justification. These facts appear not to be disputed, that on the morning in question Joseph Lafon, the brother of the accused, and the deceased became engaged in a personal altercation, that Joseph was thrown upon the sidewalk and was lying there with the deceased on or over him, and that the accused hurried from his father's house to the place where the parties were, and without one word of expostulation, or any effort to disengage the parties, proceeded to deliver on the person of the deceased 3 blows with a shovel he had picked up by the way in quick succession, from the last of which death ensued. Were these blows justified as being necessary to the preservation of the public peace, or the protection of Joseph from the assault that was being made upon him? The testimony bearing on this subject is quite conflicting, and therefore I do not refer to it in detail. Briefly, it relates to the following points. 1. The character of the assault, which was then being committed on Joseph by the deceased, as evidenced by the degree of force he was at that time actually applying, and the nature and extent of the injury, whether slight or otherwise, sustained by Joseph as exhibited by the appearance of his person after the occurrence, and his personal suffering from any injuries he may have received at the hands of the deceased, and the comparative size of the 2 persons who were in the altercation. 2. The manner in which the blows given by the accused were inflicted, the force which was used, and the manner in which the shovel was held. On this point as to the force, you have the descriptions of the eyewitnesses, the testimony of Doctors Doherty and Lobach, and the effects on the person of the deceased. The weight of the evidence is that the accused struck with the handle of the shovel and not with the blade. Was the occasion so urgent that the accused was justified in at once resorting to the force he used, and was the danger so imminent that the blows given were proportioned to the urgency of the attack? Was he exercising a lawful right in a lawful manner, or did he participate with the intent to assault the deceased for the purpose of inflicting punishment on the deceased? The part of the person at which the blows were aimed and upon which they were intended to have been delivered is not to be overlooked by the jury in passing upon the question as to whether the force used was excessive and beyond what was reasonable and lawful under all the circumstances of the case. As I have already said, the fact that the death unexpectedly resulted from his act will not of itself relieve the accused from the consequences of his act. But when the question is whether the act is a lawful act because of the exigencies of the occasion, the nature of the weapon used, and the part of the body at which it was aimed become matters of importance. If a man uses a weapon likely to cause serious bodily injury upon the person of another, if by misadventure it alights on a vital part and death ensues, he is liable for all the consequences resulting from the act. If the accused used the weapon intentionally upon a vital part, or if he intentionally used a weapon likely to be attended with serious consequences, he must be held to be responsible for all the consequences of his act, though he apprehended no such consequences at the time of delivering the fatal blow. In that case, the offense would be murder, at least in the 2nd degree. The element of misadventure and the consequences resulting from the act is entitled to just this effect in this cause. If the weapon used under all circumstances when used upon the person of another was not likely to be attended with serious consequences, that circumstance is entitled to a careful consideration by the jury, under an indictment for manslaughter in causing death in the use of such weapon in measuring the amount of force to be justified in repelling the force of the deceased. In other words, the justification must be the extent of justifying the act intended to be done and the use of the weapon he intentionally used. The question is not solely one of intent. If a person uses a weapon likely to occasion great bodily injury, he must be responsible for the consequences resulting, although he did not intend that result. If a person, either in the interposition for the rescue of a third person or in self-defense, uses merely his hands and by misadventure death ensues, The question of his justification is to be considered in the light of the means of offense used and the part of the person on which those means of offense were intentionally applied. So if he uses a weapon which, when used on any part of the person, is likely to occasion serious injury, he is responsible, though undesignedly or by misadventure. The blow was received on a vital part of the person whereby death unexpectedly resulted. I repeat that in the justification of the assault committed on the deceased, the justification must be coextensive with the act intended to be done and character of the weapon intentionally used. If you find that in these respects the defendant was justified, that is, in the act he intended to do and the weapon he used, excuse for the unexpected result will follow from that justification if the accused is free from all blame as to the manner in which he used the weapon. On these points, gentlemen, you ought to be entirely satisfied. If a person doing an act entirely lawful employs means likely to be attended with dangerous consequences to others, he is held to the exercise of due care. It would never do to visit upon the sufferer the consequences of an unforeseen and unexpected result, and hold him alone responsible for the unexpected consequences resulted from the means adopted by his assailant. The party employing means which may occasion such dangerous consequences must himself be free from all blame for such unforeseen and unexpected consequences. Was the fatal blow intended to be delivered on the head of the deceased, or did the deceased, by shifting his position, receive on his head a blow aimed at his back? You have the testimony of several witnesses on this point. You have also the fact introduced that the blows were delivered in quick succession. It is for you, gentlemen, to determine from the evidence whether the accused continued to repeat the blows on the back of the deceased, or whether he shifted the point of attack from the back to the head, and the deceased, by simply inclining his head on one side, received the blow on the temple. If you conclude from the evidence that the blow was not aimed at the head, then it will be a matter for consideration whether the instrument used was a dangerous instrument. To constitute a dangerous instrument, it is not necessary that it should be a knife or a sword or a gun. A club, a cart rung, or any instrument capable of inflicting severe personal injuries is a dangerous instrument. Whether the instrument used in this case was a dangerous instrument is a question for the jury in the view of the injuries capable of being caused by it and the manner in which it was used. After you have determined these controverted questions of fact, then, gentlemen, turn your attention to the consideration whether the acts done by the accused were lawful acts, whether they were justified in the preservation of the public peace, in the protection of the person of one who was assaulted by another from the violence of his assailant, either in their adaptedness to that purpose or in the extent to which the force applied was carried. On this subject, when the taking of life has resulted, you ought to be entirely satisfied that the grounds upon which you proceed are grounds upon which the peace and good order of the community may safely rest. It is said in judging of this question, you are to have regard to the condition of things as they reasonably seemed to the accused at the time, rather than as they actually were. On this subject, I adopt the remarks of a judge in a neighboring state in construing a statute which I think correctly defines the law on this subject. Quote, "It is argued, however, that if the prisoner did apprehend a design on the part of Brush to do him some great personal injury, and believed he was in great danger, he had then a right to act upon that belief and take the life of Brush, although there was no actual imminent danger. In other words, if he believed in the danger, he had a right to act as though the danger was actually present and the injury about to be inflicted upon him, and that the consequences of this mistaken belief must fall upon the deceased, and the prisoner must, in the eye of the law, stand entirely justified. Several particulars are to be noticed in this section as applicable to the present case. The homicide, if justifiable, must have been committed in the lawful defense of the person of the prisoner at a time when there was reasonable ground to apprehend a design to do him some great personal injury. Who is to judge of the reasonable ground to apprehend a design to do injury? The grounds must be made to appear on the trial, and the jury must be satisfied that they were reasonable grounds upon which to found an apprehension of a design to commit the felony or to do some great personal injury. It is true the party assailed must at the time judge of the ground for his apprehension, but he judges and decides at his peril, so far as the question of entire justification is concerned. It will not do to hold that he who has taken the life of another is entirely justifiable when he acts upon unreasonable grounds of apprehension, though he may have acted upon an honest apprehension of a design on the part of the person killed to commit a felony or to do him some great bodily injury. In such a case, the crime might be only manslaughter, and that too of the lowest degree, but to justify the act of killing in such a case would be to establish a ruling for the security of human life, resting upon the uncertain apprehension of men who may act upon unreasonable and improbable grounds." End quote. Wharton on Criminal Law, page 1027. You were to be satisfied from the evidence in this cause as to existence of the facts necessary to amount to a reasonable apprehension of danger sufficient to justify an interference, as well as the adaptedness of the force used to a lawful purpose, and whether it was confined within reasonable and proper limits. The means of exercising your judgment on these subjects are to be obtained from the evidence in this case. These are questions which may safely be left in the hands of an intelligent, impartial jury. I need scarcely remind you of the importance of this cause. The charge against the accused is that of having caused the death of a fellow being. The act from which death resulted is admitted. The law is tender of human life, and while it mercifully graduates the degrees of criminal responsibility according to the degrees of the guilt of the accused, it never entirely absolves the party by whose hands death results, unless the act from which such fatal consequences ensued was a lawful act. If the accused has incurred no legal responsibility because of the lawfulness of the act which occasioned the death of another, he is entitled to your verdict. The law requires no sacrifice. Before arriving at a conclusion either way, you should carefully scrutinize the evidence in this cause. The defendant has taken the law in his own hands. Nothing but necessity will justify him in doing so, and you have a right to hold him to a strict accountability for the manner in which he administered it. Was the occasion so urgent or the danger so imminent that he was justified in immediately resorting to the force he used, without first resorting to less violent means to accomplish his object? If it was not, or if he carried the force beyond what was reasonably necessary for the accomplishment of a lawful purpose, he should be convicted upon this indictment. The verdict of this jury will be a precedent of no inconsiderable magnitude in this community. The verdict and sentence. The jury retired, and after an absence of 4 hours returned with a verdict guilty, but we earnestly recommend the prisoner to the mercy of the court. The court sentenced the prisoner to pay a fine of $500 and to be confined in the state prison at hard labor for 1 year. End of section 57.
Section 58 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4, by John D. Lawson. Trial of James W. Lent for assault and battery, New York City, 1819. The narrative. One day, a leading criminal lawyer of New York City went to the city prison to see a client. When the jailer was told his errand, he asked the lawyer for a tip before he let him into the cell, and when he was refused, was quite angry. He took his revenge by not coming to open the door when the lawyer was through, and so he had to remain there until he was able to make himself heard by persons outside, who came to his rescue and told the jailer to open the door. The jailer was indicted for assault and battery, convicted and fined, his plea that he had forgotten being held by the court to be no excuse. The trial. In the Court of General Sessions, New York City, April 1819. Honorable Cadwallader D. Golden, Mayor. April 5th. At the last November term, the grand jury had returned an indictment against James W. Lent for an assault and battery upon John A. Graham, one of the counselors of this court. A jury having been impaneled, the trial came on today. People's Counselor Van Wyck for the people, Hugh Maxwell for the prisoner. The evidence. The witnesses for the people testified that the prisoner was one of the turnkeys of Bridewell, that about 4:30 in the afternoon of October 8th last, having occasion to see and consult with one Jordan, a prisoner confined in Bridewell, Dr. Graham went there and found Lent apparently dozing, who, on being informed by him that he wanted to see that prisoner, took the key and accompanied Dr. Graham to the front door, leading to the prisoner's room, and there halted and without opening the door demanded of him $5. The doctor inquired of Lent his meaning and demanded entrance, which was then granted but with reluctance. He hesitated in opening the door to the prisoner's room, and when this was done, Dr. Graham told him that he should be detained with the prisoner not to exceed 6 minutes. He finished his business, and Lent, not appearing to unlock the door in about 15 minutes from the time Dr. Graham first entered, he began to make a noise with a chain, and call aloud to those he saw passing by, and beg their assistance, but no one came to his relief. At length he saw a person passing the prison, called aloud to him and requested him to go to the keeper and give information. Dr. Graham having been detained about half an hour, Lent came and opened the door, when the former told him that he had treated him like a scoundrel and threatened to complain to the grand jury. Whereupon Lent shook his fist in the face of Dr. Graham, abused him with very insulting language, and pursued him over to his office with threats and curses. Afterwards Lent made another assault on Dr. Graham in the street. In the course of his testimony, Dr. Graham further testified that he verily believed that the conduct of Lent towards him originated from his refusing to give him $5. It had been customary for counsel, who frequently went into Bridewell to see prisoners, to give the turnkeys from time to time presents for their trouble, and the doctor had but a short time before this given Lent a small sum. For the prisoner, it was attempted to prove that the detention of Dr. Graham resulted from forgetfulness and was not premeditated. Reverend John Stanford testified that he was once detained in the Bridewell by mistake while visiting a prisoner there. The counsel made short speeches to the jury. Cadwallader, mayor, charged the jury that, as respected the public administration of justice, this case was important. Formerly a prisoner was not allowed the benefit of counsel, but now, according to the principles of our Constitution, a different rule prevailed. The party accused is entitled to the assistance of counsel, who, in case of inability of the party, shall be assigned by the court. But this privilege would be nugatory. It would be a mere mockery if counsel should be denied access when employed by the prisoner or assigned by the court. In this case, Dr. Graham had a right to visit this prison, and the turnkey, in obstructing his entrance and detaining him in the manner stated in his testimony, committed an outrage upon public justice. The demand also of the $5, if made, was scandalous in the extreme, and is not extenuated by any usage or custom whatsoever. And if the refusal of Dr. Graham to pay that sum to the defendant influenced his subsequent conduct, his offense is greatly aggravated. It had been contended that the detention of Dr. Graham was not intentional, but arose from the forgetfulness of Lent. Admitting this to be the case, it does not excuse, much less justify, the defendant. He was informed by Dr. Graham of the length of time he should be detained in the prison, and it was therefore the duty of Lent to have attended at or near the time and to have unlocked the door. This was a part of his duty, and if the excuse which has been urged in his favor is to prevail, he may, through forgetfulness, imprison a citizen a whole night. The jury returned a verdict of guilty, and the prisoner was sentenced to a fine of $25 and costs. End of section 58.
Section 59 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Action of John Trevett against John Wheeden for refusing paper money. Rhode Island, 1786, Part 1. The narrative. The period immediately succeeding the American Revolution was the most gloomy in our history. The country was exhausted by a protracted contest of 7 years, and on the restoration of peace, they were found to be causes of discontent in many of the states, which threatened to embroil the citizens in sanguinary domestic dissensions. The army, unpaid and discontented, had returned to their homes, amongst a population as impoverished as themselves, and the whole people was subjected to burdensome taxes to meet a mass of debt, which had been accumulated in the course of the war. Money became very scarce, and in Rhode Island a political party arose, which obtained a large majority in the state assembly, whose idea was that paper money might be forced by legislative authority to take the place of gold, and laws were passed to carry out this policy to the utmost extent by the strong arm of the law. A bank was established to issue 100,000 pounds of paper money, to be loaned to the farmers on their land at 4%, and to be a lawful tender for all debts. But when the money was issued, the merchants would not take it, for the goods they sold or the debts due them, whereupon the Assembly passed an act which provided that any person who refused to take the money at par should be fined £100 and be forever incapable of holding a public office. This did not do any good. People still continued to refuse the paper, and so another law was passed that all offenders against the Bank Act should be tried within 3 days after the complaint was made. No jury was to be allowed and no appeal from the decision of the trial court, and the offender to be forthwith sent to jail. A Newport butcher named John Wheeden had among his customers a strong paper money man named John Trevett. The latter, who was a cabinet maker, presented himself at the market one day and purchased a few pounds of beef and tendered in payment some of the new money. Wheeden refused to take the paper at its par value, and Trevett, in a rage, launched a complaint against him. The hearing began almost immediately, and, as it was a test case, the excitement in the community was immense. And as the judges were removable at the will of the assembly, there seemed much reason to believe that the law would be vigorously executed. When the day of trial came, the benches in the courtroom were packed. Every inch of standing room was taken, while the great crowd, unable to get in, stood under the windows or jostled each other about the doors. Each side was represented by able counsel, for the contest was in truth not between Trevett and Wheeden, but between the farmers and the merchants, between those who, having mortgaged their lands for the paper issue, now struggled hard to keep it at par, and those who, recalling the disastrous times of 1779, struggled hard to prevent a shilling of the paper from ever getting out of the hands of its holders. The first day was taken up in listening to counsel on each side. The excitement of the audience was intense. The debate was warm and conducted with great animosity. On the second day, the court rendered its decision. Judge Howell was appointed to deliver it. When he began to speak, a death-like stillness was in the room. But when he was done, the shout of exultation that went out from the benches announced to the crowd without that Wheeden had won, and that the odious act had been pronounced unconstitutional by the court. The trial. Footnote. Bibliography. The case of Trevett against Wheeden on information and complaint for refusing paper bills and payment for butcher's meat in market at par with specie. Tried before the Honorable Superior Court in the County of Newport, September term 1786. Also the case of the judges of said court before the Honorable General Assembly at Providence, October session 1786, on citation for dismissing said complaint, wherein the rights of the people to trial by jury, etc., are stated and maintained, and the legislative, judiciary, and executive powers of government examined and defined. By James M. Farnan, Esquire, Major General of the State of Rhode Island, etc., Counselor at Law and Member of Congress for said state. Providence, printed by John Carter, 1786. See also Memoirs of the Rhode Island Bar by Wilkins Updike. Chandler, American Criminal Trials 1, American State Trials 116. End of footnote. In the Superior Court of Judicature, Newport, September 1786. Honorable Paul Mumford, Chief Justice. Honorable Joseph Hazard. Honorable Thomas Tillinghast. Honorable David Howell, Associate Justices. Footnote. Tillinghast Thomas, 1742 to 1821, born East Greenwich, Long Island, State Representative, 1772 to 73, 1778 to 80, Soldier in the Revolution, Judge Common Pleas, 1779, Judge Supreme Court, Rhode Island, 1780 to 1797, Member Congress, 1797 to 99, 1801 to 03. Howell David, 1747 to 1824, born New Jersey, graduated College of New Jersey, Professor of Mathematics and Natural Philosophy, Brown University, 1769, Professor of Law, 34 years, a member of the Board of Fellows of the Corporation for 52 years, and for many years, Secretary of the Corporation. Practiced law in Rhode Island member of Congress under the Confederation from Rhode Island, appointed U.S. Judge, District of Rhode Island, 1812. End of footnote. September 16th. The plaintiff, John Trevett, having complained that he had purchased from John Wheeden some meat in the public market, and that the latter had refused to take in payment of the meat paper money of the state tendered him. The defendant, not denying the facts, pleaded that it appears by the act of the General Assembly, wherein such information was founded, that the act had expired and hath no force. Also, for that by said act the matters of complaint are made triable before special courts, uncontrollable by the Supreme Judiciary Court of the state. Also, for that the said court is not, by said act, authorized and empowered to impanel a jury to try the facts charged in the information, and so the same is unconstitutional and void. The complaint was filed before the Chief Justice at his chambers, who referred it to the full court which assembled today. James M. Varnon and Henry Marchant for the defendant. Footnote: Varnum James Mitchell, 1749 to 1789, born Drake, Massachusetts, graduated Rhode Island College, now Brown University, 1769, studied law with Oliver Arnold of Providence, and admitted to bar 1771, and settled in East Greenwich, entered the Army at 27, elected to Rhode Island Assembly, Brigadier General 1777, Major General State Militia 1779, elected to Congress 1780, resumed practice of law after the war, member of Congress 1786, in 1787 was appointed Judge of the Superior Court of the Northwestern Territory, and died at Marietta, Ohio. Marchant Henry, 1741 to 1796, born Martha's Vineyard, Massachusetts, and studied law with Judge Trowbridge in Cambridge, and established himself in Newport, Rhode Island. Attorney General of the Colony 1770, was a delegate to the Continental Congress 3 years, when he declined serving longer. On the organization of the government under the Constitution, was appointed by Washington Judge of the District Court for Rhode Island. End of footnote. The evidence. John Trevett swore to the facts as stated in his complaint. The following are the statutes of Rhode Island on which the complaint is founded. 1. The statute establishing the bank and providing that its bills were to be issued in a convenient form, not more than £3 in value, nor less than 6 pence. That the money was to be lawful tender for all debts, and in case any person refused to receive it, as such his debt was to be forever barred. 2. The statute which provided that any person who should refuse to take these bills of credit in exchange for any articles which he might have for sale, according to the amount expressed on the face of such bills, or make any difference in the prices between silver and paper money in any sale or exchange, or direct the same to be done, or in any manner whatever tend or attempt to depreciate or discourage the passing of such bills, of the price of the face thereof, or do any act to invalidate or weaken the act emitting such bills, for the first offense should forfeit and pay the sum of £100, and be rendered incapable of being elected to any office of honor, trust, or profit within the state. 3. The statute which enacted that if any person refused to receive such bills as coin, according to previous laws, the complainant should apply to either of the judges of the Superior Court of Judicature or Inferior Court of Common Pleas, and citation should be issued to the refusing party to appear before a special court within 3 days, and there stand his trial without a jury, according to the laws of the land before such court. And the judgment of the court upon the conviction of the accused was to be forthwith executed, and the offender immediately to pay the penalty, or stand committed to jail until sentence should be performed, which judgment was to be final and conclusive, and without appeal. No delay, protection, privilege, or injunction should in any case be prayed for, allowed, or granted. Mr. Varnum's speech for the defense. Mr. Varnum, may it please the Honorable Court, I do not appear upon the present occasion so much in the line of my profession as in the character of a citizen deeply interested in the constitutional laws of a free, sovereign, independent state. And indeed, whenever the rights of all the citizens appear to be essentially connected with the controverted question, conscious of the rights of man, we exercise our legal talents only as means, conducive to the great end of political society, general happiness. In this arduous, though pleasing pursuit, should my efforts appear too feeble to support the attempt, I shall derive a consolation in reflecting that the learned and honorable gentleman at my right is with me in the defense. Well may a profound silence mark the attention of this numerous and respectable assembly. Well may anxiety be displayed in every countenance. Well may the dignity of the bench condescend to our solicitude for a most candid and serious attention, seeing that, from the first settlement of this country until the present moment, a question of such magnitude as that upon which the judgment of the court is now prayed has not been judicially agitated. Happy am I, may it please your honors, in making my warmest acknowledgments to the court for permitting the information and plea to be considered by them in their supreme judiciary capacity. By this indulgent concession, we feel ourselves at liberty to animadvert freely upon the illegality of the newfangled jurisdictions erected by the General Assembly in the act more immediately in contemplation. The embarrassments naturally accompanying a plea to the jurisdiction by removing the cause from the special court into this court are totally removed, and with them the painful necessity of considering your honors as individually composing so dangerous a tribunal. The idea of that necessity is truly alarming, and we cannot do justice to our feelings without expressing a fervent wish that it may hereafter be ever banished from the human breast. In discussing the several points stated in the plea, we must necessarily call in question the validity of the legislative act upon which the information is grounded. We shall attempt most clearly to evince that it is contrary to the fundamental laws of the state, and therefore, as the civilians express it, a mere nullity and void ab initio. We shall treat with decent firmness upon the nature, limits, and extent of the legislative powers, and deduce from a variety of observations and authorities that the legislature may do err, and that this act, if we confine ourselves to the subject matter of it, can only be considered as an act of usurpation, but having been enacted by legislators of whose integrity and virtue we have the clearest conviction, and of whose good intentions we have not a doubt, it will be viewed as a hasty resolution, inconsiderately adopted and subject to legal reprehension. The parties named in the process are of no further consequence than as the one represents the almost forlorn hopes of a hitherto disappointed circle, the other as a victim, the first destined to the fury of their intemperate zeal and political frenzy. Why should the abettors of this salutary act, as many are pleased to call it, retire behind the curtain in the day of trial, unless something within them declares that all is not right? Oh, dare they not appear in the character of informers? Why should their artillery be leveled against an unfortunate man who, not 3 weeks since, was an object of charity in the streets of Newport, and now, poor pensioner upon the bounties of an hour, is called upon to answer criminally for refusing beef at 4d. the pound, when it cost him 6d. upon the hoof, although purchased of some of the most influential promoters of the present measures? Were they dubious of the event, or did they feel a reluctance in attacking gentlemen of business, character, and fortune, who daily and openly trample upon this favorite idol? Were they not acquainted with the Gibbs, and are they not intimately connected with the Cook? Incomparable was the sentiment of a fine writer that in a democratical government the customs and manners control the laws, and whatever an attempt is made to force upon the people a system repugnant to their principles, and at which every sentiment of integrity must reluct. The authors themselves, however sanguine in their hopes, will ever betray an instability in the execution that generally forebodes disappointment and chagrin. To your honors, however, it is submitted to determine how far the observation will apply to the cause on trial. The peace, the honor, the safety of the state depend upon, and the fate of unborn millions may be affected by it. The first point to which we solicit the attention of the Honorable Court is that the act of the legislature upon which the information is founded hath expired. In the preamble to this act it is stated that the usual and stated methods and times of holding courts within this state are impracticable, inexpedient, and inapplicable to the true intent and meaning of the said act. The act inflicting the £100 penalty, and altogether insufficient to carry into effect the good purposes of this legislature touching the same. Then follows, be it enacted that the mode of procedure and the method of law process against any person or persons who shall be guilty of a breach of the aforesaid act, etc., shall be as followeth. Hence, it is evident that the principal aim in this act is so to modify and vary the process as to enforce the sanctions of the former, lessening, however, the fine to render prosecutions more familiar and practicable. Examine the act with the most critical exactness. There is not a clause in it which creates a crime or defines or qualifies an action, so as to infer the idea of criminality. Observe, therefore, a subsequent clause, which enacts that the legal mode of carrying the aforesaid act into execution shall be enforced fully and completely, for every purpose therein mentioned and contained, until all offenses which have been committed and complained of, and which may be committed and complained of, until the expiration of 10 days after the rising of this assembly, may be fully heard, tried, and determined. Anything in this act to the contrary in any wise notwithstanding. What then hath become of the legal mode, pointed out in the act since the expiration of the 10 days therein mentioned? What other legal mode than in question is taken notice of? That is the only antecedent to the limiting clause. At least, it is the last antecedent, and so grammatically as well as legally is intended to continue in force the said space of 10 days. The legal mode shall be in force until the expiration of 10 days. Consequently, at the expiration of 10 days, there was an end of it. For penal statutes are to be construed strictly, not only with regard to the crime and the penalty, but also with respect to the process, more especially when the manner of trial is repugnant to the common law. I am sensible that statutes made pro publico bono, not malo, as in the present instance, claim a liberal construction. Of that kind may be deemed, in legal contemplation, the admitting act, whereby it may be supposed that the means of commerce and other business are enlarged. But this act and the former penal act becoming one are altogether penal. They are not directed to the public good, nor are they so formed as to be entitled to liberal construction. Should it be objected that this construction would manifestly oppose and frustrate the general intent of the legislature, I answer the courts of law will endeavor to establish the actual meaning of the legislature, if not opposed by plain legal construction. But as they are sworn to judge according to law, they cannot depart from this rule of decision. But, may it please your honors, we do not place our principal reliance upon this objection, although in legal propriety we might safely meet the consequences. The whole frame of the act is so replete with blunders, contradictions, and absurdities, that not a trace of law learning can be discovered in it. And to the honor of those of the professional gentlemen who prefer the good of their country to the paltry gains of business, they had not anything to do with it, nor anyone else who understood, or, if he understood, duly considered what he was about. End of section 59. Section 60 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Action of John Trevett against John Wheeden for refusing paper money. Rhode Island, 1786, Part 2. We now proceed to the second point stated in the plea, that by the act of the legislature, special trials are instituted, incontrollable by the Supreme Judiciary Court of the state. There are, in all free governments, three distinctive sources of power: the legislative, the judiciary, and executive. The judiciary power is more or less perfect, as the formation of the courts of law tends to produce certainty and uniformity in legal determinations. And indeed, without certainty and uniformity in the judicial tribunals, the best possible system of laws will prove entirely inadequate to the security of the people. For law itself is but a rule of action, and consequently its very existence is destroyed when contradictory decisions are admitted upon the same point. From hence may clearly be inferred the necessity of a Supreme Judiciary Court, to whose judgments, as the only conclusive evidence in law questions, all subordinate jurisdictions must conform. Such is the court before which I now have the honor of appearing, into the nature and extent of whose jurisdiction permit me, with humble deference, to inquire. In the charter granted by King Charles II, it is granted to the governor and company, when convened in their legislative capacity, to appoint, order, and direct, erect, and settle such places and courts of jurisdiction for the hearing and determining of all actions, matters, and things within the said colony and plantation, and which shall be in dispute, and depending there, as they shall think fit, and also to distinguish and set forth the several names and titles, duties, powers, and limits of each court, clerk, and officer, superior and inferior. In consequence whereof, the General Assembly in the year 1729 established this court in its present form, a superior court of judicature, court of assize, and general jail delivery over the whole colony for the regular hearing and trying all pleas, real, personal, and mixed, and all pleas of the crown, that they shall have the same power and authority in all matters and things in this colony, as the Court of Common Pleas, King's Bench, or Exchequer have, or ought to have in that part of Great Britain heretofore called England, and be empowered to give judgment in all matters and things before them cognizable, and to award execution thereon. This establishment has never been varied, nor the jurisdiction of the court diminished. The powers annexed to it were derived from the Charter, from our original Constitution, and by an uninterrupted exercise have become matters of common right. In point of antiquity, we find them existing in full vigor in the earliest periods of which we have any regular traces of the English Constitution. It is unnecessary, however, to look any further back than to the Norman reigns, when justice was exercised in one court called the Aula Regis. Out of this court, the courts of common pleas and exchequer seem to have been derived, some time before the making of the statute of Magna Carta, the former of which courts properly determines pleas merely civil, and the latter those relating to the revenue of the crown. And after the erection of these courts, the Supreme Court seems by degrees to have obtained the name of the Court of King's Bench, and hath always retained a supreme jurisdiction in all criminal matters. The extent of these powers is well defined by the author last referred to, as well as by most of the writers upon the subject. There is no doubt that this court, being the highest court of common law, hath not only power to reverse erroneous judgments given by inferior courts, but also to punish all inferior magistrates and all officers of justice for all willful and corrupt abuses of their authority. It commands, prohibits, and restrains all inferior jurisdictions whenever they attempt to exceed their authority or refuse to exercise it for the public good or upon the application of individuals. There are many instances, I must confess, in which no appeal is allowed from other courts to this court, and in such cases it will not interpose its supreme control, unless the other courts exceed their authority, or otherwise as before mentioned. Let us illustrate the subject by reflecting for a moment upon the establishment of our courts of general sessions of the peace. They are 5 in number, corresponding to the 5 counties of the state. They have cognizance of all crimes not capital, arising within their respective districts, and their jurisdictions are perfectly equal. Suppose them exercising their legal judgments upon the same law, and that this law is of a complicated nature, admitting of different constructions, both in the definition of the crime and the mode of punishment. May we not, must we not, conclude that the same law would have different operations in the different counties? Hence arises the necessity of a supreme control, of a common standard, to which the opinions of these 5 judicatories shall be conformable. The citizens are entitled not only to liberty, arising from the security which the laws afford, but they are equally entitled to equal liberty. They must, therefore, they will apply to one tribunal as to a focal point, where the knowledge of the law is concentrated, and from whence its voice will be heard with irresistible conviction, confirming the principles of universal equality. Had the cognizance of information been confined to the courts of session only, the evil might have been remedied without appeal by writs of certiorari, prohibition, mandamus, and precedendo. But by an unheard of arrangement in the special jurisdictions, the judges of this court are precisely upon a level with those of the sessions. Their jurisdiction is concurrent, cumulative, and equal. Consequently, there would not be a propriety in applying to this court, in their supreme judicial capacity, to correct the errors and restrain the excesses that might arise from oppressive determinations. For in the second, they might counteract their first deliberations, or refuse to grant redress. But by their first decisions as a special court, a legal prejudice would naturally be formed in the minds of the judges individually, which might totally obstruct the avenues to justice. The pride of opinion is more or less prevalent in all men, however exalted their stations, and however conformably the intention may be to the principles of rectitude. The judgment will be biased by pre-existing opinions. Making every possible concession for the sake of the argument, the Supreme Judiciary Court could only correct the errors of its own judges, determining in the special court, and therefore the extravagances that might accompany the proceedings of the other 5 courts could not in any possible case be represented. May it please your honors, as all the glory of the solar system is reflected from yonder refulgent luminary, so the irradiations of the inferior jurisdictions are derived from the resplendent control of this primum mobile in the civil administration. Under its genial influence, therefore, we beg liberty to consider the last point submitted to the judgment of the court, that by the act of the legislature, the court is not authorized or empowered to impanel a jury for trying the facts complained of in the information. The proposition cannot be controverted. The expressions in the act, that the majority of the judges present shall proceed to hear, etc., without any jury, do not require a comment. Should it be objected that this clause of the act only empowers the judges to try the fact, when the parties will agree to waive the trial by jury, it will be sufficient to answer that the General Assembly intended directly the contrary. It is well known by all present that on one day this clause was rejected, but on the day following, in consequence of a nocturnal imperium in imperial, or convention of part of the members, a motion was made for receding, and they did recede accordingly. The general tenor of the act was so repugnant to the honest feelings of the people, when excited by sober reflection, that the junto out of doors, and possibly some leading men within, were apprehensive that convictions would not take place in the usual mode of trial. They aimed therefore at a summary process, flattering themselves that the judges, being elected by the legislators, would blindly submit to their sovereign will and pleasure. But happy for the state, our courts in general are not intimidated by the dread, nor influenced by the debauch of power. This part of the subject, and which is by far the most important, will require a more ample discussion than the preceding. I must, therefore, beg the attention of the Honorable Court to the following considerations: that the trial by jury is a fundamental right, a part of our legal constitution, that the legislature cannot deprive the citizens of this right, and that your honors can, and we trust will, so determine. By the Great Charter of Liberties, which was obtained sword in hand from King John, and afterwards with some alterations, confirmed in Parliament by King Henry III, his son, which charter contained very few new grants, but, as Sir Edward Coke observes, was for the most part declaratory of the principal grounds of the fundamental laws of England, afterwards by the statute called Confirmatio Cartatum, whereby the Great Charter is directed to be allowed as the common law. All judgments contrary to it are declared void. Copies of it are ordered to be sent to all cathedral churches and read twice a year to the people, and sentence of excommunication is directed to be constantly denounced against all those that by word, deed, or counsel act contrary thereto, or in any degree infringe it. Next, by a multitude of subsequent corroborating statutes, Sir Edward Coke, I think, reckons 32, from the first Edward to Henry IV. Then, after a long interval, by the Petition of Right, which was a parliamentary declaration of the liberties of the people, assented to by King Charles I in the beginning of his reign, which was closely followed by the still more ample concessions made by that unhappy prince to his parliament before the fatal rupture between them, and by the many salutary laws, particularly the Habeas Corpus Act, passed under Charles II. To these succeeded the Bill of Rights, or declaration delivered by the Lords and Commons to the Prince and Princess of Orange, February 13, 1688, and afterwards enacted in Parliament when they became King and Queen, which declaration concludes in these remarkable words: "And they do claim, demand, and insist upon all and singular the premises as their undoubted rights and liberties." And the Act of Parliament itself recognizes all and singular the rights and liberties asserted and claimed in the said declaration to be the true, ancient, and indubitable rights of the people of this kingdom. Lastly, these liberties were again asserted at the commencement of the present century in the Act of Settlement, whereby the Crown was limited to His present Majesty's illustrious house, and some new provisions were added at the same fortunate era, but better securing our religion, laws, and liberties, which the statute declares to be the birthright of the people of England, according to the ancient doctrine of the common law. The same elegant writer, who appears to possess the highest degree of information in legal history, observes, on speaking of this palladium of liberty, that it is a trial that hath been used time out of mind in this nation, and seems to have been coeval with the first civil government thereof. Some authors have endeavored to trace the original of juries up as high as the Britons themselves, the first inhabitants of our island, but certain it is that they were in use among the earliest Saxon colonies, their institution being ascribed by Bishop Nicholson to Wheeden himself, their great legislator and captain. Hence it is that we may find traces of juries in the laws of all those nations which adopted the feudal system, as in Germany, France, and Italy, who had all of them a tribunal composed of 12 good men and true, bon homines, usually the vassals or tenants of the lord, being the equals or peers of the parties litigant, and as the Lord's vassals, judged each other in the Lord's courts, so the king's vassals or the lords themselves judged each other in the king's court. In England we find actual mention of them so early as the laws of King Ethelred, and that not as a new invention. Sternhoek ascribes the invention of the jury, which in the Teutonic languages dominated Menbra, to Ragnar, king of Sweden and Denmark, who was contemporary with our King Egbert, just as we are apt to impute the invention of this and some other pieces of judicial polity to the superior genius of Alfred the Great, to whom, on account of his having done much, it is usual to attribute everything, and as the tradition of ancient Greece placed to the account of their one Hercules whatever achievement was performed, superior to the ordinary prowess of mankind, whereas the truth seems to be that this tribunal was universally established among all the northern nations, and so interwoven in their very constitution that the earliest accounts of the one gives us also some traces of the other. Its establishment, however, and use in this island, of which date soever it be, though for a time greatly impaired and shaken by the introduction of the Norman trial by battle, was always so highly esteemed and valued by the people that no conquest, no change of government could ever prevail to abolish it. In Magna Carta it is more than once insisted on as the principal bulwark of our liberties, but especially by Cap 29, that no freeman shall be hurt in either his person or property, nisi per legale judicum parium svorum vel per legum terri, a privilege which is couched in almost the same words with that of the Emperor Conrad 200 years before. Nemo beneficium udum spurdat, nisi secundum consuetudinem antecessorum nostrum, per judicium parium sorum, and it was ever esteemed in all countries a privilege of the highest and most beneficial nature. From these passages in Judge Blackstone's commentaries, from the variety of authorities to which he refers, and from many others of the greatest reputation, it most clearly appears that the trial by jury was ever esteemed at first a fundamental and a most essential principle in the English Constitution. From England this sacred right was transferred to this country, and hath continued, through all the changes in our government, the firm basis of our liberty, the fairest inheritance transmitted by our ancestors. The settlers in this country for whom we are descended were Englishmen. They gloried in their rights as such, of being persecuted in matters of religion over which no earthly tribunal can have the control. They bravely determined to quit their native soil, to bid a final adieu to the alluring charms of their situation, and commit their future existence to that almighty power, whose authority they dared not infringe, but in whose protection they could safely confide. They tempted the foaming billows, they braved, they conquered the boisterous Atlantic, and rested in a howling wilderness amidst the horrid caverns of the untamed beasts and the more dangerous haunts of savage men. They retained their virtue, their religion, and their inviolable attachment to the constitutional rights of their former country. They did not withdraw or wish to withdraw themselves from their allegiance to the crown, but emigrated under a solemn assurance of receiving protection, so far as their situation might require, and other circumstances rendered practicable. The laws of the realm, being the birthright of all the subjects, followed these pious adventurers to their new habitations, where, increasing in numbers amidst innumerable difficulties, they were formed into colonies by royal charters in the nature of solemn compacts, confirming and enlarging their privileges. In the charter granted to our forefathers, the following paragraph claims our particular attention: that all and every, the subjects of us, our heirs and successors, which are already planted and settled within our said colony of Providence plantations, which shall hereafter go to inhabit within the said colony, and all and every of their children, which have been born there, or on the sea going thither, or returning from thence, shall have and enjoy all liberties and immunities of free and natural subjects within any of the dominions of us, our heirs or successors to all intents, constructions and purposes whatsoever, as if they, and every of them, were born within the realm of England. This concession was declaratory of and fully confirmed to the people the Magna Carta and other fundamental laws of England, and accordingly, in the very first meeting of the General Assembly, after receiving the Charter in the year 1663, they made and passed an act declaring the rights and privileges of His Majesty's subjects within this colony, whereby it is enacted that no freeman shall be taken or imprisoned, or be deprived of his freehold or liberty, or free customs, or be outlawed, or exiled, or otherwise destroyed, nor shall be passed upon judged or condemned, but by the lawful judgment of his peers, or by the laws of this colony, and that no man, of what estate or condition soever, shall be put out of his lands and tenements, nor taken, nor imprisoned, nor disinherited, nor banished, nor any ways destroyed, nor molested, without for it being brought to answer by due course of law, and that all rights and privileges granted to this colony by His Majesty's Charter be entirely kept and preserved to all His Majesty's subjects residing in or belonging to the same. This act, may it please the Honorable Court, was not creative of a new law, but declaratory of the rights of all the people, as derived through the Charter from their progenitors, time out of mind. It exhibited the most valuable part of their political constitution, and formed a sacred stipulation that it should never be violated. It would be a pleasing and perhaps a useful employment to trace and point out the numerous instances wherein the General Assembly have reasserted these solemn rights, but time will not admit of minute detail. I cannot, however, be entirely silent upon this head. At their September session in the year 1765, the General Assembly, taking into the most serious consideration an act passed by the British Parliament at their last session for levying stamp duties and other internal duties in North America, resolved that the first adventurous settlers of this His Majesty's colony and dominion of Rhode Island and Providence plantations brought with them and transmitted to their posterity and all other His Majesty's subjects, since inhabiting in this His Majesty's colony all the privileges and immunities that had at any time been held, enjoyed and possessed by the people of Great Britain. Afterwards, at the October session in the year 1769, they unanimously passed the following resolution: that all trials for treason, misprision of treason, or for any felony or crime whatsoever committed and done in His Majesty's said colony and dominion by any person or persons residing therein, ought of right to be had and conducted in and before His Majesty's courts held within the said colony, according to the fixed and known course of proceeding, and that the seizing of any person or persons residing in this colony suspected of any crime whatsoever committed therein, and sending such person or persons to places beyond the sea to be tried, is highly derogatory to the rights of British subjects, as thereby the inestimable privilege of being tried by a jury from the vicinage, as well as the liberty of summoning and producing witnesses on such trial, will be taken away from the party accused. The attempts of the British Parliament to deprive us of this mode of trial were among the principal causes that united the colonies in a defensive war, and finally effected the glorious Revolution. This is evident from the Declaration of Rights made by the First Congress in October in the year 1774. The preamble states that the inhabitants of the English colonies in North America, by the immutable laws of nature, the principles of the English Constitution and the several charters and compacts, have the following rights, the fifth of which is, that the respective colonies are entitled to the common law of England, and more especially to the great and inestimable privilege of being tried by their peers of the vicinage, according to the course of that law. At the same time, they enumerated the several acts of the British Parliament to which they declared they could not submit, particularly 12 George III, Chapter 24, entitled, An Act for the Better Securing His Majesty's Dockyards, Magazines, Ships, Ammunition, and Stores, which declares a new offense in America, and deprives the American subject of a constitutional trial by jury of the vicinage, by authorizing the trial of any person charged with the committing of any offense described in the Act out of the realm, to be indicted and tried for the same in any shire or county within the realm, in pursuance of the same principle, upon the ever-memorable 4th of July, in the year 1776, when the rights of the United States were exhibited in a new blaze of glory, when, to support them, the fathers of their country, with a firm reliance on the protection of divine providence, mutually pledged to each other their lives, their fortunes, and their sacred honor, when they submitted to a candid world the catalogue of their complaints against the King of Britain. They charged him with depriving us in many instances of the benefits of trial by jury. Here let us pause. If the first act of the English Parliament, now upon record, containing the great charter of the privileges of the subjects, if the exercise of those privileges for ages, if the settlement of a new world to preserve them, if the first solemn compact of the people of this state, if the sacred declarations of the legislature at different periods, and upon the most important occasions, if the solemn appeal to heaven of the United States, in short, if the torrents of blood that have been shed in defense of our invaded rights are proofs, then have we triumphed in the cause of humanity. Then have we shown that the trial by jury is the birthright of the people. Astonished am I, may it please the honorable court, that a doubt should have arisen in the mind of any respecting the legal construction of our Magna Carta, our Declaration of Rights. Some of our warmest politicians, whose heads are undoubtedly wrong, and it is greatly to be feared their hearts are not right, have boldly asserted that the clause which declares that no freeman, etc., shall be tried, etc., but by the lawful judgment of his peers, or by the laws of the colony, etc., clearly authorizes any other mode of trial than that by jury, should the legislature frame a law for that purpose, that their act would become the law of the land, and so the special jurisdictions are perfectly conformable to the letter and spirit of our Constitution. Is it possible that these pretenders to the knowledge of law should be serious, when they avow so dangerous an opinion? If they are, let them be informed that they contradict the wisdom and the practice of ages, that whenever a statute makes mention of the law of the land, it refers either to a particular pre-existing law, to the system of laws in general, or to the mode of legal process. Lord Coke, in his readings upon the statute, has fully demonstrated that the clause, or by the law of the land, regards the process only, that the particle, or is to be construed conjunctively, and so the sentence will read, by the lawful judgment of his peers, by, or according to, the law of the land, or, and by the law of the land, that is to say, by bill, plaint, information, or in any other legal manner. End of section 60. Section 61 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Action of John Trevett against John Wheeden for refusing paper money. Rhode Island, 1786, Part 3. There are many instances in the books of a similar construction. I shall produce only one, the case of Barker against sureties. On a special verdict in ejectment, the question turned upon these words in a will, viz., I give the said premises to my grandson, his heirs and assigns, but in case he dies before he attains the age of 21 years, or marriage, and without issue, then in such a case he devised the same to the defendant. The fact was, the grandson attained 21 and died, having never been married, and it was insisted that the attaining 21 was performance of the condition, and vested the estate absolutely in the grandson, under whom the lesser of the plaintiff claimed, and judgment was accordingly given in the county palatine of Durham, whereof error was brought in Banco Regis. And after several arguments, the court affirmed the judgment upon the authority of Price against Hunt in Paul X.F. 645, where the word or was construed conjunctively, and they said that they would read this without the word or, as if it ran, and if he dies before 21, unmarried and without issue, which he did not do, for one of the circumstances failed, and all put together are but in the nature of one contingency, and it was considered that this was not a condition precedent, but to destroy an estate devised by the form of words in fee. I recollect in an excellent treatise of law in general, subjoined to the memoirs of the House of Brandenburg, written by that great legislator, the illustrious Frederick, when speaking of the laws of England, he quotes the heads of Magna Carta, and when speaking of this part in particular, his words are, that nobody shall be imprisoned or deprived either of life or estate, without being judged by his peers, and according to the laws of the kingdom. The framers of this act, however, and the supporters of the present measure, are not without a precedent, and so cannot engross all the honor to themselves, unless they should endeavor to palm themselves upon the deluded as originals. We will produce them an instance from the reign of Henry VII, as similar to the present as the image in the mirror is to the substance. That great oracle of the law, Lord Coke, records it in the following manner. Against this ancient and fundamental law, trial by jury, and in the face thereof, I find an act of Parliament made, that as well as justices of assize, as justices of peace, without any finding or presentment of 12 men, upon a bare information for the king before them made, should have full power and authority, by their discretion, to hear and determine all offences and contempts committed or done by any person or persons against the form, ordinance, and effect of any statute made and not repealed, etc. By color of which act shaking this fundamental law, it is not credible but horrid oppression and exactions, to the undoing of infinite numbers of people, were committed by Sir Richard Epson and Edmund Dudley, being justices of peace through England. And upon this unjust and injurious act, as commonly in like cases it falleth out, a new office was erected, and they made masters of the king's forfeitures. But at the Parliament holden in the first year of Henry VIII, this act of the 11th of Henry VII is recited and made void, for that by force of said act it was manifestly known that many sinister and crafty, feigned and forged informations had been pursued against divers of the king's subjects, to their great damage and wrongful vexation, and the ill success hereof, and the fearful of those two oppressors, should deter others from doing the like, and should admonish parliaments, that instead of this precious trial by jury, they bring on in absolute and partial trials by discretion. Well may be the countenances of certain gentlemen be changed, well may their trembling limbs denote the perturbation of their minds, well may their hearts quake within them, for all others who, like Epson and Dudley, violate the constitutional laws of their country, deserve, and if they persist in their career, will probably meet their fate. But we shall proceed, with the permission of your honors, to inquire whether the legislature can deprive the citizens of their constitutional right, the trial by jury. When mankind entered into a state of civil society, they surrendered a part of their natural rights into the hands of the community. that they might enjoy the remainder with greater security. The aggregate of this surrender forms the power of government, the first and greatest exercise of which constitutes legislation, or the power of making laws. Consequently, the legislature cannot intermeddle with the retained rights of the people. In the infant state of society, when the community consisted of but few members, when their wants and desires were circumscribed within narrow bounds, the power of making laws was exercised by all the people assembled for that purpose, or at least by the heads of families who derived from nature a temporary authority over their offspring. Whatever was necessary for the good or safety of the whole was agreed to, and each individual engaged to abide by the opinion of the majority. Such was the situation of our ancestors when they first settled in this country. As society increased in numbers and wealth, as their settlements were extended and their views enlarged, it became necessary to delegate the powers of legislation and vest them in one person, in a few, or in many, as the community deemed most conducive to their common advantage. Such was the situation of our ancestors when they petitioned to King Charles II to be incorporated into a company, with the power of governing themselves. First, by making of laws in a General Assembly, to be convened twice in each year, composed of magistrates elected annually by the freemen at large, and of deputies chosen semi-annually from the respective towns as their representatives, and secondly, by carrying those laws into execution by judiciary establishments. The power of legislation in every possible instance are derived from the people at large, are altogether fiduciary, and subordinate to the association by which they are formed. Were there no bounds to limit and circumscribe the legislature? Were they to be actuated by their own will, independent of the fundamental rules of the community? The government would be a government of men and not of laws. And whenever the legislators depart from their original engagements and attempt to make laws derogatory to the general principles they were bound to support, they become tyrants. For since it can never be supposed, as Mr. Lockwell observes, to be the will of the society, that the legislative should have a power to destroy that which everyone designs to secure by entering into society, and for which the people submitted themselves to legislators of their own making, whenever the legislators endeavored to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power. They put themselves into a state of war with the people. And again, when the legislators act contrary to the end for which they were constituted, those who are guilty of rebellion. The powers of our legislature are so clearly defined in the Charter, which is conclusive evidence of the compact of the people, as well as of the royal intention, that a recurrence to them will greatly assist us in the present question. Let us attend, therefore, to the following passage. And that they, the General Assembly, or the greatest part of them then present, whereof the governor or deputy governor, and 6 of the assistants, at least to be 7, shall have and have hereby given and granted unto them full power and authority from time to time, and at all times hereafter, to make, ordain, constitute, or repeal such laws, statutes, orders, and ordinances, forms and ceremonies of government and magistracy, as to them shall seem meet for the good and welfare of the said company, and for the government in ordering the lands and hereditaments, hereinafter mentioned to be granted, and of the people that do, or at any time hereafter shall, inhabit or be within the same, so as such laws, ordinances, and constitutions, so made, be not contrary and repugnant unto, but as near as may be, agreeable to the laws of this our realm of England, considering the nature and constitution of the place and people there. This grant, which was obtained in consequence of an association of all the people for that purpose, expressly limits the legislative powers, and by invariable custom and usage they are still so confined, that they cannot make any laws repugnant to the general system of laws which governed the realm of England at the time of the grant. The Revolution has made no change in this respect, so as to abridge the people of the means of securing their lives, liberty, and property, to preserve which they have ever considered the trial by jury the most effectual. There are certain general principles that are equally binding in all governments, more especially those which define the nature and extent of legislation. I do not recollect of having ever observed them so clearly and elegantly described as in a treatise written by Monsieur de Vattel upon the laws of nations and of nature. I shall introduce him, therefore, as he is translated in his own words. In the act of association, in virtue of which a multitude of men form together a state or nation, each individual has entered into engagements with all to procure the common welfare, and all have entered into engagements with each individual to facilitate for him the means of supplying his necessities, and to protect and defend him. It is manifest that these reciprocal engagements can no otherwise be fulfilled than by maintaining the political association. The entire nation is then obliged to maintain that association, and as in its duration the preservation of the nation consists, it follows from thence that every nation is obliged to perform the duty of self-preservation. The Constitution and its laws are the basis of the public tranquility, the firmest support of the public authority, and pledge of the liberty of the citizens. But this Constitution is a vain phantom, and the best laws are useless if they are not religiously observed. The nation ought then to watch very attentively in order to render them equally respected by those who govern, and by the people destined to obey. To attack the Constitution of the state and to violate its laws is a capital crime against society, and if those guilty of it are invested with authority, they add to this crime a perfidious abuse of the power with which they are entrusted. The nation ought constantly to suppress these abuses with its utmost vigor and vigilance, as the importance of the case requires. It is very uncommon to see the laws and constitution of a state openly and boldly opposed. It is against silent and slow attacks that a nation ought to be particularly on its guard. But here, the attack is open and bold. It comes with violence. It moves with huge, gigantic strides and threatens slavery or death. A very important question here presents itself. It essentially belongs to the society to make laws, both in relation to the manner in which it desires to be governed and to the conduct of the citizens. This is called the legislative power. The nation may entrust the exercise of it to the prince or to an assembly, or to that assembly and the prince jointly, who would have then a right of making new and abrogating old laws. It is here demanded whether, if their power extends so far as to the fundamental laws, they may change the constitution of the state. The principles we have laid down lead us to decide this point with certainty, that the authority of these legislators does not extend so far, and that they ought to consider the fundamental laws as sacred, if the nation has not, in very express terms, given them the power to change them. For the constitution of the state ought to be fixed, and since that was first established by the nation, which afterwards entrusted certain persons with the legislative power, the fundamental laws are accepted from their commission. It appears that the society had only resolved to make provision for the states being always furnished with laws suited to particular conjunctures, and gave the legislator for that purpose the power of abrogating the ancient civil and political laws that were not fundamental, and of making new ones. But nothing leads us to think that it was willing to submit the Constitution itself to their pleasure. In short, these legislators derive their power from the Constitution. How then can they change it without destroying the foundation of their authority? Have the citizens of this state ever entrusted their legislators with the power of altering their Constitution? If they have, when and where was the solemn meeting of all the people for that purpose? By what public instrument have they declared it? Or in what part of their conduct have they betrayed such extravagance and folly? For what have they contended through a long, painful, and bloody war, but to secure inviolate and transmit unsullied to posterity the inestimable privileges they received from their forefathers? Will they suffer the glorious price of all their toils to be wrested from them and lost forever by men of their own creating? They who have snatched their liberty from the jaws of the British lion amidst the thunders of contending nations, will they basely surrender to the administration of a year? As soon may the great Michael kick the beam and Lucifer riot in the spoils of angels. Constitution, we have none. Who dares to say that? None but a British emissary or a traitor to his country. Are there any such amongst us? The language has been heard, and God forbid that they should continue. If we have not a constitution, by what authority do our General Assembly convene to make laws and levy taxes? Their appointment by the freemen of the towns, excluding the idea of a pre-existing social compact, cannot separately give them power to make laws compulsory upon the other towns. They could only meet, in that case, to form a social compact between the people of the towns. But they do meet by the appointment of their respective towns at such times and places, and in such numbers as they have been accustomed to do from the beginning. When met, they make laws and levy taxes, and their constituents obey those laws and pay their taxes. Consequently, they meet, deliberate, and enact, in virtue of a constitution, which, if they attempt to destroy, or in any manner infringe, they violate the trust reposed in them, and so their acts are not to be considered as laws, or binding upon the people. But as the legislative is the supreme power in government, who is to judge whether they have violated the constitutional rights of the people? I answer, their supremacy, consisting in the power of making laws, agreeably to their appointment, is derived from the Constitution, is subordinate to it, and therefore, whenever they attempt to enslave the people and carry their attempts into execution, the people themselves will judge as the only resort in the last stages of oppression. But when they proceed no farther than merely to enact what they may call laws, and refer those to the judiciary courts for determination, then, in discharge of the great trust reposed in them, and to prevent the horrors of a civil war, as in the present case, the judges can, and we trust your honors will, decide upon them. In despotic countries, where the sovereign mandate issues from the throne, surrounded by servile flatterers, sycophants, and knaves, the judge has nothing more to do than execute. His office is altogether ministerial, being the passive tool of that lawless domination by which he was appointed. Properly speaking, the judiciary power cannot exist where political freedom is banished from the administration, or without a system of laws defining and protecting the rights of the people. There can be no fixed principles or rules of decision. Hence it is that wherever the distinct powers of government are united in one head, whether that head consists of one or of many, the subjects groan under perpetual servitude. I say of one or of many, for it is very immaterial by whom scourges, chains, and tortures are inflicted, provided we must submit to them. The studied and unheard-of cruelties of a Dionysius, who violated every right of humanity in his tyranny over the Syracusans during the space of 38 years, were not more horrid and execrable than the united barbarities of the Council of 30, established at Athens, who caused more citizens to be murdered in 8 months of peace than their enemies had destroyed in a 30 years' war. Nor am I capable of distinguishing between an established tyranny and that government where the legislature makes the law, and dictate to the judges their adjudication. For in that case, were they to enact tyrannical laws, they would be sure to have them executed in a tyrannical manner. The servility of the courts would render them totally subservient to the will of their masters, and the people must be enslaved or fly to arms. End of section 61. Section 62 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Action of John Trevett against John Wheeden for refusing paper money. Rhode Island, 1786, Part 4. In civil as well as moral agency, there is freedom of the will necessarily exerted in forming the judgment. Without the exercise of this, we cannot be said to determine at all, but our actions are wholly passive, and so, in a moral sense, we could not be accountable, and in a civil point of view, we should be deprived of all liberty. Every being naturally endeavors its own preservation, and the more conformably its actions are to its nature, the nearer it approaches to perfection. But when its actions are impelled by external force, it is deprived of the means, both of preservation and of perfection. A nation may be considered as a moral being, whose health and strength consist in the due proportion, nice adjustment, and equal preservation of all its parts. And when one branch of the government steps into the place of another and usurps its functions, the health and the strength of the nation are impaired, and should the evil be continued so as that the one be destroyed by the other, the nation itself would be in danger of dissolution. Had the judges a power to repeal, to amend, to alter laws, or to make new laws? God forbid. In that case, they would become legislators. Have the legislators power to direct the judges how they shall determine upon the laws already made? God forbid. In that case, they would become judges. The true distinction lies in this, that the legislature have the uncontrollable power of making laws not repugnant to the Constitution. The judiciary have the sole power of judging of those laws and are bound to execute them, but cannot admit any act of the legislature as law, which is against the Constitution. The judges are sworn truly and impartially to execute the laws that now are or shall hereafter be made, according to the best of their skill and understanding. They are also sworn to bear true allegiance and fidelity to the state of Rhode Island and Providence plantations, as a free, sovereign, and independent state. But this became a state in order to support its fundamental constitutional laws against the encroachments of Great Britain. The trial by jury, as has been fully shown, is a fundamental, a constitutional law, and therefore is binding upon the judges by a double tie, the oath of allegiance and the oath of office. It is a rule in ethics that if two duties or obligations, both of which cannot be performed, urge us at the same time, we must omit the lesser and embrace the greater. Let the question then fairly be stated. The General Assembly have made a law, and directed the judges to execute it by a mode of trial repugnant to the Constitution. What are the judges to resolve? Did the nature of their jurisdiction admit of such a mode of trial at the time of their appointment and taking the oath of office? Surely it did not. The Act of Assembly then erects a new office, the exercises of which, other things equal, they may undertake or refuse at their own option. There is no duty, no obligation in the way. In refusing, they incur no penalty, nor can their so doing work a forfeiture of their offices as judges of the Supreme Judiciary Court. But when it is considered that the exercise of this office would be acting contrary to their oath of allegiance and the oath of office, they are bound to reject it, unless the General Assembly have power to absolve them from these oaths and compel them to accept of any appointment they may be pleased to make. I have heard some gentlemen speak the laws of the General Assembly. I know of no such laws, distinct from the laws of the state. The idea is dangerous. It borders upon treason. 'Tis rank. It smells to heaven. Laws are made by the General Assembly under the powers they derive from the Constitution, but when made they become the laws of the land, and as such the court is sworn to execute them. But if the General Assembly attempt to make laws contrary hereunto, the court cannot receive them as laws. They cannot submit to them. If they should, let me speak of it with reverence, they would incur the guilt of a double perjury. The life, liberty, and property of the citizens is secured by the general law of the state. We will then suppose, as the very nature of the argument allows us to view the argument in every possible light, that the General Assembly should pass an act directing that no citizen should leave his house, nor suffer any of his family to move out of the same, for the space of 6 months upon the pain of death. This would be contrary to the laws of nature. Suppose they should enact that every parent should destroy his firstborn child. This would be contrary to the laws of God. But upon the common principles, the court would be as much bound to execute these acts as any others. For if they can determine upon any act that is not law, and so reject it, they must necessarily have the power of determining what acts are laws, and so on the contrary. There is no middle line. The legislature has power to go all lengths, or not to overleap the bounds of its appointment at all. So it is with the judiciary. It must reject all acts of the legislature that are contrary to the trust reposed in them by the people, or it must adopt all. But the judges and all others are bound by the laws of nature in preference to any human laws, because they were ordained by God himself anterior to any civil or political institutions. They are bound in like manner by the principles of the Constitution in preference to any acts of the General Assembly, because they were ordained by the people anterior to and created the powers of the General Assembly. This mode of reasoning will equally apply in law as in philosophy, for wherever there is a given force applied to put a body in motion, that motion will continue until the body is opposed by an equal or greater force. And the judges being sworn to execute the fundamental laws, they must continue to execute them until they shall be controlled by laws of a superior nature. But that can never happen until all the people assemble for the purpose of making a new constitution. And indeed, I very much doubt if the citizens of any one state have power to adopt such a kind of government as to exclude the trial by jury, consistently with the principles of the Confederation. It having been shown that this court possesses all the powers in this state, that the courts of King's Bench, Common Pleas, and Exchequer possess in England, let us turn to the authorities and observe the adjudications of these courts in similar cases. Blackstone informs us that acts of Parliament that are impossible to be performed, and if there arise out of them collaterally any absurd consequences manifestly contradictory to common reason, they are, with regard to those collateral consequences, void. The same author having previously observed that the judges are the depository of the laws, the living oracles, who must decide in all cases of doubt, and who are bound by oath to decide according to the law of the land. In Bacon's abridgment we read, if a statute be against common right or reason, or repugnant, or impossible to be performed, the common law shall control it, and adjudge it to be void. Here permit me, may it please your honors, to apply the authority to the act, and see how exactly it corresponds. Is it consistent with common right or reason that any man shall be compelled to receive paper when he has contracted to receive silver, that for bread he shall receive a stone, or for fish a serpent? Is it consistent with common right or reason that he shall receive the paper, dollar for dollar with silver, when it is fully known that the discount in general is from 3 to 4 for 1 among those who receive the paper at all, and that there are very many who totally refuse it? That he should be called from his business and subjected to a fine for his refusal, when there is not a man in the state but upon principles of justice to himself and family would have done the same? Is it right or reasonable that for such refusal he should be called to trial in a summary manner, in 3 days, and that no ensuing protection, privilege, or injunction shall in any wise prayed, granted, or allowed. Suppose him to be confined to his bed by sickness, is he to be passed upon ex parte? No man is to be injured by the act of God, or by the act of the law. Suppose his witnesses are sick or absent, and cannot be procured by the time, he is not allowed even to pray for an indulgence, or if he should pray ever so fervently, he cannot be heard. Suppose him to be summoned to attend at 2, or at all the counties at the same time, upon different informations, he is still to be condemned unheard. Even suppose him to stand in need of professional assistance, but that he cannot obtain at the moment, the gentlemen of the law being all necessarily attending upon a special session of the General Assembly. Is he to be deprived of counsel? Repugnant or impossible to be performed? Is not the act repugnant when it authorizes the judges to proceed to trial without any jury, according to the laws of the land? The laws of the land constitute the jurors the triers of facts, and the judges the triers of law only, according to the known maxim, ad questionem juris respondet judices, ad questionem facti respondet judicores. How is it possible, then, that the judges should try without jury, and they are directed as well as authorized so to do? The said court shall proceed, and at the same time according to the laws of the land, when those laws direct that no man, of what estate and condition soever, shall be molested without being for it brought to answer by due course of law, nor passed upon, nor condemned, but by the lawful judgment of his peers. And contraries exist, and be executed at the same time. This act, therefore, is impossible to be executed. Here is a new office indeed, and were your honors to suffer the special jurisdictions to attempt to carry the act into effect, what inconceivable mischiefs would ensue? Is there a member of the administration, or any other, that will sell his beef, his pork, his corn, or his cheese, so as to enable the retailers and hucksters to sell those articles again for paper, at the same rate they could be afforded for silver or gold? There is not. What is the consequence? Every evil-minded person in the state is invited by law to turn informer, a most despicable office, and more than 500 prosecutions would take place in the course of a week. Horrible reflection! The idle, the profligate, the abandoned of every character, would appear in the group of prosecutors or witnesses, urged and pushed by petty conventions into signing jointos, till perjury would run down our streets like a stream, and violence like a mighty river. The judges themselves might be tempted, by the prerequisites of office, to encourage informations, until every man of industry, of business, and of property must quit the state, retire from business, give up his property, or join in an opposition of force. The temptation is great and seriously alarming, for to secure the judges individually and their personal influence, the very emitting act directs that they shall receive all monies tendered and refused for past contracts, and at the expiration of 3 months deposit them in the general treasury. What room for peculation? What inducement to corruption? What incentives to depreciate the currency? Oh, it is an abominable act. Yet some there are, and to our shame be it spoken, too many, who tend it, who nurse it, who hug it to their bosom as a darling child. But let me tell them it is a furious offspring, conceived by an unlawful convention and brought forth by, at an unguarded hour. 'Tis a monster, and as the immortal Pope expresses it upon another occasion, it is a monster of so frightful mien, as to be hated needs but to be seen. Yet seen too often, familiar with her face, we first endure, then pity, then embrace. Let us see it, therefore, but once. Let us consign it, O ye judges, to its fate. Death is in its constitution, and die it must. But to return, for I must confess the digression is not particularly directed to the point more immediately in question. We again read in Bacon's abridgment that the power of construing a statute is in the judges, for they have authority over all laws, more especially over statutes, to mold them according to reason and convenience to the best and truest use. Here the author refers to Hobart, Plowden, and Lord Coke, who fully justify the doctrine he advances. They are upon the table and will be produced, if your honours require it. But we presume it would be only trespassing upon your patience, too much exhausted already by a tedious discussion. The satisfaction you are pleased to express upon this head enables us to pursue the subject in another point of view. Perhaps there is not a civilized country on earth where so small a portion of natural liberty is given into the stock of political society as by the people of this state. There is a certain period in every year when the powers of government seem to expire, for the authority of the old officers ceases with the appointment of the new, and these cannot act until they are commissioned and sworn. The legislative of one house being composed of new members, or members newly elected twice in the year, feels and carries into effect the sentiments of the people, founded upon the extremes of liberty. The electors in the respective towns have generally some point to obtain, or, which is more unfriendly to public liberty, they are divided by parties, and so the members elected become the advocates of local interested measures, without comparing them with the more extensive objects of the community. The sessions seldom exceed the limits of a week. New laws are proposed, acted upon, and adopted, according to the first or the preconcerted impressions of passion, without time for deliberation or reflection. The upper house, it is true, had the negative upon the House of Deputies, but they never persist in exercising it without endangering their next election. The appointment of judges, justices of the peace, and other officers of government, being made by the members of both houses in a grand committee, is very often the result of political arrangements, and more attention is paid to the carrying of certain points than to the qualification of the candidates, so that the people feel no great restraint from this quarter. What is there, then, in the nature of our government, to prevent anarchy and confusion on the one hand, or tyranny and oppression on the other? Before the Revolution, the king, as supreme executive, formed the balance, but since the executive power hath become blended with the legislature, and we have not, like the other states in the Union, adopted any substitute for this defect. The moment, therefore, that this court feels itself dependent upon the legislature in the exercise of its judiciary powers, there will be an end of political liberty. For there is not an individual of mankind but wishes, if possible, to be exempt from the compacts that bind others, and there may be conjunctures in which the love of natural liberty will bid defiance to the restraints of law. If the legislature are blindly guided by the general impulse, or should these attachments be more strongly fixed to the interest of a few designing men than to the public wish, tyranny would spring out of anarchy. In either case, the interposition of the judiciary may save the Constitution, at least for a time, and by averting the immediate evil, will give scope for reflection, and so prevent a dissolution of government. It is extremely to be regretted that this court is not as independent in the tenure by which the judges hold their commissions as they are in exercise of the judicial proceedings. The frequent changes that arise from annual appointments may have an influence upon legal decisions, and so destroy that uniformity which is essentially requisite to the security of individuals. But from these considerations we have nothing to fear upon the present occasion, for the knowledge, the integrity, the firmness of the bench will rise superior to every obstacle, and the dignity of their determinations will display a luster awful even to tyranny itself. To this honorable court the warmest thanks of the defendant, of this assembly, of every citizen, are due for their solicitous attention to their unalienable rights. Their expectations, their joyous hopes await your determination, and we all pray to heaven that before tomorrow's sun shall deck the western sky, our hopes may wanton in complete enjoyment. Then every generous breast shall glow with purest flame of gratitude, and fathers anxious for the public good relate the glorious deed to their attentive sons, who will venerate the names of those immortal five who nobly dared to save our dying laws. I cannot further pursue the subject, but must come to a conclusion. We have attempted to show that the act upon which the information is founded has expired, that by the act special jurisdictions are erected, incontrollable by the Supreme Judiciary Court of the state, and that by the act this court is not authorized or empowered to impanel a jury to try the facts connected in the information, that the trial by jury is a fundamental, a constitutional right, ever claimed as such, ever ratified as such, ever held most dear and sacred, that the legislature derives all its authority from the Constitution, has no power of making laws but in subordination to it, cannot infringe or violate it, that therefore the act is unconstitutional and void, that this court has power to judge and determine what acts of the General Assembly are agreeable to the Constitution, and on the contrary, that this court is under the most solemn obligations to execute the laws of the land, and therefore cannot, will not, consider this act as a law of the land. O ye judges, what a godlike pleasure must you not feel in having the power, the legal power of stopping the torrent of lawless sway, and securing to the people their inestimable rights. Rest, ye venerable shades of our pious ancestors, our inheritance is yet secure. Be at peace, ye blessed spirits of our valiant countrymen, whose blood has just streamed at our sides to have a sinking land. When the tear is scarcely wiped from the Virgin's eye, lamenting an affectionate father, a beloved brother, or a more tender friend, while the matron still mourns and the widow bewails her only hope, while the fathers of their country, superior to the ills of slaughter, are completing the mighty fabric of our freedom and independence, shall the decision of a moment rob us of our birthright, and blast forever our noblest prospects? Forbid it, thou great legislator of the universe. No, the stars shall fade away, the sun himself grow dim with age, and nature sink in years. But thou, fair liberty, shall flourish in immortal youth, unhurt amidst the war of elements, the wreck of matter, and the crush of words. The judgment, September 17th. The court unanimously decided that the information was not cognizable before them. Footnote: Mr. Updike, Memoirs of the Rhode Island Bar, states the judgment of the court to have been that the amended acts of the legislature were unconstitutional and void, and the General Assembly on their records refer to the court as having declared and adjudged an act of the Supreme Legislature of this state to be unconstitutional and so absolutely void. But the judgment of the court appears to have been simply that the information was not cognizable before them. See Varnum's report, ante, page 550, and also the distinction taken by Mr. Justice Howell, post, page 586, to Chand American Criminal Trials 326. End of footnote. End of section 62. Section 63 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Proceedings of the General Assembly of Rhode Island against the judges of the Supreme Court for their judgment in the case of Trevett against Wheeden, Newport, Rhode Island, 1786, Part 1. The narrative. The friends of sound money were delighted at the decision of the court, ante, page 583, and amazed at the independence of a tribunal elected annually. But Trevett and his friends, deeply disappointed and enraged, left the courtroom muttering threats of vengeance against the judges, and the legislature itself learned the results with mortification and chagrin. A special session was called, and on the first day a summons was issued from both houses, requiring an immediate attendance of the judges to assign their reasons for adjudging an act of the supreme legislature of the state unconstitutional and so absolutely void. 2 of the judges came, but the other 2 being ill, the matter was postponed for a fortnight. At that time the Chief Justice was still ill, but the other judges appeared and made lengthy speeches defending their action. The Assembly then debated the question whether it was satisfied with the reasons given by the judges in support of their judgment, and voted no. A motion was made to dismiss the judges from their office, but before it was put, a memorial signed by the 3 judges was received, demanding a right to a trial and to counsel. The Assembly agreed to the latter request, and Mr. Barnum, the counsel for the butcher, addressed them, whereupon it was moved and carried that the opinion of the Attorney General and the lawyer members of the Assembly be heard as to whether the judges could be removed from office without a trial. The Attorney General and several legal members having expressed their opinion in the negative, it was resolved by a large majority that the judges had given no satisfactory reasons for the judgment in Trevett against Wheeden, but as they had not been charged with any offense, they were hereby discharged from any further attendance upon the Assembly. This was the last of this famous controversy, as the laws which gave rise to it were soon afterwards repealed. The Proceedings. Before the General Assembly of the State of Rhode Island, Newport, October 1786, September 26th, a summons having been issued from both houses of Assembly, requiring the immediate attendance of the judges of the Supreme Court to render their reasons for adjudging an act of the General Assembly unconstitutional and so void. 2 of the judges attended today, the others being too unwell. Thereupon the Assembly postponed the hearing for a fortnight. October 10th, Judges Hazard, Tillinghast, and Howell appeared today, the Chief Justice being ill, and gave notice in writing to both houses that they awaited their pleasure. The Assembly informed them that it was ready to receive and hear them, and certain ceremonies having been adjusted and the records of the court produced, the judges were asked to speak. The defense of the judges. Judge Howell said in the first place that the order by which the judges were before the House might be considered as calling upon them to assist in matters of legislation, or to render the reasons of their judicial determination as being accountable to the legislature for their judgment. In the former point of view, the court were ever ready, as constituting the legal counselors of the state, to render every kind of assistance to the legislature in framing new or repealing former laws, but for the reasons of their judgment upon any question judicially before them, they were accountable only to God and their own consciences. He then pointed out the objectionable parts of the act upon which the information was founded, and argued that it was unconstitutional, had not the force of a law, and could not be executed. But he denied that the judges were accountable to that tribunal for the reason of their judgment. In the first place, the legislature had assumed a fact in their summons to the judges, which was not justified or warranted by the records. The plea of the defendant in a matter of mere surplusage mentions the act of the General Assembly as unconstitutional and so void, but the judgment of the court simply is that the information is not cognizable before them. Hence it appears that the plea has been mistaken for the judgment. Whatever might have been the opinion of the judges, they spoke by their records, which admitted of no addition or diminution. They might have been influenced respectively by different reasons, as the whole act was judicially before them, of which, it being general, they could judge by inspection, without confining themselves to the particular points stated in the plea. It would be out of the power, therefore, of the General Assembly to determine upon the propriety of the court's judgment without a particular explanation. If this could be required in one instance, it might in all, and so the legislature would become the supreme judiciary, a perversion of power totally subversive of civil liberty. If it be conceded that the equal distribution of justice is as requisite to answer the purpose of government as the enacting of salutary laws, it is evident that the judiciary power should be as independent as the legislative, and consequently the judges cannot be answerable for their opinion unless charged with criminality. The nature of their office obliges them to decide upon every question that can arise in legal process. If they are not directed by their own understanding, uninfluenced by the opinion of others, how can they be said to judge at all? The very act of judging supposes an assent of the mind to the truth or falsehood of a proposition, and if a decision is given contrary to this assent, the judge is guilty of perjury and ought to be rendered infamous. Every man is excusable for errors of the head, provided sufficient attention has been paid to the means of information. But no man is excusable for depravity or corruption of the heart. The judges may err, for error is the lot of humanity. Perfection cannot be required of imperfect beings, but the very idea of being accountable to the legislature in matters of opinion supposes the legislature to possess the standard of perfection, a thought highly derogatory to the attributes of deity. Baron Montesquieu, in his Spirit of Laws, observes, "There is no liberty if the judiciary power be not separated from the legislative and executive. Were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, but the judge would then be the legislator. Were it joined to the executive power, the judge might behave with violence and oppression. There would be an end to everything, were the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and of trying the causes of individuals." Blackstone, in his commentaries, adopted the same ideas. Sergeant Hawkins is precise and conclusive, that no such judge is in any way punishable for a mere error of judgment, and as the law has exempted jurors from the danger of incurring any punishment in respect of their verdict in criminal causes, it has also freed the judges of all courts of record from all prosecutions whatsoever, except in the Parliament, for anything done by them openly in such courts as judges. For the authority of a government cannot be maintained unless the greatest credit be given to those who are so richly entrusted with the administration of public justice, and it would be impossible for them to keep up in the people that veneration of their persons and submission to their judgments, without which it is impossible to execute the laws with rigor and success. If they should be continually exposed to the prosecutions of those whose partiality to their own causes would induce them to think themselves injured, yet if a judge will so far forget the dignity and honor of his post as to turn solicitor in a cause which he is to judge, and privately and extrajudicially tamper with witnesses or label jurors, he has no reason to complain if he be dealt with according to the same capacity to which he so basely degrades himself. Comparing these passages together, the intention of the author is apparent, that, in the first place, the judges are not answerable at all for mere error of judgment, and in the second, they are triable only in Parliament for matters of a criminal nature. The same point is fully asserted in Bacon. But though they are to judge according to the settled and established rules and ancient customs of the nation, approved for many successions of ages, yet are they freed from all prosecutions for anything done by them in court, which appears to have been an error of their judgment. So tender and delicate is the law in this respect, that even justices of the peace are sacredly guarded from every kind of prosecution upon account of their opinion. Upon the 10th of May, 1757, a motion was made in the King's Bench for an information against 2 justices of the peace for arbitrarily, obstinately, and unreasonably refusing to grant a license to one Henry Day to keep an inn at Eversley, where it was alleged and sworn to be fit and proper, and even necessary, that there should be an additional one, there being one there already, and for which occupation of keeping an inn this man was, as those 2 justices themselves had allowed on a former occasion, a proper person, they having before licensed him to do so at another place. Lord Mansfield and Mr. Justice Tennyson held that notwithstanding this was a matter left in great measure to the discretion of the justices, yet if it appeared to the court, from sufficient circumstances laid before them, that their conduct was influenced by partial, corrupt, or arbitrary views, instead of exercising a fair and candid discretion, the court might call upon them to show the reasons whereby they guided their discretion. The justices thus entrusted have a right to judge for themselves. No man can judge for another, and this power is entrusted to them by the Constitution, by the legislature. It may be very dangerous to them to be obliged to give their reasons publicly, though they may have very sufficient ones to satisfy their own minds, and to direct their own judgments, and if they are thus entrusted, why are they liable to be called to an account by any other jurisdiction, unless they act faultily and wilfully wrong? Indeed, if they do wilfully wrong, let them be punished, but where they act quite conscientiously, they are not accountable to anybody. But if it clearly appear that the justices have been partially, maliciously, or corruptly influenced in the exercise of this discretion, and have, consequently, abused the trust reposed in them, they are liable to prosecution by indictment or information, or even possibly by action, if the malice be very gross and injurious. If their judgment is wrong, yet their heart and intention pure, God forbid that they should be punished. Judge Tillinghast said that nothing could have induced the gentlemen of the court to accept the office to which they were appointed, but a regard to the public good, that their prerequisites were trifling, and their salaries not worth mentioning. The only recompense they expected or could receive was a consciousness of rectitude, which had supported them, and he was confident would support them, through every change of circumstances. Melancholy indeed would be the condition of the citizens if the supreme judiciary of the state was liable to reprehension, whenever the caprice or the resentment of a few leading men should direct the public inquiry. As one member of the court, he felt himself perfectly independent while moving in the circle of his duty, and however he might be effective for the honor of the state, he was wholly indifferent about any consequences that might possibly respect himself. The opinion he had given resulted from mature reflection and the clearest conviction. His conscience testified to the purity of his intentions, and he was happy in the persuasion that his conduct met the approbation of his God. Judge Hazard: my brethren have so fully declared my sentiments upon this occasion that I have nothing to add by way of argument. It gives me pain that the conduct of the courts seems to have met the displeasure of the administration, but their obligations were of too sacred a nature for them to aim at pleasing, but in the line of their duty. It is well known that my sentiments have fully accorded with the general system of the legislature in emitting the paper currency, but I never did, I never will, depart from the character of an honest man to support any measures, however agreeable in themselves. If there could have been a prepossession in my mind, it must have been in favor of the act of the General Assembly, but it was not possible to resist the force of conviction. The opinion I gave upon the trial was dictated by the energy of truth. I thought it was right. I still think so. Be it as it may, we derived our understanding from the Almighty, and to him only are we accountable for our judgment. The question considered, October 11th. A debate took place among the members of the Assembly, and the question being stated whether the Assembly was satisfied with the reasons given by the judges in support of the judgment. It was decided in the negative. A motion was made to dismiss the judges from their office, but before the question was taken on this motion, the following memorial signed by the 3 judges was read. To His Excellency the Governor, and His Honor the Speaker of the Lower House of Assembly, to be communicated to both houses. The underwritten, appointed justices of the Supreme Court, etc., at the annual election in May last, for the term of the current year, and cited to appear before the General Assembly at their present session, by an order, therefore, passed at their last session, specially convened in the city of Newport, to render the reasons of a certain judgment given by said court at the last term thereof in the county of Newport. Having appeared before both houses in a grand committee, and made full communication of all the proceedings of the court relative to the case in which said judgment was rendered, and having entered into a full and free examination of the several parts and principles of the penal law in question, and compared them with the Constitution or fundamental laws of the state and other laws operating thereon, which secure to the citizens thereof their rights and privileges, and having established their observations thereon by many the most approved authorities in law, as well as by the Constitution and doings of the Federal Union, and the members thereof, since the Revolution in this country, for the advice and assistance of the General Assembly in point of legislation, concluded by utterly denying the power of the legislature to call upon them for the particular reasons of their judgment in that or any other case, and declining to render the same, alleging and maintaining by arguments and authorities of law that for the same they are accountable only to God, under the solemnities of their oath of office and to their own consciences, and while, to remove misapprehensions, they disclaim and totally disavow any, the least power or authority, or the appearance thereof, to contravene or control the constitutional laws of the state, or acts of the General Assembly. They conceive that the entire power of construing and judging of the same, in the last resort, is vested solely in the supreme judiciary of the state, and whereas, in the citation aforesaid, no charge is contained against the underwritten in their aforesaid capacity, nor had they reason to apprehend any proceedings were to be grounded thereon, to affect their lives, liberties, or property, or their estate in their office aforesaid, or their good name and character as officers of this state, and whereas from appearances there is reason to apprehend that a design is formed and ripening for execution by a summary vote of the legislature, either to dismiss them from their aforesaid office or to suspend them from the power of exercising the same. Wherefore, they pray that they may have a hearing by counsel before some proper and legal tribunal, and an opportunity to answer to certain and specific charges, if any such can be brought against them, before any sentence or judgment be passed, injurious to any of their aforesaid rights and privileges, and this they claim and demand as freemen and officers of this state, and at the same time, with deference, utterly protest against the exercise of any power in the legislature by a summary vote to deprive them of their right to exercise the functions of their aforesaid office without the aforesaid due process of law, or a commencement thereof, in which latter case a suspension only from the duties of office can take place, before the full term for which they were appointed and engaged under the Constitution of the state shall be completed, and more especially upon a mere suggestion of a mere error of judgment. The memorial having been received, the judges informed the Assembly that they wished to be heard by counsel. End of section 63. Section 64 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Proceedings of the General Assembly of Rhode Island against the judges of the Supreme Court for their judgment in the case of Trevett against Wheeden, Newport, Rhode Island, 1786, Part 2. James M. Varnum, who had argued the case upon which the court had pronounced the judgment complained of, was permitted to address the House in defense of the court. Mr. Varnum said that the necessity of exhibiting the memorial upon the table arose from the motion last made by one of their honorable members for dismissing the judges from office without any previous charge of criminality. A measure so novel as this motion tended to produce could not have been foreseen or expected, and therefore it would not be thought strange if the council was not fully prepared to meet and oppose it. What do the judges pray for? That if they are to be passed upon for anything respecting their duty, they may first know for what offense they are to be judged, that the particular charge or charges may be specified, that they may have time for defense, that they may be heard before a tribunal legally constituted, and that they may be heard by counsel. Is there a gentleman in this assembly so inattentive to the rights of his constituents as to refuse upon this occasion what the lowest peasant, nay, the vilest criminal is entitled to receive? I presume there is not. And notwithstanding many of them may suppose that the honor of the legislature is wounded by the decision of the court, and so would wish to restore it, even by sacrificing the judges. Yet I am confident they will not incur the imputation of real disgrace by removing the barriers to personal security and the preservation of property. For if they would preserve in the minds of the citizens an attachment to their measures, and a veneration for their laws, they certainly will not openly violate the laws themselves. Be pleased to recollect a paragraph in our Declaration of Rights, our Magna Carta, wherein it is provided that no man, of what estate and condition soever, shall be put out of his lands and tenements, nor taken, nor imprisoned, nor disinherited, nor banished, nor any ways destroyed, nor molested, without being for it brought to answer by due course of law. If it were in the power of the General Assembly to nullify this part of our Constitution, which we utterly deny, they have not done it. The right is still guarded by all the solemnities of law, and therefore the honorable remonstrants claim and demand its benefits. This they do from your honors, not as a legislative, but as acting in a judicial capacity. For the passing of sentence is the exercising a judiciary power, grounded upon a pre-existing law. You are bound then by that oath, to which you all submitted as a necessary qualification, previously to your becoming members, and which is in these words, and you do further engage equal right and justice to do to all persons that shall appeal unto you for your judgment in their respective cases. It is perfectly immaterial upon the present argument whether the judgment of the court was right or wrong, whether it was agreeably to law or against law. The only question is whether they can, in any respect, be brought to answer for it, but by due course of law, and consequently whether they can be passed upon and condemned until they be proven guilty of a crime. The tenure by which all commissions are held in this state is for the space of 1 year. Consequently, during that term, every officer has an interest, a kind of estate, inseparably annexed to his appointment, to be divested of which he must either neglect, misuse, or abuse his trust, so as to work a forfeiture. This neglect, misuse, and abuse include questions of fact which must appear, either by the confession of the party or by proof, before the forfeiture can be declared. But how can the facts appear to be true or false without an impartial and candid examination? And how can such examination take place until the facts or charges are particularly stated and the party accused have an opportunity of making defense in such way as he shall deem most beneficial to himself? Suppose he should deny the facts, he must certainly be presumed innocent until the contrary appear. How shall the contrary appear but by producing evidence, oral or written? If oral, has he not a right to cross-examine the witnesses, to disqualify them, or produce others to disprove their testimony, either by destroying their credibility or proving some other proposition totally inconsistent with that asserted by them? Or, if the evidence be written, has he not a right to suggest and establish alteration, diminution, or even forgery itself? In short, can there exist, in contemplation of law, the possibility of an accusation that cannot be controverted and proved to be groundless? If the judges held their commissions during the pleasure of the General Assembly, then indeed they might be removed without the formalities of a trial. But even in that case, the exercise of so high a prerogative, without some kind of suggestion and proof, would be deemed injurious and oppressive. In the present case, however, wherein the judges cannot be molested, but by being called to answer for some crime, by due course of law there is not even a suggestion that they have intentionally departed from the line of their duty. Then are they secured in their posts during the term of their appointment, in as sacred a manner as the property of any individual is guarded against the encroachments of a rapacious neighbor. They stand upon the firm ground of rectitude and independence. If any man has any accusation to exhibit, let him come forth. Let him produce the list of his charges. They are willing to meet him, but they will meet him only upon due and legal process, and before a court lawfully qualified to try them. Should no such accusation be made, what remains but that the judges be immediately discharged from any further attendance upon this assembly. Should they be impeached, I pledge myself to show that they cannot be tried by this honorable assembly. But if a contrary sentiment should prevail, I must request time, till the next session, to be prepared with arguments and authorities, to establish a doctrine so important in its consequences. Permit me, however, for the present, to observe that in England, the judges are appointed by the king as the supreme executive. Their commissions are during good behavior, and therefore they are not triable by the king, but by the parliament only, and upon impeachment. Were they to be tried by the king who appoints them, their judgments might be influenced by his authority, and so the channels of justice would be corrupted. Besides, the king is the party accusing, and consequently cannot be the judge, for the very act of complaining presupposes an opinion that the party complained of is guilty. Hence it is that the grand jurors, who make presentment, are disqualified ultimately to decide upon the fact. In this case, the judges are appointed by both houses of assembly in a grand committee. In this respect they resemble the king, and therefore cannot try the judges upon a criminal charge. In the present instance, both houses of assembly are the party complaining. In this respect also they resemble the king, and so cannot be the triers. For with deference to the legislators present, there may be an assembly whose interested views might induce them to establish systems totally subversive of the Constitution and of political as well as civil liberty, to effect which the supreme judiciary must be the creatures of their power, and such creatures they would finally be, were the judges to be appointed, accused, and tried by them. Let the human heart, and as I have the honor of addressing myself to some who profess, and even attempt to teach the doctrines of Christianity, the conscience also be consulted upon this question. Should not the parties litigant be equally indifferent to the judge Who is to decide upon their controversy? Why is it that jurors may be challenged and removed for favor, but that the mind should be perfectly unbiased and open to the reception of truth? Why, like Caesar's wife, should they be incapable of being suspected unless that the parties themselves might feel a perfect confidence in their judges? Can that confidence be placed upon this occasion? Has not the matter been taken up rather in a political than in a juridical point of view? I do not assert, but has it not been determined in the conventional part of the members to remove the judges and appoint others who will execute, at all events, the penal acts? Has not one town in particular proceeded so far as to instruct its deputies to use their utmost influence in bringing the judges to punishment? Can these members be considered as impartial triers? Is it possible to suppose but that the influence of the constituents will have some weight in forming their opinion? Can they be objected to as having prejudged the cause? If they cannot, is there not a moral certainty of condemnation? If they can, will not the objection be so far extended as to prevent the possibility of a legal decision? Be entreated, therefore, O ye guardians and protectors of the people, seriously to reflect upon the magnitude of the present question and the important events that may result from your determination. The great judge of all the earth, can he do wrong? A being's rational, he requires the heart, and as a man believeth in his conscience, so is he. Submit then to the heavenly standard, and as the judges have acquitted themselves conscientiously in the sight of God and man, add to the general plaudit which shall waft their names upon the wings of immortal fame to the latest posterity. The decision. A motion was made and agreed to that the opinion of the Attorney General be taken, and the sentiments of the other professional gentlemen requested, whether constitutionally and agreeably to law, the General Assembly could suspend or remove from office the judges of the Supreme Judiciary Court without a previous charge and statement of criminality, due process, trial, and conviction thereon. William Channing, Attorney General, observed that as it was at all times his duty, so he derived a peculiar pleasure in rendering to the legislature every legal assistance in his power. Footnote: Channing William, 1751 to 1793. Born Newport, graduated Princeton 1769. Studied law with Oliver Arnold at Providence. Called to the bar 1771. He filled many honorable offices in Rhode Island. Attorney General 1777 to 1787, 1791 to 1793. He lost his election in 1787 in consequence of his opposition to the paper money laws. United States District Attorney 1791 to 1793. He was an able advocate. One of his 11 children was William Ellery Channing, D.D. End of footnote. He had attended the trial upon the information, without any bias or partiality upon his mind, and was happy in the conviction that the whole conduct of the judges upon that interesting occasion demonstrated the greatest candor and uprightness, and according to his private opinion, their determination was conformable to the principles of constitutional law. But, be their judgment agreeably to law or not, confident he was that there would be a fatal interruption, if not annihilation, to government, if they could be suspended or removed from office for a mere matter of opinion, without a charge of criminality. How that charge should be preferred and conducted, he did not presume to decide, as it might possibly be the subject matter of an after question, and was not contained in the present order. Mr. Bradford informed the House that he was not present at the trial in Newport, nor had he attended to the proceedings of the legislature respecting the judges, excepting so far as related to the citation and the memorial upon the table, Till then, he never doubted but the General Assembly were vested with constitutional authority to try and remove any officer by them appointed for any malpractices in his office, but from the observations that had been made, he very much doubted the propriety of his former opinion. One point, however, was clear and certain, that as the judges were commissioned and sworn for the term of a year, they could not be deprived of their powers during that term, but by regular impeachment, in which the charges against them must be particularly stated, a trial in which they would have an undoubted right for time to prepare their defense and to be heard by counsel, and condemnation upon full proofs of the charges. Footnote: Bradford William, 1729 to 1808, born Plimpton, Massachusetts, studied medicine and commenced practice in Warren. Removed to Bristol after several years and studied law. Deputy Governor of the state 1775 to 1778. For many years Speaker of the General Assembly. Senator to Congress 1792. In 1751 married Mary LeBaron of Plymouth. Trustee, Brown University 1785 to 1808. End of footnote. In the proceedings now before the House, there was not a charge or the appearance of one against the court, to which they could in any manner be held to answer. He was really astonished that so much time should be taken up in needless inquiries and fruitless altercations. He had been honored with the seat in one or other of the houses of the Assembly for upwards of 30 years, and could not recollect a period in which harmony and unanimity were more essentially wanting than at the present time. The people of this state had been well governed. They had been a happy people, and might still be as happy as any on earth, if all party contentions could be laid aside, and everyone strived to soothe the cares and heal the wounds of his neighbors. He entreated the members to embrace the present moment, in which there seemed to be a spirit of conciliation, to put an end to all further contentions among themselves, but what might arise for the sake of information. And, as they regarded the honor, the peace, and the safety of the state, that they would discharge the judges from any further attendance, and apply themselves in earnest, and with one mind, to such measures as would render them happy at home, and respectable abroad. Mr. Helms said that the subject was new, and he was not fully prepared to give an opinion. Footnote: Helm Rouse J., son of James Helm, judge at the Colonial Common Pleas Court, practiced law in South Kingston, Secretary to General Assembly 1776 to 1777, member of Rhode Island Assembly 1778, 1786, and 1788. Died 1789 at New Shoreham. End of footnote. But at present he inclined to think that there was no constitutional law by which the question could be solved. It must therefore be in the breast of the General Assembly to point out the mode of trial by an act for that purpose, should a trial be thought necessary. If they should proceed to try the judges, either by themselves or a court to be specially appointed for that purpose, they must cause them first to be impeached, and state the facts particularly upon which the impeachment is founded. The common law would direct the manner of process, and should they be found guilty, they could not be removed from their office, but by a bill, in nature of a bill of attainder, which must pass both houses and be enacted into a law. Mr. Goodwin fully acquiesced in the opinions already given. Footnote: Goodwin Henry, 1750 to 1789, born Boston, educated at Harvard, studied law and opened an office at Taunton, afterwards removed to Newport, Attorney General 1787. He was patronized by the paper money party, and they made him Attorney General of the state, but he would not go all lengths with them, and they withdrew their patronage. He died at Bristol. End of footnote. The matter was further discussed by Henry Marchant and Benjamin Bourne, who defended the positions taken by the Attorney General. Footnote: Bourne Benjamin, first representative to Congress under the Constitution, afterwards a circuit judge of the United States. End of footnote. It was resolved by a very large majority that the 3 judges, having been fully heard before the Assembly, had rendered no satisfactory reasons for their judgment in the case of Trevett against Wheeden. But as they were not charged with criminality in giving their judgment, they be discharged from any further attendance upon the Assembly on that account. Footnote: Mumford Paul, 1734 to 1805, born South Kingston, Rhode Island, graduated Yale 1754, 1786, A.M., settled in Newport, Representative General Assembly 1774, removed to Barrington, Massachusetts when British occupied Newport, member Council of War, Deputy in General Assembly from both places, Judge Common Pleas, Bristol County, 1777, Judge Superior Court, 1778, Member Upper House, 1779 to 1781, Chief Justice Rhode Island, 1781 to 1785, 1786 to 1788, State Senator, 1801 to 1803, Lieutenant Governor, 1803 to 1805, Hazard Joseph, 1728 to 1790, born South Kingston, Rhode Island, Deputy from there, 1756, Lieutenant Colonel of Militia, Kings County, Associate Justice Supreme Court, 1786. End of footnote. End of section 64. Section 65 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Case of breach of neutrality by citizens of the United States. Richmond, Virginia, 1793, Part 1. The narrative. A large majority of the American people heartily sympathized with the French Revolution, though Alexander Hamilton and many of the Federalists were shocked at the excesses of the Jacobins. Thomas Jefferson wrote, "Rather than it should have failed, I would have seen half the earth desolated," and the whole country was for a time filled with enthusiasm for the new French Republic, when in the spring of 1793, Citizen Gannett landed at Charleston as its first minister to the United States. The people went wild. Footnote: Gannett William Charles, 1765 to 1834, born Versailles, France, known as Citizen Gannett, for the French had abolished all titles except citizen and citizeness, was recalled in 1794, but never went back to France. His friends, the Girondins, had fallen from power, and the leaders had been guillotined by the Jacobins. He became an American citizen, married a daughter of Governor Clinton, settled on the Hudson, became a scientific farmer, and died at his home there. He was only 28 when he arrived in America, but had already made a name for himself in annexing Geneva to the French Republic. End of footnote. In Philadelphia, a great banquet was held in his honor, and the head of a roast pig was named Louis XVI, passed around the table to each guest, who plunged his knife into it while uttering some sentiment about liberty and the rights of man. The French craze was everywhere, and Americans of every class imitated the revolutionists in Paris by wearing the cockade, erecting liberty poles and dressing men as citizen and women as citizeness. An important part of Citizen Gannett's mission was to ask the United States to join France in the war just declared between the Republic and Great Britain and other European states. France had reason to expect this, for she had helped to win our independence and by a treaty between the two countries made at the close of that war, we had guaranteed forever the French possessions in America. Each country had agreed to shelter in its ports the privateers and prizes of the other, and that no other country should have the right to fit our ships in the ports of France or the United States. Genet proceeded at once to commission every French consul in the United States as a court of admiralty to try and condemn such prizes as French cruisers might bring into port to fit out privateers in our chief harbors. But President Washington was determined that the country should take no hand in European wars, and he at once issued the first neutrality proclamation that the country had known. In it, he called on all good citizens to take no part in aiding or abetting either of the belligerent powers, warning them if they did, they would be prosecuted to the full extent of the law. Washington's position was most unpopular. The Republican Party not only took the side of Genet against the administration, but its newspapers attacked his character most violently, charging that he had sold himself to the English, and for the first time the popularity of Washington suffered a partial eclipse. But he was immovable, for he saw that the position of the new nation in the affairs of the world must be established at the outset, and he was convinced that the Republic would be short-lived if it did not absolutely refuse to take any hand in the political quarrels and wars of Europe. As to the Treaty of 1778, that he argued was made with the French king, who had been guillotined and had no successor, and as a treaty of alliance should be construed to refer only to defensive wars, and France was raging an offensive war. Chief Justice Jay was sent to Richmond to declare to the country the law on the subject, but the first prosecution which took place in the state of Pennsylvania failed utterly. This charge, though it was not delivered to the particular grand jury by whom the first indictment for violation of American neutrality was found, yet was prepared by the Chief Justice of the United States as a notice to the citizens of the country and as a guide to the prosecuting officers and courts throughout the Republic. The Proceedings in the Circuit Court of the United States, Middle District of Virginia, Richmond, May 1793. Footnote: this prosecution, which is always cited as the earliest case on the subject of the common law jurisdiction of the federal courts, and was considered of so much importance by General Washington as to justify a special meeting of Congress, and by Mr. Jefferson as to require a distinct explanation to the British government, is now for the first time reported. The charges of Chief Justice Jay and Judge Wilson were printed by the government for the purpose of explaining abroad the position of the United States, but they have never yet been published to the public. Dr. Wharton, however, among the papers of Dr. Rawle, who, as district attorney, conducted the prosecution, and those of Mr. Duponceau, who, with Mr. Sargent and Mr. Ingersoll, were counsel for the defense, was able to find a complete report. Wharton, State Trials, Post, page 616, end of footnote. May 22nd, Chief Justice Jay. Footnote: J. John, 1745 to 1829, born New York City, Delegate Continental Congress, 1774 to 1777, Chief Justice New York, 1777 to 1779, President of Congress, Secretary of State, Chief Justice Supreme Court of the United States, 1789 to 1794, resigned to accept the mission to England, where he negotiated the Jay Treaty, Governor of New York, 1795 to 1801. End of footnote. Gentlemen of the grand jury, that citizens and nations should use their own as not to injure others is an ancient and excellent maxim, and is one of those plain precepts of common justice, which it is the interest of all, and the duty of each to obey, and that not only in the use they may make of their property, but also of their liberty, their power, and other blessings of every kind, to restrain men from violating the rights of society and of one another, and impartially to give security and protection to all, are among the most important objects of a free government. I say a free government because in those that are not free, those objects being in certain respects secondary to others, are less regarded and less perfectly provided for. Where the conduct of the citizens is regulated by the laws made by themselves and for their common benefit, and executed by men deriving authority from and responsible to them, the most regular and exact obedience to those laws is to be expected, required, and rendered. By their Constitution and laws, the people of the United States have expressed their will, and their will so expressed must sway and rule supreme in our republic. It is in obedience to their will, and in pursuance of their authority, that this court is now to dispense their justice in this district, and they have made it their duty, gentlemen, to inquire whether any and what infractions of their laws have been committed in this district, or on the seas, by persons in or belonging to it. Proceed, therefore, to inquire accordingly, and to present such as either have or shall come to your knowledge, that you may perceive more clearly the extent and objects of your inquiries. It may be proper to observe that the laws of the United States admit of being classed under three heads of descriptions. First, all treaties made under the authority of the United States. Second, the laws of nations. Third, the Constitution and statutes of the United States. Treaties between independent nations are contracts or bargains which derive all their force and obligation from mutual consent and agreement, and consequently, when once fairly made and properly concluded, cannot be altered or annulled by one of the parties without the consent and concurrence of the other. Wide is the difference between treaties and statutes. We may negotiate and make contracts with other nations, but we can neither legislate for them, nor they for us. We may repeal or alter our statutes, but no nation can have authority to vacate or modify treaties at discretion. Treaties, therefore, necessarily become the supreme law of the land, and so they are very probably declared to be by the 6th article of the Constitution. Whenever doubts and questions arise relative to the validity, operation, or construction of treaties, or of any articles in them, those doubts and questions must be settled according to the maxims and principles of the laws of nations applicable to the case. The peace, prosperity, and reputation of the United States will always greatly depend on their fidelity to their engagements, and every virtuous citizen, for every citizen is a party to them, will concur in observing and executing them with honor and good faith, and that, whether they be made with nations respectable and important, or with nations weak and inconsiderable, our obligation to keep our faith results from our having pledged it, and not from the character or description of the state or people, to whom neither impunity nor the right of retaliation can sanctify perfidy. For although perfidy may deserve chastisement, it can never merit imitation. 2. As to the laws of nations, they are those laws by which nations are bound to regulate their conduct towards each other, both in peace and war. Providence has been pleased to place the United States among the nations of the earth, and therefore all those duties as well as rights which spring from the relation of nation to nation have devolved upon us. We are, with other nations, tenants in common of the sea. It is a highway for all, and all are bound to exercise that common right, and use that common highway in the manner which the laws of nations and treaties require. On this occasion, it is proper to observe to you, gentlemen, that various circumstances and considerations now unite in urging the people of the United States to be particularly exact and circumspect in observing the obligation of treaties and the laws of nations, which, as has been already remarked, form a very important part of the laws of our nation. I allude to the facts and injunctions specified in the President's late proclamation. It is in these words: whereas it appears that a state of war exists between Austria, Prussia, Sardinia, Great Britain, and the United Netherlands of the one part, and France of the other, and the duty and interest of the United States require that they should, with sincerity and good faith, adopt and pursue a conduct friendly and impartial towards the belligerent powers. I have, therefore, thought fit by these presents to declare the disposition of the United States to observe the conduct aforesaid towards those powers respectively, and to exhort and warn the citizens of the United States carefully to avoid all acts and proceedings whatsoever, which may in any manner tend to contravene such disposition. I do hereby make known that whosoever of the citizens of the United States shall render himself liable to punishment or forfeiture under the law of nations by committing, aiding, or abetting hostilities against any of the said powers, or by carrying to them those articles which are deemed contraband by the modern usage of nations, will not receive the protection of the United States against such punishment or forfeiture, and further, that I have given instructions to those officers to whom it belongs to cause prosecutions to be instituted against all persons who shall, within the cognizance of the courts of the United States, violate the law of nations with respect to the powers at war or any of them. By this proclamation, authentic and official information is given to the citizens of the United States that war actually exists between the nations mentioned in it, that they are to observe a conduct friendly and impartial towards the belligerent powers, that offenders will not be protected, but on the contrary, prosecuted and punished. The law of nations considers those as neutral nations who take no part in the war, remaining friends to both parties and not favoring the arms of one to the detriment of the other, and it declares that a nation desirous safely to enjoy the conveniences of neutrality is in all things to show an exact impartiality between the parties at war. For should he, when under no obligation, favor one to the detriment of the other, he cannot complain of being treated as an adherent and confederate of his enemy, of which no nation would be the dupe if able to resent it. The proclamation is exactly consistent with and declaratory of the conduct enjoined by the law of nations. It is worthy of remark that we are at peace with all these belligerent powers, not only negatively in having war with none of them, but also in a more positive and particular sense by treaties with 4 of them. By the first article of our treaty with France, it is stipulated that there shall be a firm, inviolable, and universal peace, and true and sincere friendship between His Most Christian Majesty, his heirs and successors, and the United States, and between the countries, islands, cities, and towns situate under the jurisdiction of His Most Christian Majesty, and of the United States, and the people and inhabitants of every degree, without exception of persons or places. By the first article of our treaty with the United Netherlands, it is stipulated that there shall be a firm, inviolable, and universal peace, and sincere friendship between their high mightinesses, the Lords and States General of the United Netherlands and the United States of America, and between the subjects and inhabitants of the said parties, and between the countries, islands, and places situate under the jurisdiction of the said United Netherlands and the United States of America, their subjects and inhabitants of every degree, without exception of persons or places. The definitive treaty of peace with Great Britain began with great solemnity in the words following: "In the name of the most holy and undivided Trinity." By the 7th article of this treaty, it is stipulated that there shall be a firm and perpetual peace between His Britannic Majesty and the United States, and between the subjects of the one and the citizens of the other. By the 1st article of our treaty with Prussia, it is stipulated that There shall be a firm, inviolable, and universal peace and sincere friendship between His Majesty, the King of Prussia, his heirs, successors, and subjects on the one part, and the United States of America and their citizens on the other, without exception of persons or places. By the laws of nations, the United States, as a neutral power, are bound to observe the line of conduct indicated by the proclamation towards all the belligerent powers, and that although we may have no treaties with them, but with respect to France, the United Netherlands, Great Britain, and Prussia, the before-mentioned articles in our treaties with them create additional obligations, to wit, all those obligations which result from express compact and from national faith, mutually, explicitly, and solemnly pledged. Surely no engagements can be more wise and virtuous than those whose direct object is to maintain peace and to preserve large portions of the human race and the complicated evils incident to war. While the people of other nations do no violence or injustice to our citizens, it would certainly be criminal and wicked in our citizens, for the sake of plunder, to do violence and injustice to any of them. The President, therefore, has with great propriety declared that the duty and interest of the United States require that they should, with sincerity and good faith, adopt and pursue a conduct friendly and impartial towards the belligerent powers. A celebrated writer on the law of nations very justly observes that, as nature has given to man the right of using force only when it becomes necessary for their defense and the preservation of their rights, the inference is manifest that since the establishment of political societies, a right so dangerous in its exercise no longer remains with private persons, except in those kind of encounters which society cannot protect or defend them. In the bosom of society, public authority decides all differences of the citizens, represses violence, and checks the impulse of revenge. It would be too dangerous to give every citizen the liberty of doing himself justice against foreigners, as every individual of a nation might involve it in a war. And how could peace be preserved between nations if it was in the power of every man to disturb it? A right of so great moment, the right of judging whether a nation has a real cause of complaint, whether its case allows of using force and having recourse to arms, whether prudence admits, and whether the welfare of the state demands it. This right, he says, can only belong to the body of the nation or to the sovereign representative. It is doubtless one of those without which there can be no salutary government. It is on these and similar principles that whoever shall render himself liable to punishment or forfeiture under the law of nations by committing, aiding, or abetting hostilities forbidden by his country ought to lose the protection of his country against such punishment or forfeiture. But this is not all. It is not sufficient that a nation should only withdraw its protection from such offenders. It ought also to prosecute and punish them. The same writer very justly remarks that the nation or sovereign ought not to suffer the citizens to do any injury to the subjects of another state, much less to offend the state itself, and that not only because no sovereign ought to permit those who are under his command to violate the precepts of the law of nature, which forbids all injuries, but also because nations ought to respect each other, to abstain from all abuse, from all injury, and in a word, from everything that may be of prejudice to others. If a sovereign, who might keep his subjects within the rules of justice and peace, suffers them to injure a foreign nation, either in its body or its members, he does no less injury to that nation than if he injured them himself. In short, the safety of the state and that of human society require this attention from every sovereign. If you let loose the reins of your subjects against foreign nations, these will behave in the same manner to you, and instead of that friendly intercourse which nature has established between all men, who should see nothing but one nation robbing another. End of section 65. Section 66 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Case of Breach of Neutrality by Citizens of the United States, Richmond, Virginia, 1793, Part 2. The respect which every nation owes to itself imposes a duty on its government to cause all its laws to be respected and obeyed, and that not only by its proper citizens, but also by those strangers who may visit and occasionally reside within its territories. There is no principle better established than that all strangers admitted into a country are, during their residence, subject to the laws of it, and if they violate the laws, they are to be punished according to the laws. The design of pains and penalties being to render the laws respected and to maintain order and safety. Hence, it follows that the subjects of belligerent powers are bound, while in this country, to respect the neutrality of it, and are punishable in common with our own citizens for violations of it, within the limits and jurisdiction of the United States. It is to be remembered that every nation is, and ought to be, perfectly and absolutely sovereign within its own dominions, to the entire exclusion of all foreign power, interference, and jurisdiction, whether attempted by a foreign prince or by his subjects, with or without his order. It is a manifest consequence of the liberty and independence of nations that all of them have a right to be governed as they think proper, and that none have the least authority to interfere in the government of another state. Of all the rights that can belong to a nation, sovereignty is doubtless the most precious, and that which others ought the most scrupulously to respect, if they would not do it in an injury. These are general principles. The laws to which they apply are numerous, and need not be particularized in detail. On the present occasion, it will be sufficient to lead your attention to one or two, which will serve to explain the reason and extent of these principles. The right of levying soldiers is a sovereign right belonging only to the nation. No foreign power can lawfully exercise it without permission, nor without previous permission can such attempts be otherwise regarded than as improper interferences with the sovereignty of the country. On this head, the law of nations is explicit. It declares that the right of levying soldiers belongs solely to the nation. This important power is the appendage of the sovereign. It makes a part of the supreme prerogative. No person is to enlist soldiers in a foreign country without the permission of the sovereign. They who undertake to enlist soldiers in a foreign country without the sovereign's permission or alienate the subjects of another violate one of the most sacred rights both of the prince and the state. It is a crime punished with great severity in every policied state. Foreign recruiters are hanged immediately, and very justly, as it is not to be presumed that their sovereign ordered them to commit the crime, and if he did, they ought not to have obeyed his order, their sovereign having no right to command what is contrary to the law of nature. Usually they who have practiced seduction only are severely punished, but if it appears that they acted by order of the sovereign, such a proceeding in a foreign sovereign is justly considered as an injury, and as a sufficient cause for declaring war against him, unless he condescends to make suitable reparation. From the observations which have been made, this conclusion appears to result, viz., that the United States are in a state of neutrality relative to all the powers at war, and that it is their duty, their interest, and their disposition to maintain it. That, therefore, they who commit, aid, or abet hostilities against these powers, or either of them, offend against the laws of the United States and ought to be punished, and consequently, that is your duty, gentlemen, to inquire into and present all such of these offenses as you shall find to have been committed within this district. What acts amount to committing or aiding or abetting hostilities must be determined by the laws and approved practice of nations and by the treaties and other laws of the United States relative to such cases. I doubt the expediency of anticipating such cases and endeavoring now to distinguish acts which do from others which do not involve the criminality in question. Singular cases may arise if, in the course of your inquiries, you should experience difficulties. The Attorney General and, if necessary, the court will assist you. Before I dismiss this subject, it cannot be improper to remark that a state of neutrality leaves us perfectly at liberty to exercise every humane, benevolent, and friendly office towards the powers at war and their subjects, and to continue our usual commerce with them, excepting only those offices and that kind of trade which may be designed and calculated to give one party a military preponderancy to the detriment of the others. While we contemplate with anxiety and regret the desolation and distress which a war so general and so inflamed will probably spread over more than one country, let us, with becoming gratitude, wisely estimate and cherish the peace, liberty, and safety with which the divine providence has been pleased so liberally to bless us. By the favor of heaven, we this day enjoy a degree of prosperity unknown to any other nation in the world. Let it be among our enjoyments to render our happiness instrumental in alleviating the misfortunes to which many have already been, and more will yet be, reduced by those national contentions. In a word, let us be faithful to all, kind to all, but let us also be just to ourselves. The people of the United States have exhibited too many proofs of virtue and intelligence to leave room to doubt their continuing to be so guided by their usual integrity and good sense. But in every nation, individuals will always be found who, impelled by avarice or ambition, or by both, will not hesitate to gratify those passions at the expense of the blood and tears, even of those who are free from blame. Such men are to be restrained only by fear of punishment. There is, however, another consideration connected with the subject which merits much attention. It is natural in all contests, even for the best men, to take sides, and wish success to one party in preference to the other. Our wishes and partialities becoming inflamed by opposition often cause indiscretions, and lead us to say and to do things that had better have been omitted. It is not certain that the irritability of the belligerent powers, combined with some indiscretions on our part, will not involve us in war with some of them. Prudence directs us to look forward to such an event, and to endeavor not only to avert, but also to be prepared for it. Among our preparations, there can be none more important than union and harmony among ourselves. It is very desirable that such an event do not find us divided into parties, and particularly into parties in favor of either foreign nation. Should this be the case, our situation would be dangerous as well as disgraceful. While blessed with union in sentiments and measures relative to national objects, we shall have little to fear, and therefore it is sincerely to be wished that our citizens will cheerfully and punctually do their duty to every other nation, but at the same time carefully avoid becoming partisans of any of them. There is not a history of any nation which does not record the mischiefs they experienced from such parties, and they rarely present us with an instance of a nation being conquered and subjugated without the detestable aid of its own degenerate or deluded citizens. Nothing is more certain than that if such parties should arise among the people, They will find their way into every department of government and carry distrust and discord with them. Dark and dreary would then be the prospect before us, and we should in vain look for the speedy return of those happy days when the government was peacefully, wisely, and prosperously administered, under the care and auspices of a patriot, in whom the United States have, by repeated unanimity in their suffrages, manifested a degree of confidence, no less reputable to their own wisdom and virtue than to his. But if neither integrity nor prudence on our part should prove sufficient to shield us from war, we may then meet it with fortitude and a firm dependence on the divine protection. Whenever it shall become impossible to preserve peace by avoiding offenses, it will be our duty to refuse to purchase it by sacrifices and humiliations, unworthy of a free and magnanimous people, either to demand or submit to. The subject presented by the proclamation appeared to me to be highly interesting, and I thought it useful to treat it with much plainness, as well as latitude. I was aware that I was treading on delicate ground, but as the path of my duty led over it, it was incumbent on me to proceed. On the third branch of the laws of the United States, viz., their Constitution and statutes, I shall be concise. Here also, one great unerring principle, viz., the will of the people will take the lead. The people of the United States being, by the grace and favor of heaven, free, sovereign, and independent, had a right to choose the form of national government which they should judge most conducive to their happiness and safety. They have done so, and have ordained and established the one which is specified in their great and general compact or constitution, a compact deliberately formed, maturely considered, and solemnly adopted and ratified by them. There is not a word in it but what is employed to express the will of the people, and what friend of this country and the liberties of it will say that the will of the people is not to be observed, respected, and obeyed. To this general compact every citizen is a party, and consequently every citizen is bound by it. To oppose the operation of this Constitution and of the government established by it would be to violate the sovereignty of the people, and would justify merit, reprehension, and punishment. The statutes of the United States, constitutionally made, derive their obligation from the same source, and must bind accordingly. Happy would it be for mankind, and greatly would it promote the cause of liberty and the equal rights of men, if the free and popular government which from time to time may result should be so constructed, so balanced, so organized and administered, as to be evidently and eminently productive of a higher and more durable degree of happiness than any of the other forms. It is not sufficient to tell men by a Bill of Rights that they are free, that they have equal rights, and that they are entitled to be protected in them. Men will not believe they are really free while they experience oppression. They do not think their title to equal rights realized until they enjoy them, nor will they esteem that a good government, whatever may be its name, which does not uniformly, impartially, and effectually protect them. The more free the people are, the more strong and efficient ought their government to be, and for this plain reason, that it is a more arduous task to make and keep up the fences of law and justice about 20 rights than about 5 or 6, and because it is more difficult to fence and restrain men who are unfettered than men who are in yokes and chains. Being a free people, we are governed only by laws and those of our own making. These rules are rules for regulating the conduct of individuals, and are established according to and in pursuance of that contract which each citizen has made with the rest and all with each. He is not a good citizen who violates his contract with society, and when society execute their laws, they do no more than the due operation and observance of which the common good and welfare of the community depend. For the object of it is to secure to every man what belongs to him as a nation, and by increasing the common stock of property, to augment the value of his share in it. Most essentially, therefore, is it the duty and interest of us all that the laws be observed and irresistibly executed. I might now proceed to call your attention to certain statutes which merit particular attention, and it would not be difficult to place them in points of view, in which their importance to the public would appear in strong lights. But having already detained you so long, and these subjects not being due to you, I will forbear enlarging on them on the present occasion. The manner in which you are to fulfill the duties now incumbent on you is specified in the oath you have taken. The experience of ages commends the institution of grand juries. It has merited and received constant encomiums, and I trust, gentlemen, that your conduct on this and similar occasions will afford new proofs of its utility and excellence. End of section 66. Section 67 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Gideon Henfield for enlisting in a French privateer. Philadelphia, 1793, Part 1. The narrative. The sympathy of one of the great political parties of the country and of the great majority of the people for France was at its height when the first trial came on at Philadelphia to test the power of the government to enforce Washington's proclamation of neutrality. 2 sailors on board a French privateer who had enlisted in an American port, Gideon Henfield and John Singletary, were indicted. They were American citizens and came clearly within the proclamation. On the day of the trial, the latter could not be found, and Henfield was put at the bar and a jury impaneled. The evidence was clear, and the judges so instructed the jury, but they were out but a few minutes when they returned with the verdict of not guilty. The result was received with cheers, for the jury had spoken the common sentiment of the city and country. A dinner was given to Citizen Henfield that evening, at which the French minister announced that the citizen had been formally taken under the protection of the French Republic. Footnote. Unfortunately, however, for Henfield, this protection was not very potent, for, elated with the honor of French citizenship, he sallied forth in a new excursion, which resulted in his capture by a British cruiser. Wharton, page 89, note. End of footnote. There was another reason than the French sympathy which brought about the acquittal. Not only did the people think the proclamation unwise, but a large number of lawyers and writers were arguing in every newspaper that it was unconstitutional as well. The Constitution, they said, gave the president no power to make war, to make peace, or to appoint ministers without the consent and approval of the Senate. If he should, of his own will, say to France, the United States will side with you in this conflict, send you troops, loan you money, and equip your ships, would not everyone in the country at once cry out that the president had no power to say such things, that he was really declaring war with England? If then he has no power to say to France, we will side with you, what right has he to say, we will not side with you, we will be neutral? He has simply no right. Such matters rest with Congress, and he ought plainly to have first consulted Congress. The trial. Footnote. Bibliography. State Trials of the United States during the administrations of Washington and Adams, with references, historical and professional and preliminary notes on the politics of the times, by Francis Wharton, author of a treatise on American criminal law, etc. Philadelphia, Carey and Hart, 120 Chestnut Street, 1849. End of footnote. In the Circuit Court of the United States District of Pennsylvania, Philadelphia, July 1793. Honorable James Wilson, Honorable James Iredell, Honorable Richard Peters, Justices. Footnote. Wilson James, 1742 to 1798, born in Scotland, a signer of the Declaration of Independence, delegate to Continental Congress, 1775 to 1787, Associate Justice, Supreme Court of the United States, 1789 to 1798. Iredell James, 1750 to 1799, born in England, Associate Justice, Supreme Court of the United States, 1790 to 1799. Peters Richard, 1744 to 1828, born Philadelphia, graduated college, now University of Pennsylvania, admitted to bar 1763, Registrar in Admiralty 1771, resigned at outbreak of Revolution, was officer in Continental Army, member Continental Board of War and Commissioner of War, 1776 to 1781, member of Congress, 1782, of State Assembly, 1787, Speaker of Assembly, 1788, Speaker of Senate, 1791, United States District Judge, District of Pennsylvania, 1792, was active in securing the British Act of Secession for the Episcopal Church in America, and went to England to secure the ordination of American bishops, was reporter of the Pennsylvania Admiralty decisions, 1780 to 1807, and the father of the reporter of the Supreme Court of the United States decisions. He was born and died on his estate Belmont, which is now a part of Fairmount Park, Philadelphia. End of footnote. July 22nd. On this day, Mr. Justice Wilson charged the grand jury for the Pennsylvania District as follows. Gentlemen of the grand jury, it is my duty to explain to you the very important occasion on which this court is specially convened, and to state the points of law not less important to the application of which that occasion gives rise. To the judge of the Pennsylvania District, information was given on oath that certain citizens of the United States had acted in several capacities as officers on board an armed schooner, said to be commissioned by France as a cruiser or private ship of war, and with others on board that schooner did capture and make prize of several ships or vessels belonging to His Britannic Majesty, and otherwise assist in a hostile manner in annoying the commerce of the subjects of His said Britannic Majesty, who is at peace with the United States, contrary to their duty as citizens of the United States. On receiving this information, the judge issued his warrant for apprehending the persons against whom complaint was made, that they might answer for their doings in the premises, and be dealt with according to law. That legal proceedings in this and some other business might be had speedily, one of the judges of the Supreme Court of the United States and the judge of the Pennsylvania District issued their warrant, directing that on this day and at this place a special session of the Circuit Court for this district should be held, and that grand and traverse jurors should be summoned to attend it. As the court, however, is authorized generally to try criminal causes, if any other crimes or offenses cognizable in it be laid before you or are in your knowledge, it is your duty to present them. But to the business to which you have been particularly called, and to articles intimately connected with it, I shall confine the remarks which I have to give you in charge. I introduce them by noticing with pleasure the near and endearing relation between the freedom and the dignity of man, and governments unfavorable to both. Treaties and the construction of treaties are numbered among the arcana imperii, the secrets of empire, enclosed within the cabinets of princes and secluded from the judgment of the citizens, whose lives and fortunes, however, they chiefly affect. Under our national constitution, Treaties compose a portion of the public and supreme law of the land, and for their construction and enforcement are brought openly before the tribunals of our country. Of those tribunals, juries form an essential part. Under the construction given by those juries, treaties will suffer neither in their importance nor in their sanctity. Sapientissima res tempus, says the profound Bacon in one of his aphorisms concerning the augmentation of the sciences. Time is the wisest of things. If the qualities of the parent may be expected in the offspring, the common law, one of the noblest births of my time, may be pronounced the wisest of laws. This expression, says the great lawyer, Finch on law, is not new and strange or barbarous and peculiar to England. It is the proper term for other laws also. Euripides mentions the common laws of Greece, and Plato defines common law to be that which, being taken up by the common consent of a country, is called law. In another place, the same illustrious philosopher names it the golden and sacred rule of reason which we call common law. To the common law of England, however, the phrase is often peculiarly appropriated. Of this common law, the antiquity is unquestionably very high, but the precise era of its commencement and the several springs from which it originally flowed, it is very difficult, if not altogether impracticable, to trace. One reason for this may be drawn from the very nature of a system of common law, as it is accommodated to the situation and circumstances of the people, and as that situation and those circumstances insensibly change, a proportionate variation of laws insensibly takes place, and it becomes impossible to ascertain the period when this change began, or to mark the different steps of its progress. It might be amusing and instructive, but at this time it would be improper to sketch the general outlines of the system through the government of the Saxons down to the conquest of the Normans. Suffice it to observe, and the observation is important, that the common law as now received in America bears in its principles and in many of its more minute particulars a stronger and a fairer resemblance to the common law, as it was improved under the former, than to that law as it was disfigured under the latter. The accommodating principle of a system of common law will adjust its improvement to every grade and species of improvement, in consequence of practice, commerce, observation, study, or refinement. As the science of legislation is the most noble, so it is the most slow and difficult of sciences. Willing to avail itself of experience, it receives additional improvement from every new situation to which it arrives, and in this manner attains, in the progress of time, higher and higher degrees of perfection, resulting from the accumulated wisdom of ages. On some occasions, the spirit of a system of common law is accommodating, but on others its temper is decided and firm. The means are varied according to times and circumstances, but its great ends are kept steadily and constantly in view. How effectually has the spirit of liberty animated this system in all the vicissitudes, revolutions, and dangers to which it has been exposed. In matters of a civil nature, the common law works itself pure by rules drawn from the fountain of justice. In matters of a political nature, it works itself pure by rules drawn from the fountain of freedom. It was this spirit which dictated the frequent and formidable demands on the Norman princes for the complete restoration of the Saxon jurisprudence. It was this spirit which, in Magna Carta, manifested a strict regard to the rights of the commons as well as those of the peers. It was this spirit which extracted sweetness from all the bitter contentions between the rival houses of York and Lancaster. It was this spirit which preserved England from the haughtiness of the Tudors and from the tyranny of the Stuarts. It was this spirit which rescued the states of America from the oppressive claims and from all the mighty efforts made to enforce the oppressive claims of a British Parliament. The common law, says my Lord Coke, Calvin's case, 6 Rep 88, is a social system of jurisprudence. She receives other laws and systems into a friendly correspondence and associates to herself those who can give her information or advice or assistance. Does a contract bear a peculiar reference to the local laws of any particular foreign country? By the local laws of that foreign country, the common law will direct the contract to be interpreted and adjusted. Does a mercantile question occur? She determines it by the law of merchants. Does a question arise before her, which probably ought to be resolved by the law of nations? By that law she will decide the question, but that law in its full extent is adopted by her. The infractions of that law form a part of her code of criminal jurisprudence. In our present business, gentlemen, this great subject deserves a full and appointed illustration, such it is in my power, on a short notice to give. I now proceed to lay before you. The law of nature was applied to the states of political societies, receives a new name, that of the law of nations. But though it receives a new appellation, it retains unimpaired its qualities and its powers. The law of nations, as well as the law of nature, is of obligation indispensable. The law of nations, as well as the law of nature, is of origin divine. There are, it is true, laws of nations. Perhaps it is to be wished that they were designated by another name. There are laws of nations, which are founded altogether on human consent. Of this kind are national treaties, but the municipal laws of a state are not more distinct from the law of nature than those consensual laws of nations are in their source and power distinct from the law of nations properly so called. Indeed, those consensual laws of nations are not less controlled by the law of nations properly so called than municipal laws are controlled by the law of nature. The law of nations is the law of states and sovereigns. On states and sovereigns it is obligatory in the same manner, and for the same reasons, as the law of nature is obligatory upon individuals. Universal and unchangeable is the obligation of both. How great, how important, how interesting are these truths! They announce to a free people how solemn their duties are. If a practical knowledge and a just sense of those duties were diffused universally among the citizens, how beneficial and lasting would the fruits be? It seems to have been thought that the law of nations respects and regulates their conduct only in their intercourse with each other. A very important branch of this law, containing the duties which a nation owes to itself, has in a great measure escaped attention. Of a state, as well as of an individual, self-preservation is a primary duty. To love and to deserve an honest fame is another duty of a state as well as of a man. To a state as well to a man, reputation is a valuable and an agreeable possession. It represses hostility and secures esteem. In transactions with other nations, the dignity of a state should never be permitted to suffer the smallest diminution. Need it be mentioned here that happiness is the center to which states as well as men are universally attracted. To consult its own happiness, therefore, is the duty of a nation. When men have formed themselves into a political society, they may reciprocally enter into particular engagements and contract new obligations in favor of the community or of its members. But they cannot, by this union, discharge themselves from any duties which they previously owed to those who form a part of the political association. Under all the obligations due to the universal society of the human race, the citizens of a state still continue. To this universal society, it is a duty that each nation should contribute to the welfare, the perfection, and the happiness of the others. If so, the first degree of this duty is to do no injury. Among states as well as among men, justice is a sacred law. This sacred law prohibits one state from exciting disturbances in another, from depriving it of its natural advantages, from culminating its reputation, from seducing its citizens, from debauching the attachment of its allies, from fomenting or encouraging the hatred of its enemies. But nations are not only prohibited from doing evil, they are also commanded to do good to one another. On states as well as individuals, the duties of humanity are strictly incumbent. What each is obliged to perform for others, from others it is entitled to receive. Hence the advantage as well as the duty of humanity. It may be uncommon, but it is unquestionably just to say that nations ought to love one another. From the pure source of benevolence, the offices of humanity ought to flow. By a nation, these enlarged and elevated virtues should be cultivated with peculiar assiduity and ardor. Of an individual, however generous his disposition may be, the sphere of exertion is frequently narrow, but of a nation, this sphere is comparatively boundless. By exhibiting a glorious example in her constitution, in her laws, and in the administration of her constitution and laws, she may diffuse instruction, she may diffuse reformation, she may diffuse happiness over the whole terrestrial globe. These maxims of national law, though the sacred precepts of nature and of nature's God, have been too often unknown and unacknowledged by nations, even where they have been known and acknowledged, their calm still voices have been drowned by the clamor of ambition and by the thunder of war. It is then unnecessary or improper here to say, peace should be deemed the basis of the happiness of nations, peace on earth. This is a patriotic as well as an angelic wish, but with war and rumors of war, our ears in this imperfect state of things are still assailed. Into this unnatural state ought a nation to suffer herself to be drawn without her own act, or the act of him or them, to whom for this purpose she has delegated her power. Into this unnatural state should a nation suffer herself to be drawn by the unauthorized, nay, by the unlicensed conduct of any of her citizens. These, gentlemen, are questions to which you are now called to give the closest and deepest attention. That a citizen who, in our state of neutrality and without the authority of the nation, takes an hostile part with either of the belligerent powers, violates thereby his duty and the laws of his country, is a position so plain as to require no proof, and to be scarcely susceptible of a denial. Under the Treaty of Amity and Commerce between the United States and France, it may be made a question whether the privateers of that power have a right to fit out their ships in our ports. This question arises from the 22nd article of that treaty. It shall not be lawful for any foreign privateers, not belonging to the subjects of this most Christian majesty, no citizens of the United States, who have commissions from any other prince or state in enmity with either nation, to fit out their ships in the ports of either the one or the other of the aforesaid parties. It may be alleged that this prohibition against fitting the ships of privateers belonging to any other nation implies a permission to fit the ships of privateers belonging to France. But this inference cannot justly be drawn. If, by a promise made to one person, I restrain myself from lending money to any others, I am not surely by that restraining engagement obliged to lend my money to him. It may be convenient, it may be necessary for me to reserve its application exclusively for my own purposes. In the same manner, by a stipulation that in a war between France and Britain we will not lend the use of our ports to the privateers of the latter, we are by no means obliged to lend it to those of the former. It may be convenient, it may be necessary for us to refuse it to both. True it is that by the treaty we are obliged to refuse it to Britain, and this to one of the parties was probably an important object. but it remains in our option whether we will or will not grant it to France. Both the nations which made this treaty might have the most unexceptional, nay, the most commendable motives for reserving to themselves this option. France, particularly, might have the strongest reasons for refusing to bind herself, at all events, to permit even the United States to fit out in her ports privateers against any nation, however united to her by compact, with which the United States might be at war. This option, perhaps with France a favorite one, each of the parties to the treaty reserved the power of making. This option our nation or its representatives for that purpose have not yet made. This option private citizens are certainly unauthorized and unwarranted to make. Private citizens, therefore, assisting in a business of this kind offend the law, and for their offenses are amenable to the justice of the nation. If you know of any such, it is your duty to present them here. In some instances, citizens may be accountable for the conduct of their nation. In other instances, the nation may be accountable for the conduct of its citizens. It is impossible, indeed, that even in the best regulated state, the government should be able to superintend the whole behavior of all the citizens, and to restrain them within the precise limits of duty and obedience. It would be unjust, therefore, immediately to impute to the nation the faults or offenses which its members may commit. In every state, disorderly citizens are unhappily to be found. Let such be held responsible when they can be rendered amenable for the consequences of their crimes and disorders. If the offended nation have the criminal in its power, it may without difficulty punish him, and oblige him to make satisfaction. When the offending citizen escapes into his own country, his nation should oblige him to repair the damage, if reparation can be made, or should punish him according to the measures of his offense. If the nation refuse to do either, it renders itself in some measure an accomplice in the guilt, and becomes responsible for the injury. To what does this responsibility lead? To reprisal, certainly, and if so, probably to war. And should the fortunes or the lives of millions be placed in either of those predicaments by the conduct of one citizen or of a few citizens? Humanity and reason say no. The Constitution of the United States says no. By this Constitution, many great powers are vested in the first executive magistrate. Others are vested in him, by and with the advice and consent of the Senate. But neither he, nor he and they in conjunction, can lift up the sword of the United States. Congress alone have power to declare war, and to grant letters of marque and reprisal. Who indeed should have the power to declare war but these, as the immediate representatives of those must furnish the blood and treasure upon which war depends. With regard to this very interesting power, the Constitution of the United States renews the principles known and practiced in England before the conquest. This indeed may be reckoned one of the chief differences between the government of the Saxons and that of the Normans. In the former, the power of peace and war was invariably possessed by the Witten Aganmote, and was regarded as inseparable from the allodial condition of its members. In the latter, it was transferred to the king, and this branch of the feudal system, which was accommodated, perhaps, to the depredations and internal commotions prevalent in that rude period, has remained in subsequent ages, when from a total change of manners, the circumstances by which it was recommended have no longer any existence. There is, by the way, a pleasure in reflecting on such important renovations of the venerable Saxon government, and in discovering that our national constitution is rendered illustrious by the antiquity, as well as by the excellence of some of its leading principles. The principle now under our view was urged as one reason why this Constitution should be adopted by Pennsylvania. If urged with propriety then, it may be urged with propriety now. But what was then adopted ought now to be supported. This system will not hurry us into war. It is calculated to guard against it. It will not be in the power of a single man or a single body of men to involve us in such distress. But the important power of declaring war is vested in the legislature at large. This declaration must be made with the concurrence of the House of Representatives. From this circumstance, we may draw a certain conclusion that nothing but our national interest will draw us into a war. I cannot forbear on this occasion the pleasure of mentioning to you the sentiments of the great and benevolent man, whose works I have already quoted, Mr. Neckar, who has addressed this country in language important and applicable, in the strictest manner, to its situation and to the present subject, speaking of war and the great caution that all nations ought to use in order to avoid its calamities. And you, rising nation, says he, from generous efforts have freed from the yoke of Europe. Let the universe be struck with still greater reverence at the sight of the privileges you have acquired, by seeing you continually employed for the public felicity. Do not offer it as a sacrifice at the unsettled shrine of political ideas and of the deceitful combinations of warlike ambition. Avoid, or at least delay, participating in the passions of our hemisphere. Make your own advantage of the knowledge which experience alone has given to our old age, and preserve for a long term the simplicity of childhood. In short, honor human nature by showing that when left to its own feelings, it is still capable of those virtues that maintain public order, and of that prudence which ensures public tranquility. On this great subject of peace and war, the voice of all France is responsive to the language of our national constitution. When the interesting question was before her National Assembly, its deliberations, we are told, were watched with anxiety by countless thousands. All Paris was in agitation, and when the decree was pronounced that the lives and fortunes of 25 millions of men should not be at the disposal of a single individual, there was a shout of acclamation raised, which reached from the garden of the Tuileries to the extremest province of France. Can we believe for a moment that this generous nation would wish to bereave us of our security, which they themselves so highly and so justly prize? End of section 67. Section 68 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Gideon Henfield for enlisting in a French privateer. Philadelphia, 1793, Part 2. July 27th. The grand jury returned an indictment against Gideon Henfield. The first count declared that a war was going on by land and sea between the Republic of France on the one hand and the kings of Prussia, Sardinia, Hungary, Great Britain, and the States General of the Netherlands on the other. That there was a treaty of amity and commerce between the United States and the Netherlands, and that by the Constitution of the United States, it is provided that all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. It charges that by letters of marque, a ship called the Citizen Gannett was commissioned by the Republic of France to take and destroy ships of the Netherlands and to wage wars against them on the high seas. That Henfield, being an inhabitant of the United States, while knowing this and intending to break the treaty of amity aforesaid, became a master on board the said ship, and unlawfully sailed to several places to take the ships, goods, and moneys of the Netherlands, against the treaty aforesaid, and against the Constitution of the United States, its peace and dignity. There were other counts, as to Prussia, Hungary, Sardinia, and Great Britain. The prisoner pleaded not guilty. William Rawle, United States District Attorney, and Edmund Randolph, Attorney General for the United States. Footnote. Rawl William, 1759 to 1836, born Philadelphia, studied law in New York and afterwards crossed the Atlantic and entered as a student at the Middle Temple. He became a leader of the Philadelphia bar, and for more than 20 years his professional business was very great and his income very large. He was one of the revisers of the Pennsylvania laws and the author of Views of the Constitution of the United States and The Study of the Law. Says Dr. Wharton, Trials, page 31N. His mind was eminently clear and discriminating, and his arguments and speeches simple, strong, earnest, and impressive. Of his kind and courteous deportment during a career of prosperity, all who were thrown in contact with him could bear witness, and those who saw the evening of his life darkened, as it had been, by vicissitudes, cares, and severe physical pain, still lit up by his calm, patient, and most instructive endurance, can well imagine that the same spirit and the same Christian humility had tempered his more prosperous days. The only administrative public office which Mr. Rawl ever held was that of Attorney of the United States for the District of Pennsylvania, which he received from the hands of General Washington, by whom he was much respected and esteemed. In this capacity, he accompanied the President in the expedition which, in 1794, proceeded to the western part of the state for the purpose of quelling the insurrection, which there broke out, and Mr. Rawl and General Hamilton, occupying the same tent, formed part of Washington's family. Afterwards followed the unpleasing duty of prosecuting the offenders, and in the performance of the painful task, Mr. Rawl's firmness was still mild and forbearing. Randolph Edmund, born Virginia, delegate to Continental Congress, 1779 to 1783, member of Convention which framed the United States Constitution, 1788, Governor of Virginia, 1788, Attorney General of the United States, 1789 to 1793, Secretary of State, 1794, died 1813. End of footnote. Pierre E. Duponceau, Jared Ingersoll, and Jonathan D. Sargent for The Prisoner. Footnote. Duponceau, Pierre Etienne, 1760 to 1844, born France, came to America as aide to Baron Steuben, settled in Philadelphia and became eminent as a lawyer, president of the American Philosophical Society, author of Memoir on the Indian Languages of North America. Ingersoll Jared, 1750 to 1822, born New Haven, Connecticut, son of an Admiralty judge of Philadelphia, studied law at the Inns of Court in London, his Whig principles and American birth rendering dangerous a longer stay in London. He left there after the Declaration of Independence and spent some time in France, and then returned to Philadelphia to the practice of the law. Was one of the representatives from Pennsylvania in the Continental Congress and in the convention which formed the Constitution of the United States, where, though a lawyer and a fluent one, he made no speech. Attorney General of Pennsylvania, 1791 to 1800, 1811 to 1816. For a short time District Attorney of the United States for Pennsylvania, but resigned, finding the duties of the office to interfere with his practice. Offered but declined Federal Circuit Judgeship for New Jersey, Pennsylvania, and Delaware, organized in 1801. For the 18 months preceding his death, was president of the District Court of Philadelphia, federal candidate for Vice President of the United States, 1812. Sergeant Jonathan Dickinson, 1746 to 1793, born Newark, New Jersey, member Continental Congress, 1776 to 1777, Attorney General of Pennsylvania, 1777, died October 1793 in Philadelphia. End of footnote. The evidence. Hilary Baker, Louis Deploy, John Morgan, and James Bassett testified for the government, From the evidence, it appeared that Gideon Henfield was a citizen of the United States, residing in Salem, Massachusetts. Being a seafaring man, he had been absent for some time, and about May 1st, 1793, being then at Charleston, South Carolina, and desirous of coming to Philadelphia, he applied to the master of a packet, who asked him more for his passage than he could afford to pay, whereupon he entered on board the Citizen Gannett, a French privateer, commissioned by the French Republic and commanded by Pierre Johannin. Captain Johannin promised him the berth of prize master on board the first prize they should capture, and the ship William, belonging to British subjects, having been captured about the 5th May, he was put on board her as a prize master with another person, and arrived in that capacity at Philadelphia. On his examination before the magistrate, he protested himself an American, that as such he would die, and therefore could not be supposed likely to intend anything to her prejudice. He declared if he had known it to be contrary to the President's proclamation, or even the wishes of the President, for whom he had the greatest respect, he would not have entered on board. About a month afterwards, being before the same magistrate, he declared he had espoused the cause of France, that he now considered himself as a Frenchman, and meant to move his family within their dominions. Mr. Rawle and Mr. Randolph to the jury. Every member is accountable to society for those actions which may affect the interest of that society. The United States being in perfect peace with all nations, and allied in friendly bonds with some, their national situation requires a perfect neutrality from every motive applicable to our common interest. An aggression on the subjects of other nations done in a hostile manner and under color of war is a violation of that neutrality. If not under the color of war, it would be an act of piracy. But by the laws of nations, if one of the belligerent powers should capture a neutral subject fighting under a commission from the other belligerent powers, he could not punish him as a pirate, but must treat him as an enemy, and it would be a good cause of declaring war against the nation to which he belonged. And if treated as an enemy without just cause, it is the duty of the nation to which he belongs to interfere in his behalf, and thus arises another cause of war. Hence the act of the individual is an injury to the nation, and the right of punishment follows the existence of the injury. The right of peace and war is always vested in the government. It is with us in the United States, but Congress alone possesses it. By the formation of the society, every individual has consented to its being thus exclusively deposited for the general benefit. No individual, therefore, can assume the exercise of this right, for if one could do it, 1,000 might, and while the government declared peace, the tragedy of war would be acted in its defiance. If one individual has a right to associate with the subjects of one of the belligerent powers, another individual has an equal right to do the same with the other belligerent power. Thus the citizens of the neutral nation might be fighting with each other. Under this unhappy prospect, the national character and existence of America are lost, and instead of being members of a great nation, we become a band of miserable Algerines. The facts here show that Henfield is a citizen and inhabitant, though afterwards he takes counsel and alters his note, that he entered on board the privateer Citizen Gannett at Charleston, that she was a commissioned vessel, that he aided and assisted in taking the prize, and came in on board her as prize master. The sufferings and character of Henfield can have no operation here. It is a point for the court and no justification. France is at war with Austria, Spain, Portugal, and Sardinia, with whom we are at peace, with Great Britain, with whom a treaty of peace exists, and with the United Netherlands and Prussia, with whom there is peace, amity, and commerce. To the first two we are related as having neither given nor received offense, but the want of a treaty with them will not justify the individual in his aggression on them. With Great Britain is a treaty of peace by Article 7 of which it is provided that there shall be a firm and perpetual peace between His Britannic Majesty and the United States, and the subjects of the one and the citizens of the other. With the United Netherlands and Prussia, treaties are not only of peace, but of mutual friendship and liberal commerce. The commission under which the proceedings of defendant took place is generally against all these powers, though actual aggression is charged as to one only. That one is one with whom we have a treaty of peace, which is the supreme law of the land, and this is the positive prohibitory law. Thus, an infraction of this kind, unless punished, becomes a good cause of war on the part of the offended nation. It is an offense against our own country, at common law, because the right of war is vested in the government only. In a state of nature, the right adhered to the individual. It is lost by joining society. The common welfare requires this position in its fullest extent. Otherwise, a few individuals, for avaricious purposes, might involve the nation in a war. Otherwise, the members of the nation, taking opposite sides, might destroy the nation in detail. Otherwise, the primary duty due from the citizen to the nation would remain unperformed, while his labors and his life were devoted to the service of foreigners. Nor are these only the speculations of the closet. We see them carried into effect in England, an affirmation of national common law, i.e., the law of nations. The English statute is not in force here, because the specific remedy for which alone it was made cannot be had. But the law which it aided, not introduced, is in force. The law of nations is part of the law of the land. This is an offense against the laws of nations. It is punishable by indictment on information as such. It is agreed that the laws of nations point out different methods of proceedings. 1. By the belligerent power treating the offenders as pirates. 2. By negotiation or the declaration of war. But the answer is that these are concurrent remedies. True that some writers say they may be treated as pirates, and certain that they may be treated as enemies. But these do not preclude the national right of proceeding against the delinquents judicially. So a man may defend himself against violence, but the assailant may be indicted. A man may peaceably retake his own property, but he may also have a plebeian. A man may enter, etc., but he may have his ejectment. The same observations apply to negotiation. We may negotiate as well on national as on private concerns, but without prejudice to the judicial remedy. But it is the honor of free states that the judicial remedy is necessary, that the executive should be inadequate to sudden and unusual exertions of power is our pride and happiness, and that our courts should, with that impartial and unbiased dignity which characterizes their judicial investigations of truth, apply the law of nations to men, of which nations are composed, and substitute the scales of justice for the sword of war. But it is said that there is a want of precedent for this prosecution. The first answer is that it is demonstrated that the law of nations is part of the law of the land. The second answer is that in numerous other instances, enumerated by Blackstone, the law of nations is enforced by the judiciary. In cases of this nature, we find provisions have been made by statute in affirmance of the law, providing more speedy and specific relief than the common course of the law will admit. Thus the 31 Henry VI C4 was passed, and then 3 James I C4, which makes it felony to go out of the realm to serve a foreign prince without oath of allegiance. That an indictment will lie on the latter is unquestionable. On the former, see 3 Bulst 28, a case in point. It is urged also that the right of emigration is natural to free men. It is no crime to become a French subject, and being a French subject, the defendant may lawfully enlist in this command. The answer is that when a man has feelingly and deliberately emigrated, when he has renounced his own country, and has been received and domiciliated by the other, when all this has been done previously to the commission of the hostile act, and without a view to it. There is no offense in an act of this kind, but the power of emigrating and the power of renouncing the original country are widely different. To emigrate is declared to be, in most instances, lawful for a private citizen. In some it is dishonorable, as to leave a country under difficulties, as in a dangerous war, etc. But at all events, if at the time the act was committed the party was unquestionably a citizen, had not renounced his country, and was not domiciliated elsewhere, he cannot escape punishment by becoming a citizen afterwards, still less when it is expressly stated and proved he was then an inhabitant. Is not the defendant's family still at Massachusetts? Is he not still upon the roll of their citizens? Were his family in want, would they not be entitled to public relief? Did he not declare that, as an American, he would die? It is said, it is true, that without actual expatriation, a freeman in a free country may, consistently with the law of nations, enter as a volunteer. 2 Lee 251. The answer is to be found in Vattel 1.3, paragraph 13. In addition to what is already cited, 2. The principles of Lee are as questionable as those of Vattel are solid. It is prostrating the right of civil society to support the right of man in a state of nature. The latter is destructive to civil society, which is instituted to prevent the pernicious effects of those rights. Grotius, whom he quotes, does not say so. Grotius treats simply of the right of emigrating, and there is not a syllable of the matter treated on by Lee in the whole section of Grotius. Grotius 1.2, c. 5, paragraph 24. But in the same section, Grotius very justly says that one ought not to go out of the state when the interest of the state requires otherwise. And surely the interest of the state is affected by going out for these purposes. Lee himself accepts those states in which it was not allowable by the custom, as he terms it. That this is the case in England is in proof, and it has not been altered here. The Bill of Rights declares emigration shall not be prohibited. It is contended, however, that the act done, having been done on board the vessel, it is their French country, and the act there is lawful. The answer is that in no respect is a foreign vessel a foreign country. Suppose the defendant had on board that vessel committed a private offense. The indictment lays it as having been done by a citizen, an inhabitant. There is really no technical difficulty. The evidence comes fully up to the case. The defendant was in Charleston. He there entered the vessel, and to argue that the instrument by which the offense is committed shall protect him from punishment is an absurdity. By this, the old doctrine of deodads is reversed. There the instrument partook of the offense. Here the offender is to be incorporated into the innocence of the instrument. End of section 68.